mention this matter. This is appearing in item number 11 in the regular list of your lordships. And your lordship will be taking commercial list first. Your lordship, this is an order passed by this court on 13th of June extending the interim order in this particular matter, which expired yesterday, your lordship. I'm just praying for the extension of interim for maintaining status quo.
I'm for the defendant in this matter.
We hadn't given the notice, your lordship. That's why we did not
The
apply.
partition suit earlier also they came after the expiry. Your lordship has refused to extend the interim order, directing them that you should file an application. They should have come earlier. If the interim order was expiring, instead,
your lordship,
they should have come earlier. They should have filed an application to that. Let them file an application and come with it.
So that's why I put the note. Kindly see the note.
I know, my lord. I know, my lord. I was
So you all are facing it difficulty. Though you put the note. All extensions should be mentioned at 4:30.
Yes, your lordship has
So
mentioned.
we'll come at
Because
4:15.
every day I am finding the lawyers are facing.
Lord, I'll come at 4:15.
No, it is in the list. Come at
It is-
4:15.
yes.
4:15. I mean.
Very
So yes, come at 4:15.
yes, your lordship.
But may I have your lordship's leave to mention item 140 of your lordship's commercial list? This
I appear for the plaintiff.
on notice, I apologize, I had given the mentioning notice very, very late yesterday.
Lord, I
But-
appear for that.
Yes, some order needs some clarification from your lordship. May it be listed as to be mentioned. I'll indicate to your lordship what clarification is required.
What order?
There are some orders have been passed where it has been observed. The defendant number one, I am representing the defendant number one. The defendant number one had initiated certain 138 proceedings against the plaintiff for dishonor of check. It was an observation from this court as well as from the division bench that there is no embargo on proceeding with the 138 proceedings. But I am told that a defense has been set up in the 138 proceedings by the plaintiff that there is an order from this court where an embargo has been put on the proceedings under the 138 proceedings. So that is why that clarification is required, so that if your lordship makes it clear that the 138 proceedings can proceed according to the statute and there is no embargo. That is all,
Okay, come. Monday has to be mentioned.
Monday has to be mentioned. I'm grateful.
Lord, may I have my lord's kind leave, my lord, to mention two commercial, my lord, two ordinary suits, my lord.
Commercial
yes.
to ordinary suit.
I'm sorry, my lord.
Commercial to ordinary suit.
My lord, it is a non-commercial suit, my lord, but my lord, it has been wrongly filed in the non-commercial division. It's a commercial suit in the nature. So, my lord, may kindly keeps it under to be mentioned.
Filed in the commercial division.
Filed in the non-commercial division. It
Non-commercial.
should have been filed in the commercial division, my lord.
New matter.
My lord, new suit of
You have to
2024.
withdraw.
Your lordship may kindly keeps it under to be mentioned.
Both
the suits, my lord.
Monday.
Extremely grateful.
Lordship, may I have Lordship's kind leave to mention? Lordship, this is an erstwhile commercial matter which has been converted into a non-commercial matter. Lordship had been pleased to pass an order on 10th of June. We had applied for certified copy. However, Lordship, we were a bit late in applying. That is why, Lordship, I'm seeking Lordship's leave to apply for draw up and completion and also for certified copy of the order.
Draw and completion of what?
Of the order dated 10th of June, Lordship.
Okay. Allow that.
Obliged, Lordship.
Ma'am, let's kind leave to mention, Millard, a suit, Millard. The 14 days time for Millard lodging the writ of summons has expired, Millard. There is one order, Millard, passed by your lordship, Millard, where Millard certain discrepancies were Millard recorded. Millard, those have been corrected. It was corrected on 15th of July. That process is complete. But we are out of time, Millard. The 14 days time has expired. I was only Millard praying for extension of time, Millard, for lodging the writ of summons.
Then you have to make an application.
It's very formal, Millard, and the order 6.
Also, master summon is required. Otherwise, it can't be.
But,
If the
but
court is
Millard, I have-
granted, also next it will be.
But I was only Millard praying, Millard. The original side rules, Millard, I've gone through, Millard, does not provide for any application. It only provides that.
Rules never provide for application. Rules provide for
Very
leave from the court.
very-
Come with the application.
Great.
For the defendant.
Lordship, I am for the plaintiff.
Yes.
So this was kept, I believe, for a report from the department. There was some discrepancy with regard to the filing of the Vakalat by the defendant because of the wrong cause title mentioned. Thereafter, it was corrected, and I am being told by the advocate record the defect has been cured.
Lordship, I strongly object to that. There was no correction made to the cause title of the plaint.
That is what the department informed us.
Sole defendant.
Yes, Your Lordship. The discrepancy was that the suit was originally filed with this cause title, ordinary original civil jurisdiction. So that is what we followed while filing the Vakalatnama. Thereafter, we came to know that this has been deleted.
No, so you
Thereafter
filed the
only
Vakalatnam on 28th June, but then it was lying defective
Correct.
and necessary correction was carried out on 9th of July.
Yes.
When the same was registered, recorded, registered lecture. Due to the first certified certificate issued to them. So you obtained the report on 3rd July. You obtained report
No,
on
they
3rd
have, I believe, they have.
We have
I
obtained.
for the
on
defendant.
3rd
Yes.
July.
30 days.
Yes, 3rd July. 3rd July, the Vakalatnama was defective. Yes, now what can be done?
My lord, may I? As of within time, they have not filed proper appropriate Vakalatnama. Right, wrong, whose mistake was it was, or I'm not going into that.
Okay,
But they have not. So I am just praying that they should come through proper application, my lord.
Or what? What
For
is the
filing.
prayer?
I have no prayer.
They have not
suit has come at
instructed
their
yet,
instance.
my lord.
The suit
They-
has come at their instance.
Yes, obviously, my lord.
When
So,
the notice was served, when the writ of
my lord, after within 30 days, they have not filed corrected Vakalatnama as per their
when the
submission only.
notice was served, madam.
My lord, 1 second. Notice was served on 3rd of June.
3rd June. And they filed on 28th June, but it was defective. and it
Defected.
was
They have not
corrected on
corrected,
9th
my
of
lord.
July. 9th of July.
From
So-
what date they are saying this?
So let the
Yes, it's cured now.
the written statement period is there.
Yes, yes.
Only because of not filed the Vakalatnam will not take ground for making an undefendant suit.
Technical
My lord,
office.
I was just praying that if the proper, if your lordship permits, my lord, but I think they should come through proper application, my lord,
For what?
for filing Vakalatnama beyond
Madam,
time.
filing Vakalatnam is not, it is the department, not the court. Department see, the court is to see whether the defendant has filed the written statement or not. And now they file the Vakalatnama. How the court can restrain them not to file the
I believe he
Vakalatnama?
No,
wants
my
you
lord,
to
I am not
earn,
saying
earn a
not on
fees
that, my
by
lord.
making an application. But it's not required.
So what you want now?
If your lordship permits, then through proper application, otherwise whatever your lordship.
Already accepted by the department.
Yes, my lord.
The matter is listed as to be mentioned. Full stop. In terms of the order passed by this court, the Deputy Registrar Legal has submitted the report dated 18 July 2024, wherein it has been clarified that the learned advocate Ms. Devajini Sen Gupta had filed her Vakalatnama on behalf of the defendant on 28th June 2024, but the same was defective and it was lying in the department. Subsequently, the learned advocate has rectified the defects in the Vakalatnama on 9th July 2024, and accordingly the same was taken on. As the Vakalatnama filed on 28th June 2024 on behalf of the defendant was defective, therefore there was no Vakalatnama on record, and on the basis of the same and accordingly on the request made by the counsel for the plaintiff, the department, the Deputy Registrar Legal had issued notice, issued certificate to the learned counsel for the plaintiff that none have entered appearance on behalf of the defendant, either in person or through advocate. Now the Deputy Registrar Legal through the report has clarified the position. Accordingly, this court finds that no further order is required. Yes. Any further order required?
Sorry for the indulgence, my lord.
Great.
Number 2.
That I appear for the plaintiff, this is an application. GA4 is a joint application The parties have settled their disputes.
Hmm.
And a terms of settlement has also been drawn up. But if your lordship takes one of the application, the terms of settlement is also annexed.
This is an application for
For my lord,
order,
recording the
compromise.
yes, recording of the compromise, and a decree may be passed.
Where is the order? Where is the settlement?
Page
My lord,
27,
Page 27, my lord, is the
settlement agreement.
yes. Kindly sees my lord, the recital C at page 29. These are the legal proceedings when initiated between the parties. And one at page 31, clause 4 is the payment to be made by the defendants in the respective suits to the plaintiff. Already made. This is just left. That's 30. Okay.
Next election. 5.1. If you can show him 5.1, also is important. Compromise decree.
First payment made.
Yes,
Yes,
till serial number 3, if your lordship.
Serial number 3, payment is made.
Yes, till serial number 3, it is made, and serial number 4, this is subject to the
7
directions.
days from the release of fund of Registrar General.
Yes.
The amount is spent like
Yes, the amount was on an application filed by the plaintiff. The defendant was directed to deposit,
First,
and that has been
what are the
deposited.
amount?
40
40
lakh.
lakhs.
40 lakh.
This amount is lying here.
Yeah.
Lying with the registrar.
And it is in the fixed deposit.
In an
Interest,
interest-bearing
no.
account, but
Interest-bearing.
possibly interest-bearing account.
Where is the original? Settlement deed, you are not include the original. Because this will be made as a part of the decree.
Yes, this will be made as a part of the decree. We'll produce the original.
But to produce the original along with this.
I shall. আচ্ছা কি এখন আছে? তোমাদের কাছে original আছে? But we'll find out if the original is there, but we'll kindly pass it over. But we'll find out if it is there. If not, we'll inform your lordship. Lordship will take it up on Monday. We'll bring it.
Pass over.
Grateful.
Item number 3.
Two, three, same.
My lord, item number 2 and 3.
2 and 3, pass over.
Yes, my lord.
Item number 4.
May I have my lord's kind leave to present a plea? My lord, the suit is for my lord unpaid price of goods sold and delivered.
Hmm.
My lord, we are praying for leave under clause 12 of the latest patent. My lord, we have gone before the mediation. There is a failure and there is a non-starter report, which we have annexed, my lord. So, my lord, the pre-institution mediation we have already availed. My lord, the plaintiff number 1, as your lordship would see from the cost title, is a company which has been formed under the laws of the Kingdom of Saudi Arabia.
Saudi Arabia?
Yes. My lord, yesterday was Switzerland, day before was Italy, today it's Saudi Arabia.
So every day I am roaming around the world.
Yes, that is
here.
Yesterday Switzerland, day before Italy.
You all persons are taking me all over world. Yes. Then
now, my lord, plaintiff number 2 is a company which is the agent of the plaintiff number 1, and we have annexed all the agreements which we have with the plaintiff number 1, where we have been given the authority to my lord, negotiate with and market and my lord, deliver and do all things for the plaintiff number 1 in India for a specific including recovery of money. So that agreement is still subsisting. That is, my lord, annex
Plaintiff one and 2 are connected.
1 and 2 are connected. My lord, 1, 2 is the agent in India,
Agent
appointed by the plaintiff number 1. And my lord, the agency agreement we have annexed, and all the subsequent extensions we have annexed. Now the defendant is a company which has purchased, my lord, goods from the plaintiffs. My lord, the goods is, my lord, linear alkyl benzene.
What is the suit for?
Suit is for recovery of money, my lord, for price of goods sold and delivered. So, my lord, partly paid, partly not paid. My lord, checks issued in the name of the plaintiff number 2. Your lordship will kindly have a look at, my lord, page 203 in the second volume of the plaint, my lord. This is a letter which has been issued 203 in the second volume. Now, there is an email issued by the defendant, my lord, to the advocate, my lord, to the plaintiff number 2. And here there is a mention at the bottom of page 203 of 2 checks. Your lordship will see 2 undated checks, my lord, handed over. The check numbers and the amounts have been given.
Yeah.
Now, if your lordship kindly turns over to page 205, my lord will see for these checks which were, my lord, given. And your lordship will see that AR Stankem Private Limited is the, my lord, drawee, or is the, my lord, pay. And, my lord, here this is the plaintiff number 2. So the plaintiff number 2 also, my lord, acts as the agent to recover monies for and on behalf of the plaintiff number 1. And, my lord, there has been meetings held within the jurisdiction, and I have also, my lord.
So what has happened to these checks?
My lord, these have been dishonored. At 218, my lord will kindly have a look at page 218. This is the first check. Your lordship will see account closed. At the top, my lord, there is an endorsement, account closed at 218. Same thing at 219.
So how the 205 is undated and 218 is undated? You have put that here.
Right. And that is the specific pleading, my lord. Your lordship will kindly have a look at, my lord, paragraph 30. But initially, my lord, at paragraph, my lord, 26, we have mention of these undated checks being handed over at page 10. Page 26, my lord, at page 10, we have mentioned that these checks were given which were undated.
2022.
Yes. So these were undated checks handed over that we have mentioned in this paragraph. Kindly turns over to paragraph 28. At the next page, my lord, page 11. My lord, we had called upon the defendant to send its personnel for the purpose of chalking out a plan and to put the date in the check so that this can be honored. My lord, that was again reiterated at paragraph 30, when by 7th of June we had requested that to fill up the checks. Then paragraph 31, we have mentioned that Mr. Venkatraman of the defendant visited the office on this date, and this was done. And, my lord, thereafter, upon depositing the check, this was. And also, my lord, your lordship will kindly turn over, my lord, to page, my lord, 15, where even thereafter, at paragraph 42, there was a physical meeting at the office of the plaintiff number 2 within the jurisdiction, at paragraph 42.
Yeah.
On 13th of May also. But this is after, my lord, we had initiated proceedings, mediation proceedings.
Where is the medium?
Yes, the failure report, your lordship will see at, my lord, the second volume. My lord, page 233, it's a non-starter report at page 233, the last annexure to the plaintiff.
Yeah. Only clause 12.
Only clause 12. And the physical meeting which I was referring to, that is at page 228. My lord, that they have signed everywhere, and the minutes of the meeting has recorded, it's within the jurisdiction. At the office of the plaintiff now.
Clause 12.
I'm so good. Extremely.
Item number 5.
My lord, I beg to appear on behalf of the, my lord, defendant number 7.
I appear on behalf of defendant numbers 3 to 5, my lord.
My lord, I appear for the plaintiff petitioner, my lord. My lord, I have an innocuous prayer to make. The plaintiff is extremely sick. He has not been able to come to court to affirm the affidavits. The date has expired yesterday, my lord. My lord, he has been advised, investigations are going on. detection has not yet taken place as to what is wrong with him, but he has been advised to be confined in isolation, my lord. So I was praying 15 days time, my lord.
Reply.
My lord, replies are ready. Only affirmation has not
My
could
lord,
not
my
be done.
instructions are it is not so, but in any event, my lord, as
My
subject
lord,
to
I
my lord,
have
it may
the medical reports. I have no reason to
no interim.
make.
My lord, say, my lord. My opposition, my lord, I have served on.
Yes, I know.
My lord, in the month of May. In the month of May, I
The
have
sick,
Yes.
ground of sickness.
My lord, I have brought all the medical documents since. My lord, I have another prayer, my lord. Since the scrutiny took a lot of time, my lord, the fresh summons have to be lodged. My lord, without going into that, pursuant to your lordship's direction passed on 26th April, all the parties have been served with a copy of the plaint and the application, my lord. My lord, I was praying the service of writ of summons may be waived.
My lord, I have no instructions with
Until the parties will not say.
My lord, it is admitted in their affidavit in opposition. First paragraph.
Let it be let come on record.
My lord, in that event, my lord, the fresh writ of summons have to be lodged. And since the plaintiff is not in a position to come to court for affirmation, my lord, I was praying your lordship can extend the time to issue lodge fresh summons.
My lord will kindly not do that, my lord. My learned
I am
friend,
extending the time for reply. If any in future, if you are finding any difficulty, come we'll suit to that. You are having a good ground for that.
But it is they admittedly in their opposition they have said that they have received a copy of the
Having
plaint.
good ground on that.
Yes.
So and so appearing for the plaintiff. So and so Mrs. Suparna Mukherjee, learned advocate appearing for the plaintiff. Mr. Gopal Pahari, learned advocate appearing for the defendant number 1, 2, and 9, Mr. Sen
my lord, Miss Kajaria.
appearing for the defendant number 3 to 5, Devajit Mukherjee, advocate appearing for the 6 and 11, Udainaran Bethel, an advocate appearing for the defendant number 7, Mr. Arindam Paul, an advocate appearing for the defendant number 8, and Mr. Rahul Karmakar, an advocate appearing for the defendant number 10. Police counsel for the plaintiff submit that the plaintiff is suffering from serious ailment and is under investigation and prays for extension of 2 weeks time to file affidavit in reply to all the affidavit oppositions filed by the defendant. Considering the submission made by the counsel for the plaintiff, time to file affidavit in reply to all the affidavit in oppositions filed by the defendants is extended for a period of 2 weeks. This is the matter on 9th of August 2020.
If possible, my lord, can record, my lord, that I have served my lord opposition on my lord in the month.
It is part of the record. I have not denied that.
Yeah. Next.
I'm deeply obliged.
Your Lordship, in item number 6, I am beg to appear on behalf of the defendant.
My application, my lord.
Yeah.
Lordship was pleased to pass an ad interim order on 24th of June, 2024 on my application restraining the defendants. Lordship, the ordering portion.
Achha, that cafe.
Yes, that cafe and that.
Yes.
Your Lordship, I am praying for at least 2 weeks time to file my opposition, Your Lordship. They have suppressed many facts which is pertinent to the instant dispute.
Being on record.
Only
I am extending the interim order.
Only thing that is the race. Only thing, my lord, we thereafter visited the property. Now, this lordship has granted them an injunction not to utilize the conference room at the page 37. Now, I have pictures we showing that they are still utilizing.
You take steps.
They're still utilizing. Now, I have a prayer for a receiver. If the receiver can mean
Your Lordship, let a time be granted to me.
possession of the property, none of us will use it.
My business is running, Your Lordship, from therein.
No, I'm not stopping.
My business is running from therein. If the receiver is appointed or what my senior friend is praying.
Stop the business. Only the conference room
They
did not use.
forcefully they visited the premises, Your Lordship, on the pretext of the order passed by Your Lordship. Now, Your Lordship, what I am praying before Your Lordship, grant me 2 weeks time. Let the interim order be extended. Grant me 2 weeks time. I'll file the facts before the Your Lordship, which needs to be incorporated.
But you have to comply with the order.
I'll comply, Your Lordship. I'm denying their allegation. I'm denying their. In that even if
None
he is
of us
praying
will
for
do-
symbolic position, I'm praying for a short pass over your lordship. My senior will appear.
Only
If
the
he is pressing for his application, I'm praying for a short pass over your lordship.
So appearing for the plaintiff, so
affidavit of service.
defendant. Full stop. Counsel for the defendant pressed for 2 weeks time to file affidavit.
At no point of time we have violated the order.
Affidavit in opposition. Let affidavit in opposition be filed within 2 weeks. Reply.
1 week there.
Reply if any there to be filed within a week thereafter. Please the matter on
Now the my lord's last order that we will not use the conference room, my lord. That has to be
13th August 2024. Full stop. Under the counsel for the plaintiff submitted in spite of the order passed by this court, in spite of the interim order passed by this court, comma, the defendant is using the conference room, but the allegation made by the plaintiff is denied by the learned counsel for the defendant, comma, the full, comma, considering the submission made by the counsel for the respective parties, the matter will be decided at the time of hearing of the injunction application. Next.
I'm grateful, your lordship.
we have to take steps, my lord, otherwise. I know. Affidavit of service is kept with the record.
Affidavit of service filed by the plaintiff be kept with the record.
Obliged.
Yes.
We are appearing on behalf of the
application,
defendant.
my lord, for that order 38 rule 5 in which your lordship was pleased to grant an order, my lord, funds used for purchase of flats and all these. My lord, your lordship has granted an ad interim order of injunction restraining them from using the bank account without keeping aside the sum of the claim.
Yes.
My lord, I am appearing for the on behalf of the defendant. Kindly see the order dated 14th of June 2024.
14 June.
14th of June, which has been subsequently corrected on, my lord, June 24, 2024.
Correct. There was some.
In the original order, my lord, there was a direction that the plaintiff is directed to serve a copy of the application along with the document. Although the writ of summons has been served, my lord, it does not contain the application.
No,
on the basis
that
of
is
which
writ of summons different. You are not taken step for service of notice of the application.
I just satisfy your lordship, my lord, what has happened.
Yes.
I knew that this point would come up.
Yes.
Only the thing is this
This
my
is
lord,
only
since-
submission. The notice has not been served to you.
Yes, it has.
No. The application has not
That's
been.
why the
Ad interim injunction, my lord, which has been sought for under
been
order
served.
38 rule 5, my lord, that has not been served. Unless that has not been served, we will not be in a position to file the opposition also.
Okay. Yes.
My lord, the affidavit of service, I have put it on record. Your lordship would kindly see what was served on them.
You are appearing for sole defendant.
All the defendant, my lord. Company and the, my lord,
Your lordship sees the letter which was of 25th of June 2024.
my lord, the writing.
Please find attached a copy of the notice of motion, copy of the plaint, and the copy of the application along with all annexures and server copies of orders dated such. But it was served. If he is in a position he has not received it, I don't know. I'll serve him another copy if not.
My lord, it would be very difficult to justify. A bunch of documents would be there and 5 or 10 documents would not be there, which prompted me to say before this court saying that an application has not been submitted.
Whether your client has received this.
No, my lord.
Because it is there.
Only the plaint has been received. Plaint has been received and the
Plaint by
application.
through survey through speed post.
Yes, my lord.
Speed post.
Speed post.
Speed post, you have not received the notice.
The application also, no.
No, because your client has received on
Yes, 27th
of June.
Yes.
Right, and delivered
Only
signet media.
my lord, yes. An envelope has
Your
been
lordship
received
would
by my client, and which contain, my lord, the plaint does not contain the, my lord, the application.
My lord, your lordship would kindly see the weight at
That's
page
it,
5.
That's what I'm telling. The weight is 50 and
1240 grams.
So then, my lord, I have to bring the entire thing and I have to wait and then I have to submit, my lord.
Well, if you
Okay,
want
leave
to take
aside,
directions
all
for
this.
affidavit,
You saw the.
I'll give him.
Saw the copy.
Yes. Yes.
And kindly give me leave so that I can file the opposition.
The making the submission from the bar, I recognize my practice time. What has happened in High Court? My client has received the cover. When the cover was open, inside the cover only 3 blank papers.
No, that is evident from the weight. That's why I wanted to show the weight.
So that's why now
Yes.
once you told me, then
Correct.
immediately I checked the weight and the
Yes.
amount.
Well, in fact, I got a judgment yesterday which said specifically this, where the order was vacated on the ground that it did not contain the application and the plaint. And thereafter, I found that the Order 39 Rule 3 has been watered down a lot over the time.
That is so.
The basically is whether prejudice is caused to the defendant or not if service is not.
So and so appearing for the plaintiff, so and so appearing for the defendant. Plaintiff has filed the affidavit in service of affidavit service. Let us be complete the record. Police counsel for the plaintiff submitted. The plaintiff has only received the copy of the plaint, but has counsel for the defendant submitted the defendant has received only the copy of the plaint, but has not received the copy of the application and the annexes thereto. Concerning the submission made by the counsel for the respective parties, the learned counsel for the plaintiff is directed to serve the copy of the application and the documents to the learned advocate appearing for the defendant in course of the day. In course of the day, counsel for the plaintiff plays for extension of interim order dated 14th June 2024, which was subsequently corrected by order dated 24th of June 2024. Considering the submission, the interim order granted earlier. So you will file affidavit?
My lord.
It is then. Counsel for the defendant prays for time to file affidavit in opposition. Let affidavit in opposition file 2 weeks.
2 weeks.
2 weeks, reply 1 week. Should reply within 1 week. This is the matter on 12th of August 2024. The interim order is extended till 13th August 2024 or until further order, whichever is earlier.
Great. Grateful, madam.
Item number 8, your lordship, I am for the respondent.
Yes.
Lord, I am injured. I moved it, Lord. I got an order. Lord, I have a registered Mark Miller to fund. Lordship was please copy the order that the DH also. Lordship will kindly take Miller. I have a registered Mark Tufan. My invoices, Lordship will find at page 32.
Ready hearing?
No, here
On the only pointed out, your lordship, how this, your lordship, matter has been moved, your lordship, and the order, your lordship, has been obtained. Lordship, what happened, your lordship, kindly sees once. Your lordship kindly takes your lordship's order on 24th of June 2024. Now, what happened? This order was passed, your lordship, on that basis, your lordship kindly sees page number 2, last 4 lines, or rather 3 lines.
Yes.
It starts from in the year 2018. In the year 2018, the plaintiffs have also filed a civil suit being CS 101 of 2018 against the defendants for perpetual injunction along with an interlocutory application being GF 1597 of 2018 on the basis of a quaternion action. Now, at that point of time, your lordship, there was an order of injunction passed, which was subsequently vacated. And finally, your lordship, the injunction application was actually dismissed. Thereafter, what they have done, they tried, your lordship, and filed a contempt application on the basis of same cause of action. Lordship kindly sees the contempt application, para 20. Nothing, your lordship, has been disclosed. Para 20 onwards, it's the same mark. Contempt application is pending.
Correct.
They tried to get that particular order in a contempt. Contempt application is pending, which has not been disclosed before your lordship. And thereafter, they obtained a decree, which they have annexed in their application. I filed an application for setting aside, which is pending. Nothing has been disclosed. And thereafter, your lordship, once your lordship, they have said that this is a cause of action and there is a contempt which is pending, and saying, your lordship, that there is a violation of that particular order, during the pendency of everything, they have come before this honorable court, obtained a leave under section 12A and obtained an ex parte ad interim order of injunction. Isn't it the duty, your lordship, of the plaintiff to at least disclose? Okay. And your lordship kindly sees, your lordship, the order passed, your lordship, in that particular suit.
Well, the contempt was in the suit which culminated into a decree. I went to the court saying there is a contempt. Well, an friend appeared. My lord, lordships, the contempt, honorable contempt court was, we will not get the suit heard.
I have got the suit heard, I have got the decree. Correct. Milord, I have got the decree A, B, C of the plaintiff. Tufan or any deceptively similar. Milord, I have, Milord, annexed the decree. That is, Milord, between the parties. There is no stay on the decree. Now, Milord, he has an opposition, which has been, Milord, dismissed.
Then you have to go for an execution.
I don't have to go because it's a new
Yes.
mark he has come.
If it is, no, certainly, Lordship kindly sees contempt application para 20 onwards. Is it the same mark or it's a new mark? Lordship kindly sees, your Lordship, the interim order which was passed, your Lordship, by the earlier court and which has been already, your Lordship, this has not been disclosed in the plaint and the petition. First order passed, your Lordship, by Justice Sen, that was an ex parte. Thereafter, your Lordship, the order was vacated. Lordship kindly sees the next order.
That has been confirmed by Justice Sen, Milord. I had showed the order.
No, that is a different matter.
This matter.
No, sir. No, sir. Let me. Lordship kindly sees CS 101.
You bring all the things on record.
Lordship kindly take up this matter on Monday, your Lordship, because
soon you will file.
Because my all goods are stuck. Tuesday korbe.
Tuesday koro na.
Tuesday koro tarikh.
Tuesday mein aajke thakbo market.
23rd, your Lordship kindly take up. 24th, I am not saying.
Bring on.
Yes, yes, all records I'll bring.
Yes, yes. No difficulty, Milord. I thought, Milord, my learned friend will at least cross-examine my witness, Milord, in an ex parte suit.
So suffering.
I have filed, Milord, and the content is in this suit which culminated into a decree. Yes.
Have you filed the affidavit service?
Yes, yes, he's there, Milord.
I'm here, Lordship.
I thought.
Plaintiff has filed the affidavit service. Let the same be kept with the record. Full stop. Counsel for the plaintiff prays for extension of the interim order. The counsel for the defendant submits that the plaintiff has obtained the interim order by suppressing the several material facts, several orders passed by this court, as well as in the content proceedings, and he intend to bring all the documents on record. In view of the submission made by the counsel for the defendant, full stop. Let the affidavit defendant, defendant director to file affidavit in opposition by enclosing all the document within.
Lordship, may I come and show your Lordship before filing an affidavit?
Once I'll file in 2 days. I'll file in 2 days. Reply, I'll file in 2 days.
Come on record by way of affidavit.
Yes, I'll file in 3 days. Lordship gives me, fix it next Monday to Monday.
By Monday, your Lordship, I'll file it.
By Monday?
Give me 2 days, Milord, for a reply, or 3 days, whatever.
What is the date? By Monday, 22nd. 22nd, reply if any there to be filed by 25th of July 2024. Release the matter on 26th of July 2024 under the same heading. Full stop. In the meantime, full stop, the interim order granted earlier is extended till 29th of July 2024 or 29th July or until further order, whichever is. Come on, 29th.
Lordship, come.
Great. Yes, next.
So may I take back your Lordship the document?
Judge Sahib, Judge Sahib রেগে যাবে। I told my clerk now my lord will be extremely annoyed seeing me again. Milord, it's again 12 o'clock, Milord, again, Milord.
Yes.
Milord, junior, Milord, Saj Food. I am Saj Food, that is Bisque Farm. Lordship has heard of Bisque Farm biscuits. Defendant is also a leading manufacturer. Milord, I am registered proprietor of the ward, Milord. Kindly, Milord, takes page 30, capital A of your petition.
30?
No, 3A, 30 capital A, because Lordship will remember I had corrected some, Milord, documents missed out. So, Milord,
yes.
Petition I have withdrawn and file afresh. Bisque Farm, the top, so it is a duty to point out since it's an ex parte matter, Milord. Registration of the mark shall give no exclusive right over the mark the top.
Yes.
Lordship will now take, Milord, the next page. I have an application for Milord Top Gold claiming user from 24th of September 2008. And Milord, this has been accepted and advertised. Milord, that means, Milord, the trademark registry has accepted it. There is a window of 4 months within which someone may come and oppose. It's still now not opposed.
So 30A is the Bisque Farm.
It's the Bisque Farm, the top.
The top, that's right. This
Registration shall no exclusive use of the. So, my lord, if I
D-top.
have to use D top, I have to use it
Along
with
with-
this part.
with this part,
That
yes.
lordship has now, after silk, my lord, lordship has, my lord, gone, my lord.
You all persons made me the interlocutor. Yes.
Yes. Now, my lord, the next page 30, the next page 30, capital B, my lord, it's top gold. It's a word, 29th of, my lord, September 2008. Now, my lord, it's, my lord, advertised and accepted. It is published in the journal on 13th of May 2024. There's a 4-month window. So, my lord, till now, that's not objected or opposed, my lord, not objected by the registry or opposed. Now, lordship will kindly take, my lord, the next one, next page. It's, my lord, Bisque Farm Top Hub device. This is, my lord, used from 1st of, my lord, February 2012. It's a registered mark, my lord. There's a condition.
The device.
Yes, there's a condition. This is, my lord, of utmost good faith, my lord. One has to registration of this mark shall give no right to the exclusive use of all the descriptive matter appearing on the label. That, my lord, lordship will take the label on the next page, 30 capital D. Top herbs. My lord, there are, my lord, several, my lord. Like, my lord, I cannot individually claim, my lord, over the word herb. I can use it in conjunction with the label, no dispute.
The top.
Yes, I must. Itai to oppose. Now, my lord, it's my the next page, 30 capital E. There's a mark called D top. This mark is opposed. Only the top. I am not on the top at all. Or objected.
This is
That is-
objection.
That is, well, at the examination stage.
Hmm.
Now, lordship will, the next page, ওই কাগজগুলো দাও এবার। Lord সাহেবকে দিতে হবে তো। Well, at the next page, lordship, page 30F, lordship will find a mark is there, which is Bis Farm D top, device with the scene of the village. This has been opposed by Parley. Lordship, how lordship finds? Lordship will find, Miller, in the opposition and rectification details. Please give me the copy.
So this is Bisque Farm, the top device of village sign.
Yes, that's the next page. Lordship will find, Miller. Lordship has seen it. আরে,
Yes.
আর মার্কটা দাও, পার্লের মার্কটা কপি, একটা কপি দাও। নেই কিছু নেই। Millard, Parley has opposed this mark. Millard, I have found out. Millard, this Millard Parley has opposed on the basis of.
No, page 30F is the Bisque Farm top device village scene small biscuit.
Yes, it is
And
opposed
no,
by Parley.
What is the 30G? That is the mark. 30G.
30G. G Millard is the mark in question. It's a label marks the copy of the label, Millard. Copy আছে? Now, Millard, this has been opposed by Parley. এটা দেখাও না। এটা কোথায়? কি দেখাচ্ছ বিশ্বরূপ? What are you showing? Why are you giving this? এটাই তো। এটা তো। This is opposed by এটা 30. Lordship will kindly turn back to page 30 capital A.
Capital A.
কেন এটা opposed কোথায়? Registered তো। Absolutely. Millard, kindly now take Millard, the Millard, just Millard, 30H. 30 Millard H. এটা কেন? এটা GH food. You have lost everything. You've lost everything. Kindly have a look, Millard.
Yes.
The
30.
mark in question is 30J. Lordship will come to Millard, 30 capital J. Lordship will find in the bottom, Parley Products has Millard, the defendant has opposed this mark on the basis of their mark, which Lordship will find from their opposition. That's noted, which is
No, 30A.
30A.
30A is the Bisque Farm top, is Bisque Farm the top.
It's my registered.
It was registered
Yes.
with because no exclusive right.
Yes, absolutely.
Correct. Now 30J.
30J. Yes.
30J, that is the Bisque Farm the same.
Yes. It's a different label, Millard.
Acha,
It's a different label, Millard. Millard, in the biscuit trade, Lordship will find Millard 30K, Millard is the Millard line.
Okay.
It's a different label, sometimes blue, lighter blue, more deeper blue. So, Millard, now Lordship will kindly take 30
Color, okay.
30J, Lordship is seen. They had opposed by parley on the basis of a mark which is proposed to be used. Lordship will find, my lord, my opposition of parley, I'll just hand up, and the basis on which they oppose my mark, on a mark which is proposed to be used. I have to only show, I just hand up. Lordship will kindly take parley's mark is proposed to be used, and this is
Parley also the Britannia.
parley.
No,
Britannia, I am not concerned. Britannia is not a party here. Parley, my lord, what parley has done, I have to show, my lord, in the ex parte stage. My lord, on basis of the mark of a parley, which is, my lord, not registered and is proposed to be used. And this is the opposition. Yes, Lordship can take it from me. Yes, relied on this particular of that parley. Parley market copy does not. At a copy পাবো না?
Parley top.
Yes, that is proposed to be used. Now, Lordship will ask me, what are my, my lord? Do I have any? Now, my lord, this is a mark, top, my lord, which is, my lord, very, my lord, well known in the market. So, my lord, I try to distinguish myself. I do, my lord, something called top gold, which is, my lord, page 33 of your Lordship's petition. No point, my lord, going to the I have a top, so I distinguish. Ultimately, 10 years down the line, my lord, there is an attempt of, because I show, my lord, I have to, he's proposed to be used, but he's opposing me. Now, my lord, kindly take, my lord, page 33, my mark top gold label with a user detail of 1/4/2005 is registered in respect of biscuits, goods and services. The sixth one is the biscuits. Or, my lord, the sixth letter is the biscuit. This has not been, I have got it registered. It was opposed, my lord, by one GD phones. I have got it registered. The label is at next page, page 34. 34. Label, my lord, this is the label registration.
Yes.
In addition to that, my lord, there is one more mark at page 35, which has been opposed by not parley, page 35. It's also Bisque Farm top gold label by one GD Foods. GD Foods is not a party here. Whatever parley has done, I have given. So far as my word mark in relation to top gold is at page 37, which is accepted and advertised. There is a four months window. The window has, no one has opposed till now.
37.
37. With a user of 24/9/2008. I also have a copyright at page 38. 38, there are two copyrights, 38 and page 40. With a user claim of 2015 is at page 38. That's Miller, the 9th column. And Miller 2009, page 40, the 9th column is 2011. These are different label as Lordships asked me. As Lordship asked me, why different registration? These are different labels because labels change from time to time. Now, my lord, Lordship knows, my lord, for the purpose of, Lordship will now take my label at page 42 and 43 are my present label in question. Lordship now takes page 44. Page 44, one can do a search, my lord. If some mark is similar to my mark, immediately it comes. Lordship will find there is no one in the market, 7 except, my lord, the petitioner, selling in biscuits under the mark top gold. That's page 44. Top gold, Akshay Chatandan, all kinds of tea, that is removed. Item number 1.
Top gold, Akshay Tandon.
Removed. It's removed.
Removed, yes.
Top gold label, Saj Food, that's me, which I just now showed you, Lordship.
Registered.
Registered. Top gold device, Nipun Dhawan, that is in respect of rice, tea, wheat, etc., etc. Abundant. Then top gold tea, Ram Ahutar, Millard objected. And Millard top gold, the last one, again Saj Foods, advertised and accepted, which I just now showed you, Lordship. So Millard, there is no one else except, my lord,
Ramauta.
the plaintiff herein.
Who is the plaintiff?
Saj Foods, my
Saj.
lord. Saj Food Private Limited. This is a Bisque farm, my lord, which it's a parent company, Saj Food. That is the, my lord, parent company of Bisque farm. Now, my lord, kindly have a look at page 45, because Lordship's judgment now holding the field. I have to disclose invoices, even at the ad interim stage. Page 45, kindly look at the date, 24/9/2008. On the top, Lordship finds a date.
Yes.
Miller, the last item, which the parlay opposed, that biscuit, Miller, that trademark. The top gold, that is 2008. 2008, Miller, I am doing top gold. Lordship will find, Miller, page 46. I am only on top gold. Top, Miller, kindly do not pass an order. 24/3/2009. Because I have to show I am prior. He is proposed to be used as on 2010, even in top. Top gold he hasn't filed. I am, Miller, prior user so far as top gold is concerned, or top is concerned, Miller. Top is much old, 2001, Miller. That's not necessary here. 24/9/2008. Next page, Lordship will find 24/3/2009. Now, Lordship will kindly take, Miller,
Yes.
the new variant, only top gold, nothing will other than top gold. That's page 50. 28/12/2010, top gold, 74 grams.
It's only top gold.
Only top gold. Well, only. I am only now on top gold. I am not on top. He can do, Millard, top, whatever Millard he wants, but kindly do not do top gold. Don't combine it. It's my mark. It's a registered mark. So invoices are there at galore. Millard, kindly look at my sales figures in relation to top gold at page 122. See, there's a CS certificate. This is the amount of sales, Millard, in 2023-2024. It's, Millard, 1106.51 crores.
Where is?
2023
Page?
Page 122. If your Lordship takes, Millard, 2022 to 2023-2024 is 204 crores only in top gold. And the year before that, 2022-2023 is 189.43 crores.
Manufactured and sold.
Yes, only Millard in respect of top gold. I am, Millard, restricting my claim to top gold. Top, Millard, he has a user. I am not on top. I am only on top gold. He can't do top gold or any variety like that. Now, what he is doing, Millard, kindly have a look, Millard. 133. 133. He is doing top gold, and star, Millard, is written, Millard, in such a small font. Let him do top star. Let him do gold star.
Yes.
Kindly take 133. Kindly top gold. And this star, Millard, it's almost invisible.
133.
133 of your Lordship brief. Top gold star. This is absolutely, you add only one word. Even the star is in the, you do gold star, you do top star. I am not aggrieved. You are doing top gold star.
They are having the registration.
No. Gold star, they don't have anything. And Millard, top, Millard, even top, I am the prior user. I have shown. He has opposed on the basis of a mark that I am the prior mark. That's proposed to be used.
So, they have
They are doing top gold star. Kind of look how they're doing. Top gold. Actually, it's top gold. The star is small. Kindly look. Could anyone write it, Millard? Top gold, it's top gold. I have shown no one else is in market in the name of top gold. Now you add this, it's, Millard, worse, because, Millard, addition of a word here and there, Millard, will not, Millard, escape a liability. If he's a registered mark, Millard, he has a different thing, Millard. Now, Millard, top gold star. In respect of gold star, if your Lordship again comes back to the page, top gold, page 44, Millard, there is no one else other than me on top gold. Page 44. How the star is written? Let him do Millard Gold Star. Let him do Millard Top Star. Let him do Top. I have no injunction. Kindly do not do Top Gold.
2008
Yes, 2008.
got registered and 24
Lordship is seeing which page, Lordship?
37
37.
not registered. Okay.
No, no, no. This is Millard advertise and accepted. It's not
Advertisement
registered.
listed, yes.
This is not registered. My registered mark, I am Millard mainly on passing off, is Millard 33. I am holding the field. Look, there's a label. People call the Millard biscuit by Top Gold. This is Millard, I am doing it. Registration I have got of a particular label. I am writing Top Gold label with a claim of user of 1/4/2005. At the ad interim stage, I have shown the invoices from 2008. I have not been able to show from 2005. Even in Top, he is proposed to be. And Top Gold, he hasn't applied yet. It's a pure passing of action. Can you, Millard, escape liability by doing Millard, adding a word Millard star in a small fashion? This is my cause of action.
Yes.
Like Top Gold, she's adding star. What difference does it make? I am Top Gold biscuits from Millard. At least if you take the registration certificate, 19 years have gone by. And if you take my invoices, 16 years have gone by.
Yes.
It's same cheese cracker biscuits. So Millard, Millard, they can do Millard whatever. Let them not use Top Gold Millard. Let them do Millard Top Star, Gold Star, Millard, whatever they want to do Millard. Top Gold in conjunction is a coined word, which you can't infringe with.
But you are registered on Top Gold level.
I have a registration on Top Gold level. It's a pure passing of action, Millard. I can claim a right on a word. Lordship knows this Sifi's case, Millard. If I, Millard, do it for a considerable period of time, kindly have a look at paragraph 31 and 35. That's Millard the case. Sifi, তুই বার করুন একবার. Kindly have a look at paragraph 31 and 35. Pure Millard passing up. It's a pure passing up. It's Millard bit of mark. It's unfortunately my mark, Millard. Kindly have a look at 31, 35, and Sifi and Sifi.net. 31 and 35 Lordship considers for the time. Acquire করতে পারি right on the basis of a mark. এটা কেন এরকম পাঠাও? Also, Millard kindly takes Millard. It's a test Millard, para 13 Millard. If your Lordship takes para 13 with that. May I just place para 13? The next question is, would the principle of trademark law, in particular those related to passing off, apply in an action for passing off, as the phrase passing off itself suggests, is to restrain the defendant from passing off his goods to the public as that of the plaintiff, is an action not only to preserve the reputation of the plaintiff, but to safeguard the public. The defendant must have sold his goods or offered in a manner which is likely to cause deceive into the public and making the public's of the goods and services of the plaintiff. The action is normally available to the owner of a distinctive mark, and the person is who, if the word or name is invented one, who invents this and uses this. If the true trademark claims to have individually invented the mark, then the rival trader who is able to establish prior use will succeed. The question is, what has been aptly put, who gets first? It is not essential for the plaintiff to prove long use for reputation of a mark in passing out. It depends on the sales and volume of action. So, Millard, I can even Millard without registration. Millard, registration, Millard, registration is nothing. It's a it's Millard recognition of one's pre-existing right under the common.
Yes.
So, Millard, it's mainly a passing of suit, Millard, because I have a label registration. You can't do, you distinguish yourself, your product. Why do Top Gold Star? You could have done Top Star. And it is Sifi and Sifi.net, Millard. There are, Millard, enormous without Millard, anything Millard. Renaissance अच्छा देखेছে. And I'm sorry, Millard, it's gone from my iPad. It's Millard, marked Millard. I Millard highlight and read in my. They should have that's plain copy. I'm very. So in situation Millard, kindly Millard, I am asking for an order in terms of prayer. Kindly clarify this order will not prevent him to selling biscuits under the mark top or any other mark without using the mark top. Kindly Millard clarifies that because I am not asking for an order against top because he is using for a con law. On top Millard, I am not asking an order. I am only on this top gold star what he has done. That's all. There are others Millard. Even the Ramdev's case, Lordship will find Millard. Even the rest paragraph 52. Kindly have a look at paragraph 52. Paragraph 52, Lordship. Along with that, Lordship takes paragraph 52 if your Lordship takes once.
So Parley is also having the top.
Yes, it is opposed. He is not ready and proposed to be used. Top, I am not asking for an injunction. Kindly do not permit him to Millard top. Do not do top gold star. Top, he is free to do Millard. He can write top. He can do whatever he feels like. This is opposed Millard. Proposed to be used, opposed.
Where?
I have given Lordship Millard.
Acha.
Given your Lordship Millard.
Yes.
This is nowadays, Millard, we have the advantage of going to internet and find out. Otherwise, Millard, it would have been Millard. Difficult, Millard, 7 days. Kindly look, Millard, Parley top. I have no difficulty, Millard, if he uses Parley top. Nor I can, Millard, today after, I cannot ask to stop him, Millard.
Yeah.
Proposed to be, though he is proposed to be used, I am from 2000. The essential feature is top gold star. If your Lordship has a look at Millard, Ramdev, I just Millard.
Any further?
No, nothing further.
The petitioner
Great.
has filed the present application for grant of
grateful
ad interim injunction. First, the petitioner is well known and reputed manufacturer of biscuits, snacks and bakery products. Marketing and selling such products under the well-known brand Brisk, BRISK, Brisk Farm. The petitioner commenced its business in 2000. One of the premium marks of the petitioner is top gold, which has been continuously and extensively used since 2005. The petitioner conceived and adopted the mark top gold by taking the words top, top and gold and making a unique combination of the same as top gold. Full stop. All the products of the petitioner are manufactured, sold, advertised, marketed and distributed under the house mark Brisk Farm. The petitioner also manufactures, markets, trades, distributes and advertises diverse type of the biscuits and allied products under the specific marks inter alia this type, paragraph 5, page 3. Settle. The petitioner has adopted the mark top and top gold sometimes in the month of April 2005 in class 30 in respect of its butter and cheese biscuits and has been regularly, extensively and continuously using the same since 1st April 2005. The defendant only sold one defendant.
There's only one defendant. Only one.
Parley.
Only one.
The defendant has now sought to launch its product under the mark top gold star,
Page 133.
which would invariably lead to confusion and deception, and as such, the part of the petition's mark top gold, which is a coined mark of the petitioner. Full stop. The petitioner has obtained statutory protection of its mark top gold by obtaining registration on 8th of August 2011. Full stop. The petitioner has also obtained the copyright.
Also, my lord, obtained copyright, my lord.
Has
Those
also
are two
obtained-
copyright certificates are there.
Has also obtained the copyright certificate on 14/11/2017,
Page 38 and 40.
which is in which it has been categorically mentioned that it has been used in India 2015 by the petitioner. Full stop. The petitioner is continuously and extensively selling its butter and cheese biscuits under the mark Top Gold since 2005. And as per the sale figure for the year 2022-24 is rupees 2024 is rupees 20491 lakhs. 1 lakhs. Full stop. In order to popularize all its biscuit under the Top Gold, the petitioner has extensively advertised its biscuit sold under the mark Top Gold in print media and television, as well as on the social media, for which the petitioner has made expenditure as on 23/24 to the tune of rupees 1140.19 lakhs rupees. Full stop. The learned counsel for Mr. Devnath Kaur, learned advocate appearing for the petitioner, submits that the respondent deliberate use and adopted the Top Gold star mark and its corresponding packaging from a traders and get the impugned mark
Top Gold star.
Top Gold.
A star is written in an insignificantly small manner.
Get up, trade desk and get up of the mark Top Gold. Mark Top Gold. Full stop. The mark of the petitioner
Comparison to answer.
is as follows. This you page 7 can
Para 13 and Millard, para page 11, both marks in the petition.
and full stop. The mark of the respondent is as follows. Page 11. Is can go. Full stop. The petition full stop. The petitioner is the prior user of the mark Top Gold, and having been regularly and continuously and extensively using the mark since the month of April 2005. Full stop. The respondent is using the mark top gold and oblique or top gold star and the accompanying packaging subsequent to the petitioner. Full stop. The respondent is using the top gold and top gold star marks which are identical to the petitioner's mark top gold, wherein the term invert comma top and फिर inverted comma gold are written in larger font and the term star is written in the smaller font, and using the such mark in respect of the identical and similar goods, that is the biscuits. The petitioner has also enclosed the invoices showing that the petitioner is selling the biscuits since the year 2005 under the mark called Top Gold.
Page 50, 45, page 50.
Top Gold.
Starts from page 1.
Full stop. The full stop. The petitioner also enclosed the certificate showing the sales figure of the biscuits under the name Top Gold for total amount of rupees 11.06.51 lakhs. 1 lakhs. Full stop. Considering the submission made by the counsel for the petitioner, peruse the materials on record. This could find that the petitioner has also obtained the document from the website wherein it is found that none of the company are using the mark Top Gold, though the Top Gold mark of the petitioner was accepted and advertised. Full stop. Considering the above facts and circumstances, this court find that the petitioner has made out a prima facie case and balance of convenience in favor of the petitioner. This court also find that if at this stage an ad interim order is not passed, the business of the petitioner will suffer irreparable loss and injury, as the defendant respondent using the mark of the plaintiff Top Gold and oblique or Top Gold star identical to the mark of the petitioner. And accordingly, full stop. Accordingly, the defendant respondents are restrained. Defendants, their men, agents, servants, assigns, dealers, distributors, or anyone claiming through them from using or enabling other to use the plaintiff's trademark Top Gold by manufacturing, marketing, processing, selling, advertising, dealing with the biscuits or allied products under the trademark Top Gold and oblique or Top Gold star in any manner whatsoever. Till 27th of August 2024.
Only one thing. I think the duty but you will clarify this order will not prevent him from using the mark
it is
top
made,
or parlay.
It is made clear that the order will not
Prevent the respondent from using the
restrain the
mark
defendant, restrain the respondent to use the mark top
or parlay.
Use the mark top or parlay without using the word gold along with the top.
Grateful.
So the plaintiff is directed to serve the copy of the application, plaint and documents, and to file affidavit of service on the returnable date. This is the matter on 27 August 2020.
Can you ask my lord to read the last line what lordship said? not prevent.
Along with
Great. Grateful. Monday. Grateful. Atif?
yes, next.
Grateful.
Ashe.
Grateful.
Customer matters, item number 2 and 3 of the commercial list.
That the original has come. May I hand up?
So and so appearing for the plaintiff, so and so appearing for the defendant. Full list. Different, and this application was filed by plaintiff.
Well, both, well, joint. Joint.
This application joint.
Yes, well, joint application.
Full list. The plaintiff and the defendants have filed a joint application being GA within bracket com number 4 of 2024, praying for an order for recording the compromise entered between the parties in CS number 59 of 2021 within bracket CS com number 252 of 2024 in terms of the deed of settlement entered between the parties on 24th of April 2024. Full stop. Subpara. The plaintiff has filed this suit against the defendant for a decree for an amount of rupees 92,65,347 along with interest and allied prayers. Full stop. During the pendency of the suit, by an order dated, by which order the full amount was deposited?
That was
By an order
Let me give you
dated
a number.
14 November.
Well, yes, the appeal court's order is of 13 December, by which that order was confirmed. 13 December, Lordship will find at page 22.
30.
Page 22, 13th December 2022 order.
By an order dated 13th December 2022, the appellate court had directed the defendant
That page 23, second paragraph. In view of the above, we direct the appellant to deposit the decretal amount.
directed the appellant to deposit the decretal. What was the decretal
The
amount?
decretal amount was 40 lakh. That was the order passed by the trial court.
Directed to deposit
Kindly
the
see.
amount of rupees 40 lakhs.
Yes, but as directed by
40
the
lakhs
trial
in
court.
terms of the order passed by this court dated 14th November 2020.
My lord.
In compliance of the order passed by the Honorable Appellate Court, the plaintiff and the defendant has deposited the said amount with the registrar original side of this court, and the said amount is lying with the registrar of this court. Now, during the pendency of the suit, the plaintiff and the defendants have entered into a deed of settlement. The settlement deed is enclosed with this application being annexed D, page 27 to
27 to
page 27 to 43.
Yes, my lord.
44.
That in fact, my lord,
44.
In fact, till 46, Lordship will kindly include because these are post.
But in this, they are not include that. That's why. Original check is not there.
In that case, Lordship will kindly
44.
Till 44.
27 to 44.
My lord.
Full stop. At the time of hearing of the present application, comma, the parties have also handed over the original settlement deed dated 24th of April 2024, wherein all the parties have signed the said agreement. Consider the submission made by the counsel for the respective parties, peruse the application and the settlement deed entered between the parties dated 24th of April 2024. After considering the settlement deed, this court find that there is no impediment to accept the settlement arrived between the parties. Accordingly, CS number CS-Com 252 of 2024 is disposed of in terms of the settlement deed dated 24th of April 2024 by making the settlement deed as part of the deed.
But only one thing, my lord, upon instructions, my lord, can it be recorded that this terms of settlement has already been acted upon by the defendant?
It is also fine from the record that though the deed of settlement was entered on 24th of April 2024, and in terms of the terms of settlement was entered between on 24th of April 2024, and in terms of the settlement, comma, the parties have also acted upon by paying and receiving the amount in terms of the money received.
Except the amount which is lying with the registrar.
No, that I will pass an order.
Yes. That is
with regard to acted upon in
Fine.
terms of
Yes,
in terms of the money in terms of the memo of receipts includes with this settlement deed. Full stop. As the amount is lying with the registrar of this court, and the who will take the amount?
The defendant,
the defendant will and then
Full stop. In terms of the deed of settlement, comma, the defendant is at liberty to make to receive the amount of rupees 40 lakhs along with the interest accrued therein from the registrar of the original side. The registrar original side is directed if the defendant applies for withdrawal of the said amount, comma, the same may be released upon proper identification. In view of the above, suit is disposed of, decree withdrawn by making the deed of settlement as part of the decree.
I'm so grateful. But same order may be passed.
Similar amount is different, or in that amount
same
40,
amount.
40.
With the same terms of settlement, same with the different.
There's no direction for the other matter. There's no deposit made in that.
Yes, only one
The
thing. There is no
fact that-
deposit in the other suit.
And
So
there's
if your
no
lordship
appeal
kindly
clause.
omits that portion where you
40,000 is not there.
40 lakh is not there in the other suit.
But
But the
then
terms
that-
of settlement is the same.
That will not.
Grateful.
Okay. Accordingly, all connected application is
Item number 10.
Lord, I have 5 minutes before your 12 o'clock matter. I'll try and finish it within that. This is a very simple infringement and passing of matter without too much controversy. In this case, just
not controversy suit.
This one should be without controversy. The only I'll indicate to your lordship where the controversy can be, if at all. We are not real estate developers with a large number of developments. Please come to page 9. I'll just take your lordship through it very quickly. These are page 9. There's a table annexed, and if your lordship turns the page, we make townships and big projects, real estate development projects. So these are very big ones, and we have hundreds of crores worth of sales. Now, we are one of the biggest in Eastern India. Now, if your lordship comes to page 12, reason I say it's should not be without any controversy. Now, my registrations are annexed, and two of them, item numbers 4 and 5, your lordship will find are word marks. So I have registration over the word Solaris in respect of the class relating to real estate. Now, I also have these label registrations. So, Not that I have a right over this mark, not very difficult to not dispute. Now, Lord, I have annexed sales figures. I've given Lord pictures of projects and all of that. Lord, I've been around from 2017. Earlier, I was under some other name, but not from 2017. It's been Solaris, and all these are registered, my friend. And Lord, your Lordship will also find one more thing, Lord. Now, Lord, Lord, the controversy here, Lord, relates to I have been selling all my projects, Lord, under the Solaris name, and Lord, those things are next, Lord, including advertisements to show I'm doing it. Now, my Lord, suddenly the defendant, Lord, if your Lordship will turn to Lord, page 200 and 361. Now he starts marketing Lord, a project under the name Siddhi Vinayak Solaris. And Lord, your Lordship will find Solaris is the prominent part of it. 361, bottom left side. 361, your Lordship will find is it two. Not 361, your Lordship will find this Solaris, which is my registered mark. And your Lordship has seen my label also. The label is also very similar. I won't say identical, but very similar. That Siddhi Vinayak is almost invisible. And my Lord, he puts up the picture of this building on the next page. Now, this is not a ready building. This is not the picture they put of what the building is going to look like when it is ready. Now, the actual position on ground, now, my Lord, if your Lordship turns to page 300 and so, my Lord, their plans, this is their booklet and pamphlet. And, my Lord, we've given the pictures. If your Lordship, Lord, turns to page 397, this is the actual position on ground. There is nothing over there. Colored. Lord, I'll just give them. It's not visible in black and white. Take it out and give it. No? Lord, these are the pictures. The work is going on. Lord, that black and white, it's not visible, I find. So these are colored pictures. Nothing has really happened today. Sure.
This is a defendant side.
Yes, this is a defendant side.
Yes.
Page 7. So, Lord, on ground, nothing has happened. On ground, nothing has happened. So, Lord, balance of convenience will also be in my favor. And, my Lord, for example, if your Lordship not sees page 403 once and compares it with the manner in which he is writing Solaris, but it's, I'll say, Lord, it's not identical, but very close. Lord, your Lordship sees. But I have annexed my booklets, and Lord, your Lordship has seen this is also one of my registered label marks. This Solaris.
So this is yours?
Yes, this is mine. These are ours. Lord, the registrations, Lord, I've showed your Lordship in tabular form. The certificates are all annexed here. So, Lord, he writes it in a very similar way. And, Lord, he does not highlight Siddhi Vinayak. In any case, Lord, in whatever form, he can't use Solaris because it's a registered.
Of the plaintiff.
Yes,
403 is of the plaintiff.
Yes. Now, not just threefold submissions. Not I am registered for real estate. I have word mark. I have label marks which are similar to what he is using. So, it will be a clear infringement because same goods or services and also identical word mark and very similar logo mark. And my logos are registered. My word mark is also registered.
Yes.
So, it's a clear case of infringement. It is also a case of passing off, because of the way in which he is trying to do it. But he need not have adopted it. And, the other thing is based over. He is also, the only other relief I'm looking for, if your Lordship turns to page, he is also using it as part of his domain name, this Solaris. So, I will want to, he is using this as part of the domain name, that your Lordship will find, the pleading is there, this But I'm just showing it. He's calling it Solaris.home creation.
Siddhi Vinayak Solaris Sundarpuram. Sundarpur.
So he is using Solaris.home creation. Now I want to stop the Solaris because whenever one looks for Solaris, you are getting this.
Have you pleaded this?
Yes. I'll give your lordship the paragraphs, pleaded, and the only other thing which I need to point out here is, your lordship is aware that after SIFI's judgment, I'm carrying it, may not be necessary, your lordship is not familiar with it. Using it as a domain name is also passing off. I'll just give your lordship the judgment just for ready reference. Should be down, right? A copy though. Well, I'll hand up my copy. Para 16, if your lordship sees, but the Supreme Court has said. They've equated it with passing off. Only when I asked you.
Yes. Where is the pleading? The domain?
Yes. Pleading of him using it as a domain name. Paragraph 36. But 36 and 37.
Yes, got it.
The pleading is there. Now, your lordship asked me, when can a matter be without controversy? I'll tell your lordship here, what the only possible controversy could be. I am West Bengal, he is in Bhubaneswar. That's the only controversy which could happen. Here, the mark is settled. First, he could raise the point of jurisdiction. Registered mark, I am over here, under the Act itself, 134, this court has jurisdiction. So, doesn't create a jurisdictional problem. Number two, my registration is not limited to West Bengal.
Where this construction is going on? Where the construction is
going on? This construction is going on in Bhubaneswar.
Bhubaneswar.
And they are advertising over here, but it doesn't matter. Under 134, the place where the registered proprietor stays, that court will have jurisdiction. So, that controversy will perhaps not arise over here. And as far as passing off and otherwise or the infringement is concerned, my registration is not restricted to West Bengal. The registrar can do that, but it's all India registration, so it will be an infringement anyway. I didn't need to deal with it, but since your lordship had said, can there be? So these are the two possible controversies. I need not have gotten into it.
Yes.
And if your lordship will therefore consider restraining the respondent from using Solaris in any way or manner in relation to his project. If your lordship kindly turns to page 47. So 47 prayer is to restrain them from using Solaris, which will cover this, cover everything, and D is relating to the domain name. So if your lordship considers A and D.
Yes. That's all?
Yes.
Officer. I'll pass out. You will get.
I'm sorry, I overshot by 5 minutes. I thought I'll finish by.
No, that's why you not dictated. That's why you
Also your matter.
No, that's good.
Matter 6 and 12, no, item number 39 to 41 of the commercial.
I appear for Gaston number 5, my lord. The second matter, Garden Silk. So far, my instruction is concerned, my lord. The person concerned who has passed the order was validly appointed in persons of section 3(2) of the Act.
But we had finished the submission.
Yes.
They were
There was allegation that some other person passed the order, some other person heard the matter, and order was passed by Mr. Saurabh Dubey. That fact is not true, my lord. he was appointed and he has passed the order during the tenure of his appointment. Lordship, I'll indicate, I placed some of the documents below, which will show.
You are appearing for?
Respondent number 5. At the chart. Our
কপি দিয়েছেন
the first document, my lord.
কপি দিয়েছেন না কিছু দেয়নি এটা কপি
একটাই আছে first document, my lord.
No, you are appearing for whom?
For the registrar trademarks. Respondent number 5.
Respondent number 5. Which matter you are given?
Respondent number 5. Item number 41. Garden silk matter.
তো দেখেন আয়রন সিল্ক 5 মিনিট দাও দেখি
Respondent number 5.
Yes, number 5 too.
My lord, in garden silk. That's after the visa matter.
After the visa matter, my lord.
Garden silk.
Yes.
Garden silk.
That's it.
IPDTMA Com 1. So garden silk.
it's IPDTA 1 of 2020
Which matter you are appearing, sir? Which matter?
Garden silk, my lord.
Gardens.
নাম্বারটা বলো আবার কেন
এটা ভিসা IPDTMA Com 1. এই তো garden silk.
তাই তো বলছি নাম্বার কত না না লিস্টে নাম্বার সিরিয়াল 41
Yes, 5.
The first document, my lord. This is the office order by the Controller General of Patents in pursuance of the powers conferred upon the Controller General of Patents, Designs and Trademarks by subsection 2 of section 3 of the Trademark Act 1999. It is hereby directed that the various functions of the registrar shall be delegated through the e-module of the TMR system upon the direction of the registrar of the system administrator. So it was the direction was there. Power was given under section 3, subsection 2 of the Act. May I just indicate section 3, subsection 2, my lord. The central government may appoint such other officers.
Just a minute. Let me. Patent Act. Where is the Patent Act? कुछ करो ना
The copy has given on.
Yes.
Section 3, 2. The central 3, subsection 2, my lord. The central government may appoint such other officers with such designations as it thinks fit for the purpose of discharging under the superintendence and directions of the registrar such functions of the registrar. Under this act, he may from time to time authorize them to discharge. So power was given to appoint such other officers.
Yes.
Now, Lordship, kindly the next page, my lord. Next page of the document, my lord, I have submitted.
Yes.
Next page of the document I have submitted, my lord. This is the office order by the joint controller of patents and designs. As Lordship confused, head of the office of TMI Ahmedabad, Chennai, Delhi, Kolkata, and Mumbai are hereby authorized to allocate, assign works to contractual manpower. So there was authorization for appointment of contractual manpower.
The similar documents have relied upon by them.
So Mr. Saurabh Dubey, who has passed the order, was appointed. Lordship will kindly see the next page. In pursuance of the advertisement issued.
Page? Which one?
Next page, my lord. The document I have submitted, advertisement, walk-in interview. Next page, my lord, advertisement.
This is a mail. Next page is the mail.
No, my lord.
Yes.
Next
Next page is the mail. Then details of the officials.
No. May I get back? Wait that one second. Wait. That got a problem.
Way back.
Sorry, this is the page. This is the advertisement published. The terms and conditions for appointment was given.
Yes.
By the QCI, Quality Control of Quality Council of India.
Yes.
And Lordship kindly says the next document 14/6/23. Next document, Lordship kindly says the next document 14/6/23. And later dated 14/6/23.
Yes.
Mr. Saurabh Dubey was appointed on 14/6/23. And his tenure, next document, my lord, his tenure was extended for another period of 6 months. That is till 30th April of 2024.
Yes.
Now, Mr. Dubey heard the matter on 30th, sometime in August 23, during the tenure of his employment. And he has passed the order sometime in December 23. So these are
your submissions. So as per your opinion, he is the authorized person.
Yes.
So he can pass an order. There is no.
And there was another document, my lord. Another document, my lord. There's a mail. There's one mail, my lord.
Yes.
That was in the beginning, my lord. There's a mail whereby
5th July.
5th July.
Yes.
Attached details of new QCI officials. And the next page, my lord. Number 3, Mr. Saurabh Dubey, Associate Manager, was appointed to QCI. These are my submissions. He was validly appointed. And another submission, there was some mistakes in the order with regard to dates and number. So my submission is Lordship can remand back the matter for correction.
I accept, Willard. I accept. Willard, the registrar is saying remand back. I accept, Willard. It's a registrar who can say.
Only for correction.
He can't say, Willard. Not Mr. Bachar. Registrar, Willard, saying.
Not in our application.
अरे आपका क्या ना अरे बोल अपनी लेके जाने तो he is saying remand.
No, since
registrar Willard is saying my order, please
I'm
go
not
back.
saying, since there was allegation was made, that's
Yes.
why.
If he says Willard fair, it should go back. Lordship will kindly record.
I will show your lordship there is a typographical error.
Registrar is not saying so. Willard, the person who has passed an order, he is saying that please, I am going to willing to go back.
No, I'm not saying. I'm not.
No, he's saying for remand.
No. I'm not. No, I'm not saying for remand. Since there was allegation was made, since they have also filed an application, that can be decided. Only for correction. Only for correction. That's all.
Yes.
Submission and merits we have not argued.
But just to not clarify any confusion, this correction is to do with that
No,
card
it's a
missing
separate
matter.
matter.
It's
I accept.
nothing to do with visa.
I
That's
accept.
all.
I
No,
accept.
Here there is no concession of any kind.
No,
by
I
anyone.
accept. If the order Willard calls for a remand, it goes back. Now, Lordship will give me 1 minute, Willard, too much of papers. আমি তো রিপ্লাই জাজমেন্ট গুলো ডিস্টিংগুইশ করতে হবে বসে পড়
Is there any other matters with regard to this?
No, sorry. No, these are the two matters.
These are
my
the
lord.
two
They
matters.
have spoken, my lord. I give a
The
composite.
visa matter, my lord, is a different matter. And my lord, so far as Garden City is concerned, it's a different matter.
I believe Mr. Bachawat has already said so.
My lord, facts are also different,
He
everything.
has already said so.
Yes.
Repeat, reiterate, my lord, it's good, but not at the time of hearing.
Continue. Yes.
Visaটা তুমি চলে এসো মিলাদ I argue visa first because মিলাদ visa the judgments have been shown মিলাদ I have to distinguish মিলাদ 6 of his judgments মিলাদ first point argued is milad the present appeal proceedings is an appeal under section 91 of the Trademarks Act and it presupposes, since I have preferred an appeal, it presupposes the order has been passed by a registrar or any other person appointed by him. Now, Millard, if your lordship kindly look, Millard, volume 4, Millard, the order in question. Kindly have a look at the order. Millard, the order is at page.
You are in?
I am in visa, Millard. Kindly, Millard, takes Millard, IPDTM 83 of 2023.
It's good.
Yes. Millard, the order, Millard, is captioned as page 594, volume 4. The order is captioned as before the Register of Trademarks, Kolkata, in the matter of such and such. Has Lordship found out the page?
Yes.
So, Millard, the order is said it is before the Register of Trademarks. Now, Lordship will kindly take Millard, page 599. But the order has been passed by the person named therein, who is the Assistant Manager of Trademarks. So, it's an order passed by the Office of the Registrar of Trademarks, but not by the Registrar of Trademarks, by someone else other than the Registrar of Trademarks, who is Assistant Manager of Trademark. So, Millard, I have to come up in appeal because that's the appellate forum. Because, Millard, the appeal says, Millard, if Millard, my challenge is the person who has held the hearing is not the Registrar of Trademarks, nor is an officer, cadre, or a cadre officer of Millard, the Office of the Registrar of Trademarks. He is not an officer from the cadre of office.
Yes.
I am up in appeal. Now, Millard, the simple thing, Millard, on the first line, extension. Millard, this I take, Millard, in this matter, 2 documents were, Millard, produced by the, I am, Millard, making my arguments into different compartments. I keep garden silk separate, I keep visa separate. So, Millard, if your lordship takes, Millard, the documents produced in this matter by Millard, the registrar of, by the Office of the Registrar of Trademarks, in this matter in question, only this matter. Lordship must have a letter must be having a letter, Millard, of Millard 28th of February 2024 in the Millard letterhead of Mr. Sunil Kumar Singhania. That is in court, Millard. If it's not there, I give my lords a copy.
Page number?
Millard, that he produced, his authority. Like today, Millard, bunch of papers have been given in the garden matter. It's in the visa matter. No, 1, 2, 3, 4. Because this matter, I am only to deal with these two documents.
Yeah.
Copy আছে dot save ke dao na. May I hand up Millard without
Let
Millard
me tell
wasting
you,
the
Mark,
time.
which letter you are referring?
It's Millard 20th of February 2024 by Sunil Kumar Singhania, issued to Mr. Khaitan Company. This looks like this. 20 February. হ্যাঁ কাভারিং লেটারের তলায় একটা দুটো চিঠি দিয়েছে may I have এই দুটোই তো দিয়েছি
20 February 2024.
Yes, it has two enclosures, Millard. One is Millard, the first enclosure, which Millard is the letter of registered trademark registry to Mr. Sunil Singhania. It's an instruction.
Yes.
It's not an office order.
Yes.
It's a mere instruction.
There are two letters.
Yes. First one is an instruction to the advocate.
Sunil Kumar Singhania.
Sunil Kumar Singh. What is the instruction?
Information regarding authority.
At the cost of repetition, I say it's not an office order. It's an instruction to the advocate in question.
Okay.
With reference to Millard information, Millard, the caption is information regarding authority of associate manager appointed through QCI to hear trademark matter. So Millard, it's an appointment not by the central government. It's an appointment. You will get your chance to hear the opposition and pass orders. Now, Millard, with reference to the subject mentioned above, it is to be informed that office order number such and such, that's 24th of May 2023, issued by CGPTDM, Mumbai, which is the administrative headquarters of the Office of the Register of Trademarks, Ahmedabad, Chennai, Kolkata, and Mumbai, are hereby authorized to allocate works to contractual manpower. So kindly makes a note, it's contractual manpower. Deployed at the location through the Quality Council of India, QCI. Therefore, in pursuance of the aforesaid order, Head Office, Trademark Registry, Kolkata branch, allocated assigned matter of hearing opposition matter and passing orders really to the associate managers deployed through QCI, Trademark, Kolkata branch office. Millard, first of all, Millard, how it's an appointment by the central government. Millard, this is not a work order in question, Millard, appointment order in question. Now, Millard, kindly Millard, takes Millard the next letter. This is Millard, the sum and sub. This is an instruction to the advocate. This is merely an instruction to the advocate. I heard my learned friend saying, if Millard, the three documents are read together, then the cards fall in the right place. He has the authority. First of all, it's a mere instruction to the advocate. It's not, Millard, an office order. Because I had showed this. They had produced and I had relied on it. Now, Millard, kindly take Millard.
Yes.
The office order, which is 24th of May 2023. The head of offices TMR, Ahmedabad, Chennai, Kolkata, Mumbai are hereby authorized to allocate work to contractual manpower deployed through location of QCI. In Millard, contractual manpower QCI. In addition, head office TMR is also TMR Mumbai. So Kolkata is conspicuously absent. He is also authorized to assign, who is in head office TMR Mumbai, is authorized to assign the work of the contractual manpower through QCI, such and such Nagpur, hereby declared as a one-station unit of TMR Mumbai. Hence, TMR application TMR shall also be examined and deposed therefrom. Next, having regard to the above, all the allocations and assignment by the head office shall be submitted to the office pursuant to CGPDM, and further direction, if any, shall be noted to the contractual employment, who shall have 6 days in a week and hence to supervise the work in a Sundays for regular employment, and shall prepare and announce the entire quarter in advance. The employment shall furnish the weekly performance report to the head office. First of all, Millard, I break down. It relates to Millard, head office, Mumbai. Secondly, Millard, appoint employee, but purpose not stated. Thirdly, Millard, The work order does not specify itself because it's a source. My lord, the power to examine and adjudicate in relation to opposition or rectification. So, my lord, this, my lord, itself doesn't. My lord, it goes worse. My lord, kindly have a look at. I am, my lord, interested. Nothing else have been produced. If he is, my lord, pressing his hard, my lord, like, my lord, the garden matter, then, my lord, there should be an authority, my lord, of this, my lord, particular person, my lord, who is hearing the matter. This too, my lord, has come on record. And the third document, the order of I have gave the nothing else as before your lordship. Simply, my lord, like the other matter, this is, my lord, the appointment of, my lord, this is my first lay of the argument. This, my lord, Mr. Chakraborty, my lord, there's an order of engagement. Now, I have given my learned friend a copy. The entire document was not produced. There's a set of documents which is, my lord, connected to this. Kindly, my lord, look at the document in question. The entire document, my lord, which, my lord, two other documents which he relied upon, this was, my lord, not produced. I had given my learned friends the copies. There is no response to it. Because I said, my lord, entire document should come forward. Kindly look at, my lord, the letter of appointment in question. Kindly have a look at it. I have given him the copy. There is no response to it, my lord. Kindly have a look at it. Letter, my lord, which is, my lord, very important. And in all fairness, my lord, this should have been, my lord, shown to the court. My lord, it's dated 13th of, my lord, April 2022. Offer of engagement. My lord, I cannot come. I have luckily got it from the website. This should have been, my lord, said. My lord, kindly take order of engagement of this particular person. My lord, yes. Now, my lord, kindly take, my lord, the next one, next page. Lordship will kindly take. This is by the Office of Government of India, my lord, Ministry of Trade and Commerce. Kindly take, my lord, page 4, the next page. No further continuation beyond the period 31/3/2023 can be claimed. What is the date of my order? This should have been supplemented by the registry in question. This is, my lord, part. This is why, my lord, the documents have been shown, my lord. Two of them were uploaded. Kindly, my lord, takes 31/3/2023. The above engagement is made on a purely contractual basis, contract basis, and will not confer any right as a regular employee. That is serial number 10. The contract can be terminated without any prior notice and without assigning any reason. Therefore, the period of service done by the candidate hearing officer, trademark attorney cannot seek claim for age of relaxation for employment under the government. So, it's a pure contractual service. Now, my lord, now, my lord, it's a relevant period of, my lord. If your lordship, my lord, takes, my lord, what is the date of the order in question? Kindly, my lord, takes 594. My lord, the hearing took place on, my lord, 30th of May 2023. If your lordship, my lord, can take it from me, the order has been passed on 16th of September 2023. If it is an irregular appointment, my lord, so far in that matter in question, the counsel appearing, my lord, for, my lord, the central government or the trademark registry has given 2D documents.
Whether this order has not been extended?
I do not know. At least he, my lord, doesn't, my lord, give any paper. What he gives, my lord, 2 documents.
How could anyone deal with it? He only filed these documents. He never said it to say that the appointment has ceased.
I have said
How
so.
can anyone deal with a
It's very unfortunate. My learned friend files document. I gave him a copy. I said I'm going to rely on it. I haven't said
on it.
I said
500 sentences there.
Mr. Bachawat, if
Please,
it is,
Milord,
if
it's,
the
it is
party
part of the
found
document
that,
which he
My lord.
relies upon.
if it is party found that the document is necessary and
Yes,
they got.
I am not coming in the way. All I am saying is my learned friend made a submission that a document was given to me. I did not deal with it. Now, my lord, he simply filed it. Did he make any submission that he is going to rely on this
It was
document?
already over.
1 minute. Please don't talk over me. My lord, did he ever make the submission that this gentleman's tenure has ended? His submission was he was never appointed. So I've dealt with it. Now, my lord, if he wants to say it has come to an end, I'll deal with it.
I will not interrupt my learned friend. Why he is interrupting? If he wants to say, he can
I
have a
will-
bite.
I will-
Give him a second bite,
Mr.
Mr. Cherry.
Both are senior, not to.
No, I am not senior. He is senior.
This is not fun and games. He made this imputation that I did not deal with it. But I can only deal with something where he makes a submission.
Milord, I have given him the document. This is part of the bunch which he rely upon.
You continue. The court requires, we'll ask for the clarification.
Yes, absolutely. No difficulty. So, Milord, this is, Milord, on the face of it, it's gone. Milord, this is part and parcel of, Milord, the documents, Milord, which were shown to the court. For the purpose of, Milord, showing, Milord, this is the, if, Milord, documents A, B, C, D and read together, I remember, Milord, distinctly, Milord, the cards will fall at place. This is the chain of events. Then why didn't you give the further chain? It's available in website. But the registry doesn't come and say, registry has given 2 documents. Who can defend it? The registry can defend it.
Yes.
So this is, Milord, issue number 1. So even if I take his best argument case, Milord, so far as the documents on record today, Milord, Shomoran's tenure has expired. There is no document, Milord, by, Milord, the authority who can vouch for it, saying that it has been extended.
Yes.
If they show, I meet it. And this is, Milord, uploaded in the website. He has given 2. I am dealing 2. I gave Milord 2 documents for the part.
Please, you want come on.
Yes. Now, Milord, the next point. Let us, Milord. I am very sorry. No. It's a point dekhi lavni. Now let us come to, Milord, the point of law involved in it. Whether, Milord, if you, Milord, kindly, Milord, takes, Milord.
Who is appearing for the authority?
My
What is your instruction? If it is correct,
May I submit one
if it is
submission,
not, if it is correct
Madam,
that his engagement
this
is not
point, Madam, may I say, this point is not taken in the
not
grounds of
taken,
appeal.
okay, that's why I'm asking all you. If this engagement has not extended, then order.
I have to take instruction whether it has been extended or not. I have to take instruction. I will inform the court.
How soon you can take the instruction?
Next week, by 3-4 days.
Because this is the main. Without going further, if you say you come with an order that yes, order has been extended, thereafter he has passed, then on merit the court can go.
No,
for
no,
it.
I am not.
My lord, my
this.
preliminary point is there is no such ground in the appeal.
If it is not also, the
Yes, my
court
lord,
can
and
take
no
the-
supplementary affidavit has been filed, my lord.
Necessary.
It's a verbal ground. First time.
I will
No, no,
record, this
only
court
the
will
Mukerjee
record
order,
this
sir.
objection. Once this court find the order passed by the authority is not the authority on that day, the court cannot take the cognizance. With the appeal, the grounds of appeal is required.
No supplementary affidavit
Not
has been
required.
filed. Only verbal ground.
Hold that. I will hold that. I will hold that. If the documents got by the court, finding that the officer who has passed the order, he was not the officer on that day, whether the court can shut his eye.
My lord, the officer was well within.
That's why I'm asking.
I will submit, my lord, on instruction, my lord.
Whether his service has been extended or not.
Or not.
If it is not extended, automatically order.
I shall submit. Kindly
Has
give
to
me
go.
3-4 days. I will submit. 4 days required, my lord. I will submit.
And Millard, without that also, Millard.
It's better, Malad, may submit, Malad. May,
not
Malad.
allow.
Malad, every,
just a minute.
Malad,
Mr.
on every
Mr.
hearing,
Ghosh,
Malad.
just a minute. Mr. Ghosh, what are the document you require, you are harping upon?
Yes.
Please give the document along with an affidavit
I
so
gave-
that I can serve them so they can reply.
Yes, Malad.
Millard,
No,
only one thing. Without that also, Millard. Kindly, Millard, this is happening not from now. 5th of February 2024, I take this point. Millard, it is pointed out, it is not there in the ground of appeal. There is an order of the court to disclose Millard. Millard, under what authority Millard he has Millard acted. That is the document has come. That stage is over. That is Millard order of 5th of February 2024. That is Justice Mukherjee's order. Now, Millard, without that, for the Millard, kindly gives me 2 minutes, Millard. This Millard, cat and mouse Millard game should stop. Now, Millard, kindly Millard takes Millard the order. Millard kindly takes 3 Millard, section 3. Kindly have a look at section 3. Every day, Millard, you give chits and pieces and you don't disclose it. What is uploaded in the website? It's your website.
Yes.
Kindly Millard takes on the interpretation of the section. Even Millard proceeding, Millard, he was validly appointed. Kindly take section 3. I have to distinguish the cases. Appointment of the registrar and other officers. The central government may by notification in the official gazette appoint a person to be known as Controller General of Patent Designs and Trademark, who shall be the Registrar of Trademark for that purpose. This was my first argument. So, Millard, there is no notification under subsection 1. Kindly, Millard, make a note of it. Central government by notification in official gazette appoint a person. So, Millard, person. So, Millard, a notification is required.
Yes.
Now, Millard takes 2. The central government may appoint such other officers, not persons. It's not person, officer. The central government may appoint such other officers with such designation at is fixed for the purpose of discharging under the superintendence and direction of the register and the functions of the register under the act as may from time to time authorize them to discharge.
Correct.
So, Millard, when a person is appointed, he needs a notification. Because he presupposes he is not an officer of the central government.
Yes.
Or an officer, Millard, of this particular branch.
Yes.
When an officer is appointed,
Yes.
that's Millard, this is a distinction. No notification is required, but the precondition is he should be an officer. Millard, but the judgment cited by my learned friend Millard makes the Millard the position Millard clear. Kindly Millard have Millard to look at the judgment cited by my learned friend. Kindly Millard have the Madras Millard, JP Medical System Millard, and Millard the Bisleri Millard. That is Millard. Sort of notification, everything is there. Now, Millard, kindly take Millard the relevant part. I'll be very short, Millard. He has passed, learned friend has placed in great detail. Kindly have a look at paragraph 13, where Millard, this section has been
Which citation? Which citation?
Millard, it's Millard,
JK Medical?
JK Medical, Millard.
Yes.
His Lordship will take, they have given a Manupatra copy, I believe.
Manupatra.
Then Millard, kindly take paragraph 13, where this section has been construed. This is Millard. I'm grateful to my learned friend Millard for citing this. Upon considering the contention paragraph 13, the parties, it is evident that this case hinges upon interpretation of section 3 of the Trademark Act. Section 3 is set out below. So, Millard, I have placed it, I have not placed it. From subsection 1 of section 3, the conclusion follows is that CGPDM is the register of trademark for the purpose of the Trademarks Act. This CGPDTM, who is the hierarchical apex, is in charge of the offices dealing with patents, designs, and the trademark. It follows that the registrar, as defined under section 3.1, cannot exercise all powers vested him under the Trademarks Act. Thus, the design and scheme of the Act makes delegation by the registrar. I am not on that. He is authorized to delegate for the purpose of carrying out function prescribed under the Act. Such delegation is enabled by Section 2 of Section 3. This is where notification, no notification. In response to a question, both counsel of the respective petitioner and the learned Attorney General said that there is no other provision in the Trademark Act that enables delegation. Now, paragraph 14. This is very important. In order to determine the issues raised in the writ petition, it is pertinent to break up subsection 2 of Section 3 into its constituent and analysis the same closely. I set out my analysis in subsection 2 and section 3. 1. The use of the other officer indicate that these officers other than the registered CGPD, albeit the word officer indicate that they should be from the cadre of officer. So there is a caution. So these officers should be from the cadre of the officers. So anyone outside couldn't come. It should be in the officer cadre of your institution. This is a judgment relied by my learned friend. The appointment from the other officers by the central government should be for the purpose of discharging the function of the registrar under the Trademarks Act. This is clear for the purpose of discharging such function under the register. Now, let kindly take 3. The use of the such designation indicates that there are no fetters. I don't dispute it. Or limitation with regard to the designation of the officers appointed by the central government for the purpose. Consequently, central government may appoint officer from any designation to perform the register. This is what in effect it means, that even officers with the designation of senior examination may be appointed for the purpose of discharging the function of the registrar. So, 1 has to be read with 3. First, qualification, he should be an officer cadre. It's an officer cadre post. That's the reason on the first day, I gave the rules of recruitment. It refers to officer cadre. And who are the officer cadre there?
Yes.
Now, kindly takes 4. Subsection 2 prescribes the requirement of the other officer to discharge the function of the registrar required to function under superintendence of register. This leads to the question, quasi-judicial function by the other officers of the Trademark Act and superintendent's direction of register. The obvious answer is that quasi-judicial functions are required to be functioned independently and not subject to the superintendence of the register. It could be contended on the basis that subsection 2 of 3 is only intended to empower delegation of the administrative power and not quasi-judicial power. So, delegation is only provided under section 3, subsection 2. Without that, there cannot be a delegation under the Act. If there is a delegation, delegation can be to the officer cadre.
Yes.
Kindly now takes the last. Therefore, 4 bottom, 4 line, 3 line. Therefore, the only reasonable interpretation of the expression under the superintendent direction is that it would apply to all administrative function and other register and not to quasi-judicial function. Yes. Now, 5. The use as he may time to time authorize them to discharge in 2 indicates that the other officer who were appointed by the central government to exercise function by the registrar should undertake the function authorized by the registrar. But the qualification or the benchmark is officer cadre or the cadre of officers.
Yes.
Lordship knows, this cadre of officers, who are the cadres, in different branches, like, the IAS services, IPS services, state government, there are cadres. Where says it should be from that cadre service. That is his judgment, say the first one.
Got your point.
You cannot read the judgment, in isolation without reading, the qualification, which the first qualification, serial number 1. even assuming, my lord, that he has, my lord, validly extended or appointed. Now, my lord, this is his first judgment. Now, my lord, I had given, my lord, the recruitment rules. Now, which, my lord, I had placed it in my opinion. It refers to, my lord, cadre of officer. দাঁড়াও 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 আগে দাঁড়াও এটা বলে দিই কাগজ তো হেঁটে গেছে সব কোথায় আছে বলো তো জাস্ট একবার বার করে দাও Well, I had given the recruitment rules on the first day. That's the reason Lordship says it's a delegation. কোথায় আছে বলো তো who are the officers is mentioned. And their, my lord, parent cadre or the department is mentioned. It may be, my lord, my lord, it's a gazette notification, should be internal page, my lord, 15.
15.
15, my lord. These are recruitment rules, my lord. Ministry of Trade and Commerce. There will be other recruitment rules, my lord, for, my lord, the administrative service or the police service.
15.
I have it.
Yes, it is.
Oh, copy abar extra diyecho. Oh, I am sorry, my lord. Very sorry.
It's the same.
No, no, absolutely all right, my lord. In exercise of the powers conferred by Article 209 of the
page you are
Constitution.
reading?
Millard takes Millard 14. The page before that, which start it looks like this, Millard, Ministry of Commerce. In exercise of the powers conferred by the provision of Article 309 of the Constitution, supersession of the trademark such and such.
That
Group
is
A-
609, yes.
Yes. Now, Millard, kindly take Millard where the word cadre is mentioned. Millard, first is Millard, Senior Joint Registrar. Now, Millard, these are cadre posts because Lordship will come, Millard, because they can come, Millard, from any post of the central government. Now, Millard, A, holding, Millard, analogous post, that's, Millard, page 15, Millard, the next page, or regular basis in the parent cadre or the department. Now, Millard, these are ex-cadre post. So, Millard, that is what the Madras High Court judgment says, that there is a recruitment rules, it provides for a cadre officer. That is, Millard, the officer cadre, that is the judgment of my learned friend, which he has cited. Millard, the Act, Millard, do not visualize contractual appointment in any manner whatsoever.
Yes.
It's not visualized by the Act. And Millard, if your Lordship comes back to the judgment in question, which my learned friend Millard showed, your Lordship Millard takes the judgment in question, JK Medical. If your Lordship Millard takes Millard, it has been admitted by the ASGI as well as the petitioner. That's Millard, paragraph Millard 13 of that judgment, relied upon by Millard's friends, Millard.
Which judgment?
Millard, that JK Medical, if your Lordship comes back again. দেখাচ্ছি এটা আগে দেখিয়ে দিই the judgment which I just show, Millard, this JK Medical, the Madras one, Millard.
Yes.
I'll only distinguish, I'm not going to cite any new judgments, Millard.
Yes.
If your Lordship Millard reads Millard, paragraph 13 of the judgment with me once more. Thus, the design and scheme of the Act makes delegation by the registrar imperative for carrying out the function prescribed by the Act. Such delegation, what delegation? By the registrar, is enabled by subsection 2 of subsection 3. In response to the question, both the counsels of the respective petitioner and the learned must be Millard Additional Solicitor General Government of India concurred that there is no other provision in the Trademark Act that enables delegation. So, Millard, the authority, Millard, has come and said so. Now, if your Lordship takes, If your lordship again takes the rules once, there must be something, my lord. The Honorable Madras High Court has said so. Of the year, he hasn't said, my lord, it's officer cadre.
Yes.
That is, my lord, lordship will now take, my lord. It is the third page.
Of the same rule?
Of the same rule. That's the reason on the first day, my lord, I showed. That's the rule of the central government. Now, will kindly take Group A, Departmental Promotion of Committee for considering promotion. Now, Millard, how is to be done in consultation with the Union Public Service necessary for appointing an officer on deputation, including short-term contract. So, Millard, they can do that, but in consultation with the Union Public Service Commission while appointing an officer on deputation, including short-term contract. You can send someone of the central cadre to please go and function. They will and discharge the official duties of the registrar because there are no manpower, but it qualifies. He should be an officer cadre, not a contractual employee. And what does cadre officer means? Lordship will find it in not their rules, in the rules of Indian Administrative Service Cadre Rules 1954, from where the UPSC rules have been taken.
No, that is correct. For every post,
yes,
the concerned department prepare
absolutely
notify the recruitment
absolutely,
and they give the criteria how the appointment is to be made,
Very
whether
well
it is
said.
to be UPSC selection or it is for the local selection, and the criteria for the selection of the post has been mentioned.
Yes, absolutely.
So
this
that's
is
why in the
Millard,
very first day, but when you have produced the document, now Mr. Bachawat has referred all the rules. Now the court has to be considered whether it is in
because
accordance
his
with the
judgment of Madras Millard is explicit, which is defining that such other officer and officer cadre. It must be something Millard. It is not Millard, something officer cadre has no meaning.
That is
anyone Millard on the road cannot Millard picked up and Millard be an officer. So the pre-qualification of section Millard 3.2 is an officer who is an officer cadre. This is a judgment of relied upon my learned friend Millard. I had it. Now Millard kindly takes the next Millard judgment question. Now Millard now kindly takes the next judgment, which Millard, my learned friend, has cited. Kindly have a look at the first judgment of on Millard waiver, the Procedural case, Millard.
Yes.
Millard, I had relied, Millard, on the point, a judgment of Millard 3 bench, that point of nullity or invalidity can be raised up at any stage, including arbitration, Millard, because we know, Millard, under section 16 of the Arbitration Act, point of jurisdiction has to be taken at earliest. If you don't take there and waive it, you cannot take it at all. That is, Millard, the scheme of the Act. Lordship has seen, Millard. But Millard, the Supreme Court now has said, Millard, even if you don't file section 16, Millard, you can take it in 34. The invalidity can be taken up at any stage, irrespective you plead it, you don't plead it. That Millard, the judgment, I do not Millard, 3 bench Millard I have showed. My learned friend showed a 2-bench judgment of Procedural, which is Millard 87-4 SCC 217.
Yes.
Now, Millard, it's a case for arbitration and a not of a waiver before appearing a statutory body. Now, Millard, arbitration, in this case, parties has agreed and appointed an arbitrator of their choice. As Lordship will find, Millard, in paragraph 7. That's the distinction in this judgment. If the parties to the reference, paragraph 7, I'll be very short, Millard. All his judgment, I'll try to distinguish it in 10 minutes or less than that. If the parties to the reference either agree beforehand to the method of appointment or after acquiescence in the appointment made with full knowledge of the circumstances, they will be precluded from objecting such appointment as invalidating subsequent proceeding. Taking part in the proceedings with full knowledge will amount to acquiescence. So, Millard, the parties beforehand agreed to go, Millard, to that particular person. Now, my lord, kindly, my lord, takes, my lord, paragraph 7.
7 you have gone.
Yes, paragraph 8, my lord. Kindly takes, my lord. On the whole, therefore, their lordship thinks, para 8,
Yes.
that appellant having clear knowledge of circumstances which have founded an objection to the arbitrator proceedings to make their award, did submit to the arbitration is going on. He allowed the arbitrators to deal with their case as it stood before them, taking a chance in the decision more or less favorable to him. And that too late for him for the award to be made on the application to file an award and insist of filing of the award. Now, my lord, this, my lord, proposition of law, which is, my lord, there in paragraph number 8, quoting, my lord, an old, my lord, judgment, my lord, is contrary to a 3 bench, my lord, which I have given. My learned friend says, my lord, the judgment, my lord, relies on, my lord, a judgment of N. Chelappan versus Kerala Electricity Board, which is also a 3 bench.
Yes.
So, my lord, this motion law is good law. This is the argument, lordship. Will remember it, my lord, so far. Unfortunately, my lord,
Yes.
the judgment which I cited, my lord,
Yes.
which I cited, my lord, 1917 SCC page 82, Hindustan Zinc versus Ajmer Vidyut, which I cite.
Hindustan Zinc.
Zinc, which says, my lord, invalidity in respect even of an award.
2019.
Yes, yes. It's a 3-judge bench, my lord. Proshunra is 2-judge bench. My learned friend tried, my lord, to overcome that, showing, my lord, Kerala Electricity Board is a 3-judge bench where, my lord, it has held, acted upon the principle acquiescence defeats the right of the appellant at a later stage. In the case fact, it was held that conduct of acquiescence, even where initial order was not passed by consent, every party by participating acquiescence can preclude further future challenge. That is, my lord, what he showed. That is, my lord, N. Chelappan versus, my lord, Kerala Electricity Board. That is a 3-bench judgment. And, my lord, this copy was given to your lordship, perhaps. What was not noticed, that, my lord, in paragraph 17 of, my lord, this 3-judge bench, which I, my lord, place, lordship can take it from me. We are of the view it is settled law if there's an inherent lack of jurisdiction.
Where from your reading?
Paragraph 17, my lord, of
this
my lord,
Prosun?
Vidyut. Kindly take. Proshunra is 2 bench. If I have a 3 bench, 2 bench is immaterial, my lord. It's not good law.
Paragraph?
Paragraph 7. Kindly look at the 3 bench in question. My learned friend, to overcome that,
Correct.
has Miller cited N. Chelappan, a 3 bench, so the old 3 bench will prevail. That was what we know. Now, Miller Supreme Court says, recent view, why haven't you considered? Now, Miller, kindly look at paragraph 17. I follow the same principle.
Paragraph 7.
17 of Miller, the Miller Ajmer Vidyut, Hindustan Zinc. It refers, we are of the view that is settled law. If there is an inherent lack of jurisdiction, the plea can be taken at any stage in collateral proceedings. This court has held in Karan Singh versus Chaman Paswan and quoted. What is missed out is Karan Singh versus Chaman Paswan is a 4-bench judgment.
4 bench?
It's a 4-bench. That's quoted in paragraph 17. Then it should have been seen, that paragraph 17 relies on a bench of a higher strength, immaterial. Today there is a 3-bench, there's a 2-bench.
Yes.
I am answering a query, Karan Singh is referred to, Karan Singh is 4-bench. That is quoted here. I am not relying. I am only for the purpose of saying it's a 4-bench. Justice Mukherjee, Justice Bose, Ghulam Hassan, T.L. Venkatraman, Iyer. So, what is the distinction in the 3-bench, 4-bench? There is a 3-bench. This is a subsequent bench. It's a 3-bench vis-a-vis a 3-bench, which rely on a 4-bench, which is a subsequent decision.
Yes. Next.
The present Supreme Court's view. So, this is Proshun Rai. Now, kindly takes the Gurdev Singh, so presumption. Now Gurdev Singh's case, lordship will kindly take 1991 4 SCC page 1. Lordship will kindly now take
1991.
Yes, 1991. He has cited 4 SCC page 1.
Yes.
Kindly have a look at. My learned friend has cited paragraph 7 and 8. For the purpose that something is illegal and void, that has also to be challenged. And for such proposition of law, paragraph 7 and 8 was quoted. Kindly Millard takes Millard paragraph 7, which follows to page 6, placitum A. Next page is page 6, placitum A. If an act is void or ultra vires, it is enough for the court to declare it so, and it collapses automatically. This is what he cited. It need not be set aside. It need not be set aside. The aggrieved party can simply seek a declaration that is void and not binding on him. The declaration merely declares existing affairs and does not quash or produce new status. Nevertheless, the dismissal order has to be at least de facto operation until it is declared to be void by a competent body. So, Millard, it was said, Millard, this was service matter. Millard, there was an order of declaration. That, Millard, there was an order of termination of service. Millard, personal contract, service has been terminated. Millard, how it is applying on a statutory interpretation of rules, whether someone is an appointment, I really don't know. It's a service matter, someone's service gets terminated. He files a suit saying, Millard, that Millard, my matter, my tenure has been wrongfully, Millard, curtailed, and a suit has been filed. In this context, Millard, it is said, Millard, unless you ask for a declaration that the act is void, it remains. So, Millard, this is the first one. Next, Millard, is the case of presumption. That is, Millard, 2011 4 SCC. Kindly take, Millard, 2011 4 SCC. He has placed paragraph number 9.
2011.
Paragraph number 9. That was placed, Millard. This case is N Money versus Sangeeta Theatres and others.
Yes.
Lordship will kindly take, Millard, para 9. That was placed, Millard. It is well settled, evidence sector law.
Yes.
That an authority has a power under the law merely because while exercising the power or source of the power is not specifically referred to, or a reference is made of a wrong provision of law, that by itself would not vitiate exercise of power. Next line is very important. So long as the power does not exist and can be traced from a source available in law. So this is my case. You may have a power. That is, Millard, section 3, subsection 2. So power flows from there. So if it is not there, whether, Millard, judgment will apply. First question, Millard, whether there is a power of appointing contractual employees. Under the Act, at least, Millard, I haven't found out any rules in the Trademark Act or any provision of the Act that this can be done, Millard, in subsection 2, where, Millard, the term is qualified as an officer.
Yes.
Now, Millard, 114E was relied upon.
Correct.
It say, my lord, court may presume existence of certain facts. My lord, it's a rebuttable presumption. If I can prima facie show, or my lord, show, my lord, with the fullest extent, that the power is lacking under subsection 3, subsection 2, my lord, the presumption can be rebutted. If I can show primarily that Mr. Chakraborty's tenure was not extended, at least on the paper today is none, Chattopadhyay, then, my lord, it's a rebuttable presumption. Court will not take it for, my lord, absolutely correct on such premise.
Yeah.
Now, the last judgment, which also was shown by my learned friend, my lord, may I show?
Mr. Ghosh, how much time will it take?
Just I'll wind up.
Just 1 p.m. matter is there.
Just, my lord, my lord, just show, my lord.
Which?
Just one, my lord, kindly, my lord. 65 Calcutta. This I need to distinguish, my lord. That is what was shown by my learned friend. My lord, it's a division bench of Calcutta.
Yes.
The case was, my lord, not, my lord, of a contractual employee. Kindly, my lord, look, my lord, paragraph number 3. In pursuance of subsection 2 of section 4, central government has appointed an officer called Deputy Registrar of Trademarks. Actually, there are several such officers. And the Registrar of Trademarks, that is to say, the Controller, the Controller General, to hear out application for registration, opposition proceedings, rectification, correction of the register, as well as interlocutory application to all other matters connected to the above. Well, is it a case here that a Deputy Registrar of Trademark has been appointed to hear out the matter? Now, my lord, kindly now takes, my lord, the funnier part, paragraph 5. In the present case, my lord, 6 lines from the top. An opposition had been filed, though through mistaken inadvertence, it was not considered, so that it cannot be said that the opposition has been decided in favor of the applicant. Thus, the registration was granted, although a precondition mentioned have not been satisfied. The learned judge in the court below has agreed with the above proposition and has actually held that registration was not made in accordance with law. However, he has, however, come to the conclusion upon consideration of the provision of the Act. This is most important, that the Deputy Registrar of Trademark had no jurisdiction to rectify the mistake or cancel the registration. If he is from the officer cadre, he is a Deputy Registrar. He is from the cadre, my lord, he can be appointed in the subsection 2 to rectify or correct the mistake.
Yeah.
Now, my lord, kindly have a look at. This is all, my lord. There is no discussion on the judgments on notification of section 2. There is nothing, my lord. My lord, it, my lord, proceeds. Deputy Registrar is a person or an authorized cadre officer or an officer who can, my lord, decide, my lord, the issue of trademark. This is, my lord, the case. There is no dispute to the proposition. Where is the dispute to the proposition in law? In fact, my lord, there is no dispute to the proposition. In fact, my lord, if your lordship takes the last office order, which I had showed, my lord, initially, which is, my lord, 9th of, my lord, June 2023. That is, my lord, after, my lord, Mr. Chattopadhyay's, my lord, appointment. Kindly look at the office order. It's a subsequent office order. This is also, my lord, I showed. Yeah. There are post mentioned, and, my lord, the post, my lord, has, my lord, the following persons. Where is assistant manager or a contractual employee in his office order of 9th of June 2023, which is a subsequent order?
You are already indicated that.
So, my lord, this is why, my lord, that cadre post, my lord, is reflected in the Madras judgment. And Deputy Registrar, kindly have a look at, my lord. My junior is absolutely correct. Judgment of Madras. Deputy Registrar is already there. Serial number 3. So, my lord, the post is envisaged under, my lord, the office order of the trademark offices. Where this is envisaged, my lord, under, my lord, 3, my lord, sub rule 2.
Yes.
So, my lord, in this context, my lord, so far as the first matter is concerned, I do not know whether it is extended because they haven't showed. The second matter, my lord, they have given some sort of extension, my lord. I have got it today. My lord, there, my lord, the first, my lord, my first argument, my lord, this is not an appointment order 2 because he is not within the office cadre. These are my respectful, sir.
Thank you.
But could I just point out 2 paras from that judgment? because my learned friend has now not abandoned the earlier argument. Here, let's just look at two paras from that judgment. The construction which he gives is, but please take, my learned friend showed two paras. I'll just show your lordship. I showed your lordship para 9 once. Now, please remember, my lord, this is not a writ petition by which he is challenging, my lord, the appointments. Appointments can't be set aside in these proceedings. Now, that's what not para 9 says. And, my lord, it says that, my lord, in fact, the Vairis is not under challenge. Then, my lord, please come on to, my lord, the two portions which my learned friend showed, my lord. Please come to, my lord, para 14, para 13 and 14. Lord, if your lordship sees, the last 4 lines, Lord, first is, Lord, there is a concession. This is a concession, it won't change the position of law, whatever it is. Now, my lord, please come to para 14. In order to determine the issues raised in these writ petitions, it was a writ petition. It is pertinent to break up 3-2 into its constraints and analyze the same. Now, my lord, please remember, my learned friends, my lord, entire argument made today presupposes not something that look 3-1 now gone, no notification necessary. But under 3-2, it must be a person belonging to some cadre of officers, some imaginary cadre of officers. That's his argument. Now, Lord, let's deal with that. Lord,
No, not imaginary. This is there in your rules.
Yes, let Mr.
if you would have a seat very kindly, I'd be very
Yeah,
happy.
I'm very sorry.
Don't say it's in my rules.
Yes.
No, I not in your rules. In
That
the
would be their rules. Their
IPDCL
rules. Their rules. Now, Tamrat, please see over here. Now, this is the analysis of subsection 2 of section 3. The use of the expression. Now, my lord, your lordship will have to read this very carefully in the context of not 2 words there.
Correct.
Other officers indicates that they are officers other than the registrar CDMT. Albeit, now, my lord, what does the word albeit mean? Lord, I'll show your lordship from the dictionary. The word officers indicates that they should be from the cadre of officers. But read in another way, what it says is, even though there's an indication that the officer should be from the cadre of officers, in spite of that, other officers here means officers other than registrar. That's what it means. Not because the term albeit in the dictionary, not I took the liberty of checking it out just now. I wasn't carrying a copy. Not it reads, my lord, despite, notwithstanding. So, my lord, if one is to read it like this, notwithstanding that the word officer indicates they should be from the cadre of officers, use of the expression other officers indicates they are officers other than register. This is number 1. Number 2, my lord, what does cadre of officers mean? Now, my lord, the definition of cadre, my lord, I'll show your lordship. It means nothing other than a team of people working together. So it can be a cadre of lawyers. That's what the dictionary indicates. No, this interruption is not appreciated.
This will then
Now-
will one have to see.
No, this is a brand new argument made, which has never been raised. Now, my lord, this cadre means, my lord, it includes the example, my lord, cadre of leaders, cadre of lawyers. Cadre means a team. That is all. It does not mean belonging to a recognized government service, which is what he wants to say. Anyway, to bust all that, my lord, I'll show your lordship. This is interpreted later on in the judgment. Now, please turn para 16. It says any officer. Nothing to do with cadre. I'll show your lordship 2 other portions. Let me put an end to the controversy. My lord, 16, your lordship will find 18, 4 and 5 are set out. Now, my lord, may I read the portion after that? Subsection 4 describes the registrar is empowered to refuse, accept absolutely or conditionally any application subject to provisions of the Trademark Act. When read with subsection 2 of section 3 as interpreted earlier, this power of the registrar may be delegated to any officer, not any cadre officer, not officer belonging to cadre. So any officer appointed by the central government. Now, my lord, please look at the notifications, all of which he has showed. Advertisement for appointing officers.
But Mr. Bachawat.
Yes.
See, it is not, it is a society. It is not, it is some association. It is a government
Absolutely.
body.
I agree.
And
Now, when does it become?
admittedly, all the appointments has been made in terms of the recruitment rule.
No.
And recruitment.
No, 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 no.
Just a
Yes,
second.
yes,
And the
yes.
recruitment rule has been framed under Article 309 of the Constitution of India. And all government servants are governed by the 309.
Very well.
Under the
I'll take it to
as
that.
per the recruitment failed by the
Absolutely.
government.
Absolutely.
And all the appointments. I don't know. That's why I can. It is not good to say from here.
Yes.
I don't know whether this appointment has been challenged
Extended or not, or
under
challenged.
the co-warranto process or not.
Correct. Your lordship is right.
Whatever the argument which Mr. Ghosh has argued, that is the case of the co-warrant.
Correct.
That is, but here I am not on the
Correct. We are not on that.
jurisdiction.
Your lordship will see whether the gentleman had the power to sit as a judge on that.
With regard to that, whether the officer, what the orders you have placed, you are right on your way as per the document given by the authority and appointed by the authority in terms of the order. Now he is telling that that order is not in consonance with the rules
correct, which
which
can't-
the government relied upon.
But that can't be the subject matter of challenge here, but be that as may. But I'm not on that. But I was on something else altogether. But the question is, not let us assume not everything else to be. Question is, assume cadre means appointed in accordance with some government procedure. That's what it can mean at the highest. Hey, listen, if you're going to keep talking, it's very difficult for me to hear myself. Now, my lord, question is whether these people who have been appointed belong to a cadre. Now, over here, what happened was first an advertisement by the Department of the Ministry of Commerce and Industry under the Office of the Controller General, asking for appointment of hearing officers. They are then appointed on a contractual basis, sent for training. Now, my lord, as I understand, a cadre is a group of trained people serving a common purpose. Now, the central government makes the appointment. The question is then, did they become an officer or did they not? But if they became an officer, then my learned friend's entire argument is meaningless, because any other officer, he's saying they must belong to a cadre. In other words, what are the cadres? He is trying to treat the cadre to mean you must belong to IAS or IPS or IRS. Question is not that. If you are appointed by the government to a certain position under its appointment procedure, you belong to that cadre. So, my lord, these people who were all appointed, your lordship will see any of them, as trademark officers, as hearing officers. That is the designation given to them. Now, for my learned friend to say they don't belong to any cadre, or a contractual employee can't belong to a cadre, my learned friend has to show some authority, but it can't be ipse dixit. I say he is not part of a cadre. Now, is that a submission? These are duly appointed officers of the government, by the government, to discharge certain functions. They have done so. Now, to say that the government did not do it properly means that the 50,000 orders they've passed are all going to go into the Ganges. Doesn't make sense. Doesn't make sense. Of course, if it goes
paragraph 10.
Let me finish myself. Let me finish myself. Let me finish.
Purely on a contractual basis. And will not run for any regular appointment.
Let the matter be.
Let me just finish with my submission. My learned friend can say whatever he wants to. Now, Millard, what he says, Millard, please understand the irresponsibility of it. The man does not challenge it before the registrar. He does not challenge it before your lordship when he files the appeal. Today, no, Millard, I'm going a step further. He has not dared to file an affidavit to say that this appointment was not made. He never made the submission till today that the appointment has ceased. Now, these have to come on affidavit and they have to be dealt with. And the department, and the, I'm very sorry, these are not on the website.
Sorry, Millard.
I'm very
You should have pointed out.
I'm very sorry.
You should have pointed
I'm
out.
very sorry they are not on the website. I'll show it to your lordship. We have taken out a printout of the entire website. My learned friend will show that it is there. Let him put it on affidavit. Lord, my learned friend can yell and shout and try and outshout, but that does not substitute saying something on affidavit.
Simple, Millard.
Let him say so. Let him say so.
Come from.
Where it's come from.
known it.
Not everyone knows where it's come from. Everyone knows. There is a
Same
dispute now, Millard,
website,
between There is now, Lord, in the department, Lord,
You have to turn, roll back,
Lord,
take their data. All data removed.
Let leave
Lord, let him file. Lord, let me just. Now, Lord, the
And
question
it's
is,
an appointment. The engagement is on
My
contractual
lord,
basis
I
and
have
not
one, my lord.
conferred in
My lord,
right to continue with the regular
my lord,
employment.
my lord, may I have one?
I have put already question, you have not given the answer, sorry.
No, my lord, I have gone through the emails, my lord. I have gone through the emails, my lord. The period was extended. My lord, I have gone through the emails, my lord. The
Grateful.
my lord, the period was extended, but that date, my lord.
Grateful. Much obliged, madam.
Well, exact date, if your lordship want, I can give, but the period
Sorry,
was extended.
once the court is putting the question, if you are going here and there and basing upon the others, this is the last court to hear that.
My apology.
That's why when I heard the submission of Mr. Ghosh, he has given the paper, immediately I put a question to you,
my lord,
but
he
you
is
failed
putting-
to give a
My lord,
specific
my
answer.
apology, but my lord,
This court has specifically put the question, when you be labeled, then you failed to.
it was extended, my lord. On every hearing, he pointed out the new questions, my lord. 42.
That is the court to decide
My lord,
whether new question or
kindly
old
give me
question.
time for exact date, my lord. I cannot say, my lord, from my own record. I have gone through the emails, my lord. The period was extended, and he was well within that period. He has passed the order, my lord.
This is a written argument.
Milord, item number 42, Milord, which is fixed at 1 p.m., Milord. Milord, my written arguments are not ready, Milord, today.
What
So,
you are doing, Mr. Singhania?
Milord, written arguments could not be ready. So technical data are there.
The problem, just one of your office advocate putting some question, your officers, your advocates are not able to give the answer. This is the department is running.
No, sometimes it may happen, Milord, sometimes.
Other
Otherwise,
side,
we
is,
are ready.
other side is bringing some orders which you are not able to give the answers. Before the court, one person is placing the orders. It is the responsibility of the respondents.
Yes, yes, Milord. PA agreement.
Justify that.
Yes.
Yes, how soon you will file?
So let's say 7 days, Milord. That next Friday we will file it. I will argue for 10 to 15 minutes in the writing.
Next week date होगा देखो लेकिन कोई खाली है.
Lordship, I'll just give handout one list on one small point.
आज क्या डेट है? 26. By 26 you can prepare.
Yes, you will. Yes,
I am fixing on 26 at 1 p.m. You file there.
Okay.
So and so appearing for the appellant. So and so appearing for the respondent. Police counsel for the appellant has filed the written notes of argument. Let the same be kept with the record. Counsel for the respondent prays for a week time to file written notes of argument. Considering the submission made by the counsel for the respondent, time to file written notes of argument is extended. Let the matter appear on 26th of July at 1 p.m. for filing written note of the argument by the respondent.
Lordship, that single sheet which I had given
That's
is on the basis of the resistance from the bar as to the appointment of a different controller. Now, these are suo moto done, and all these matters of this month only, there are 3 matters of this week, where they have moved from one controller to the other. For transparency, somebody who is doing the FER should not do the matter. So, in a matter like this, where evidence is not considered and then wrong considerations have been made out, it's my humble submission that it should go
That's
to
why Mr. Ghosh has raised the question whether this appointment can in accordance with the law, whether the person can pass the order. So now that is, so it is not the writ court, but court has to see whether the order passed by the person is a competent to
But
pass
these
the
people
order.
are appointed actually. I mean, that is for trademark contractual officials.
Contractual, but
but these are patent office officials are appointed.
That's why Mr. Ghosh has raised the question on that. That is the question raised by Mr. Ghosh, whether this contractual in the same, they have been appointed, sent for the training and appointment and delegation, whether they are the authorized to pass an order, which is to be done by the controller or registrar. is the question this he has raised. Okay. Okay, let's see.
Before your lordship rises. Thing, Millard, the foreign national Millard, who is company, who is opposing Millard this application. So there should be an apostle power of attorney as well as Millard Vakalatnama. Lordship will kindly, it's a technical. I forget those are because if that is not there, they don't have any right of hearing.
Lordship, item number 30 may go out of the list. So maybe in August, if it is fixed, we are also.
Item number 30.
30. I think Mr. Ghosh is also in that matter. So I'm saying that let it be fixed on a given date.
Yes, people will come down from Bombay.
UPL Limited.
Yes, it's no difficult.
Now, UPL is coming from Bombay. His clients are also coming from Bombay. So
any date lordship gives me. It has to be heard out.
It's ready.
No, not ready. It has to be heard out.
No, there is no requirement any affidavit and all.
Millard,
that's all done.
Millard, I have to take instruction. Lordship can first day, Millard, there is no scope for any Millard stay, Millard.
That's good. No, it is adjourned motion.
Then it's a no scope on this. The matter has to be heard out on the basis of the papers.
Papers.
That's all.
Give the date, August.
Item number 30 Millard, I am for the respondent. Item
Yep,
number 30.
I am fixing a date in the month of August.
Millard, yes.
Except 9th and
We are not filing opposition, so it can be.
23rd August at 2 p.m.
Okay.
Sense appearing for the appellant, sense appearing for the respondent. With the consent of both the parties, let the matter appear on 23rd August 2024 at 2 p.m.
The best person who can answer all these queries is standing beside.
That's why I'm asking.
Yes. He started briefing me when my fees was 340 rupees.
That's why now the Mr. also.
Before your lordship rises, your lordship.
Others will be offended if I speak here.
No, I'll be not at all.
You are not. But
yes.
I have other
Only one small correction in so as the names are to be included in the last lordship order.
Which order?
Just passed yesterday, lordship. Just.
You are not given the name.
I have given the names. The only 3 names are to be incorporated. We were present.
They're not given the name yesterday order?
Yes. I had personally given the name. But whatever, it can be incorporated. I was present, Mr. Sarkar was present, and Mr. Sinha was also present. Only this much, nothing much.
Learned counsel for the respondents. Respondents has mentioned the matter being GA Com 1 of 2024 in CS Com 727 of 2024 and submitted that in the order dated 8 July 2024, 18th July 2024, the name of the learned advocates are not mentioned in the cost title along with the learned advocate general.
And the GP.
Advocate. In view of the submission made by the counsel for the petition respondent, let in the cost title of the order dated 18 July 2024, the name of Mr. Paritosh Sarkar.
Sinha.
Sarkar written.
Ritoban Sarkar, Mr. Ritoban Sarkar.
Acha, Ritoban Sarkar, comma, Arindam Mandal and Mr. Paritosh Sinha shall be read along with the name of Mr. Kishore Dattalana Advocate General and Mr. Anirban Ray Advocate for the respondents.
Lordship, before Lordship rises a small mention, Lordship, for extension of AO Lordship, Lordship, extension of time to file AO Lordship expired on 10th July.
Which one?
This is Lordship CS 64/2024. It's due to list on 25th July. The person affirming is a senior citizen.
Listed.
Not listed, Mala. We have.
Which for the other side?
Lordship, I have served them the notice. They are not.
So mention you come with the other side, then we'll see to it.
Yeah, obliged.
I'm for the plaintiff. It's a defamation suit.
Yes.
Well, my witness is here.
Witness.
Yes.
Hindi, yeah, mix of Hindi and English.
क्या आप पहली बार आज गवाही दे रहे हैं?
हाँ, पहली बार गवाही दे रहे हैं।
बोलिए।
Which was the other side? Undefended?
Undefended. बोलिए। हम धर्म से कह रहे हैं,
हम धर्म से कह रहे हैं
इस मुकदमे में
इस मुकदमे में
गवाही के तौर पर
गवाही के तौर पर
हम जो कुछ भी बोलेंगे
हम जो कुछ भी बोलेंगे
सच बोलेंगे,
सच बोलेंगे,
सच के सिवा झूठ नहीं
सच
बोलेंगे
के सिवा झूठ नहीं बोलेंगे
और कुछ नहीं छुपाएंगे।
और कुछ नहीं छुपाएंगे।
आपका नाम?
संजय कंसल,
स्पेलिंग बताइए।
SANJAY, कंसल KANSAL।
SAL। पिताजी का नाम?
लेट महावीर प्रसाद कंसल।
लेट महावीर प्रसाद कंसल। आपकी उम्र?
जी,
उम्र?
48 गोइंग टू
48 इयर्स। क्या करते हैं आप?
मैं कंस्ट्रक्शन में हूँ, रियल एस्टेट
कंस्ट्रक्शन बिजनेस। और आपका पता बताइए, घर का पता पूरा।
एल्कोव ग्लोरिया 403/1 दक्षिण धारी रोड, सॉरी
एल्कोव ग्लोरिया
एल्कोव ग्लोरिया
ग्लोरिया
403/1 दक्षिण धारी रोड।
दक्षिण धारी रोड। दाढ़ी
दक्षिण धारी रोड। फ्लैट नंबर 9H।
फ्लैट नंबर
फ्लैट नंबर 9H 7000048।
7000048। यस सर। धीरे धीरे से बताइएगा, ठीक है?
What is your connection with the instant suit?
इस मामले में आपका कनेक्शन क्या है? आप किस तरह से इस मामले के साथ संयुक्त है?
जो कंपनी है उसके मैं डायरेक्टर हूँ।
आई एम द डायरेक्टर ऑफ द कंपनी, ऑफ द सेट कंपनी।
Which company are you talking about?
किस कंपनी के बारे में आप बात कर रहे हैं?
कंपनी का नाम है सिल्वर विला कंस्ट्रक्शंस प्राइवेट लिमिटेड।
द नेम ऑफ द कंपनी इज सिल्वर विला कंस्ट्रक्शंस प्राइवेट विला कंस्ट्रक्शंस प्राइवेट लिमिटेड।
Is this company a party in the proceedings?
क्या ये कंपनी इस मामले में एक पार्टी है?
हाँ, ये कंपनी इस मामले में पार्टी है।
Yes, this company is a party. This suit.
How is this company arrayed in the present suit?
ये कंपनी कैसे इस मामले में संयुक्त है?
ये कंपनी एक जमीन ओन करती है।
प्लेंटिफ है और डिफेंडेंट है?
दिस इज प्लेंटिफ।
This is the plaintiff company.
And what is your connection with the plaintiff company?
प्लेंटिफ कंपनी के साथ आपका क्या संयोग है?
मैं उस कंपनी में डायरेक्टर हूँ।
I'm the director of the plaintiff company.
Are you also EO nominee a party in the proceedings? EO nominee by name.
आप क्या एक नॉमिनी है?
आप भी एक केस में पार्टी है?
जी, मैं भी पार्टी।
Yes, I am also a party in this suit.
Why, according to you, did the plaintiffs file the instant suit?
Plaintiff ने ये
sorry, just kidding. Sorry. Who are the defendants in the instant suit?
इस मामले में डिफेंडेंट्स कौन है?
जमीन के बगल में जो जमीन कंपनी जो जमीन ओन करती है उसके बगल में जो रहते हैं मिस्टर मुरारी मोहन कर्माकर और उनके 3 लड़के हैं, वो लोग डिफेंडेंट हैं।
The land which is owned by the company around which the persons reside, Murari Mohan
कर्माकर, he is no more.
and late Murari Mohan Karmakar and his 3 sons are the defendant in this current Karmakar and his 3 sons are the defendant in the present proceedings of the suit.
Why has the plaintiff filed this suit against the defendants?
Plaintiff ने defendant के against ये मामला क्यों फाइल किया है?
जो कंपनी जो लैंड ओन करती थी उसके ऊपर मैंने सैंक्शन प्लान कंसर्न म्युनिसिपैलिटी साउदर्न म्युनिसिपैलिटी है, उस म्युनिसिपैलिटी
स्लोली छोटे-छोटे सेंटेंस में बताइए।
जो कंपनी है जो प्लेंटिफ है कंपनी वो लैंड जो ओन करती है इसमें, उस लैंड पे अपने सैंक्शन प्लान लिए फ्रॉम द कंसर्न म्युनिसिपैलिटी, दैट इज साउथ दमदम म्युनिसिपैलिटी.
The plaintiff company owns a land on which they have taken a sanctioned plan from the Damdam they have taken a sanctioned plan from the South Damdam municipality. बोलिए.
And after taking the sanction, हम लोग उसको कंस्ट्रक्शन स्टार्ट किए.
And after taking the sanction, the plaintiff company started the construction on that site. बोलिए.
वो कंस्ट्रक्शन जब स्टार्ट हुआ तो वो लोग आगे साइट पे डिस्टर्ब कर रहे थे.
After the starting of the construction, the defendants were creating problems on the site.
Thereafter we filed this suit.
After that, we filed this suit. Because of that, we filed this suit.
What have you prayed for in this suit?
आपने क्या मांगा है ऑनरेबल कोर्ट से इस सूट में?
This suit, मैंने क्लेम किया वो डैमेजेस फॉर द डिफेमेशन, वो हमको जो मानहानि हुआ है वहाँ पे, मेरे जो कस्टमर्स वगैरह जो लॉस हुआ है, मेरा कुछ बुकिंग भी हमारी कैंसिल हुई है, और उसके कारण हमारे और भी जो प्रोजेक्ट्स है सब हम माइक्रो मार्केट में काम करते हैं वहाँ पे, तो मैं जो भी कंस्ट्रक्शन.
एक सेंटेंस. वी हैव प्रेड फॉर द रिकवरी ऑफ लॉसेस, द डिफेमेशन दैट हैज हैपेंड. बोलिए.
वहाँ पे हम जो भी बिल्डिंग बना रहे हैं वो लोकल मार्केट में वहीं पे बना रहे हैं, तो उसके का ये जो उन्होंने एक पेपर जो जो डिफेंडेंट है उन्होंने एक पेपर पब्लिकेशन किया. उस पेपर पब्लिकेशन में जो उन्होंने पब्लिश किया, दैट वाज नॉट द ऑर्डर ऑफ द कोर्ट. मतलब उन्होंने कहा कि हमने
The defendant has made a paper publication. On that publication, what they have stated is not the order of the court. Stated was not the order of the court.
In the newspaper they have given that the court हम लोग को प्रोवाइड करता फ्रॉम द ट्रांसफर ऑफ द फ्लैट, कि हम लोग फ्लैट सेल नहीं कर सकते हैं.
In that advertisement, in that statement, they have stated that we, the
In the
plaintiffs,
publication.
in that publication, they have stated that we cannot sell the flats. We cannot, the plaintiffs cannot sell the flats
As per the order of the court.
as per the order of the court.
बट द ऑर्डर ऐसा नहीं बोल रहा था कि.
But that was not a fact. There is no such order. আর কিছু বলবেন?
অর্ডারে এটা লেখা যে যে কিনবে সে নিজে দায়িত্ব কিনবে.
অর্ডারে লেখা ছিল না পাবলিকেশন?
না সরি, পাবলিকেশনে লেখা ছিল কি
in that publication it was written that the buyer, the purchaser have to purchase the property on his own risk.
I am showing you now. You have mentioned about the purchase of land by the plaintiffs and construction thereon. In this regard, I am showing you the original of a document disclosed as PD1 to PD1 Judge's Brief of Documents, pages 1 to 31. Kindly take a look at the same and tell my lord what is this document all about.
आपने मेंशन किया है कि प्लेंटिफ ने एक जमीन खरीदा है और उसमें कंस्ट्रक्शन शुरू किया है, ठीक है? तो इस डॉक्यूमेंट को देखिए और बोलिए क्या वही डॉक्यूमेंट है ये परचेज वाला?
ये डीड ऑफ एक्सचेंज है, मतलब जो जमीन खरीदे थे उसके बदले.
दिस इज अ डीड ऑफ एक्सचेंज.
Mr. Ghosh, PD1 is not mentioned.
Oh, sorry, it's mentioned PD, the first PD. I'm sorry, the PD1 na kore first document.
I am giving leave.
My lord, I'll correct it.
Correct it
I'll
so
correct
that it.
Yes. So let it go as PD1. I will
correct it.
do that PD1 too.
डीड ऑफ एक्सचेंज.
ये डीड ऑफ एक्सचेंज है.
दिस इज अ डीड ऑफ एक्सचेंज. बोलिए.
ये डीड ऑफ एक्सचेंज जो हम जो उनसे जमीन खरीदा, जो कंपनी जो जमीन खरीदी है, इसके बदले हम लोग जो वेंडर है उसको 3 फ्लैट हमारी दूसरी बिल्डिंग जो हम लोग बनाए हैं वहां पे दिए हैं.
as we purchased the land, we have given the party, the vendor, we have given the party 3 flats on another site.
Nearby,
3 flats on another construction site of us.
3 ready flat.
3 ready flats. And different another construction.
Same locality.
Location?
Same locality.
On the same location.
Whose signatures appear at the end of this document?
इस डॉक्यूमेंट की आखिरी पन्ने में किसका सिग्नेचर है बताइए?
इसमें सिग्नेचर जो परचेजर है वो मेरा सिग्नेचर है.
Yes.
इसमें परचेजर जो मैं जे कंपनी के ब्याप में मैंने साइन किया है. आई एम द परचेजर.
This is my signature on behalf of the company. I have signed this. I have signed. Yeah.
And other signatures are of the vendor.
And there are other signatures. Signatures of the signature of the vendors. There are total of 5 signatures.
5 vendor signatures.
5 signatures of the vendors.
How have you obtained this document?
ये डॉक्यूमेंट आपको कैसे मिला?
This is a certified copy. I have requested my advocate के मैंने बोला कि ये certified copy हमको चाहिए.
This is the certified copy of the document. I asked for this document from to my advocate.
From my advocate. Are the contents of this document true and correct?
क्या इस डॉक्यूमेंट का जो कंटेंट्स है वो सच और सही है?
जी बिल्कुल सही है.
Yes.
But may I tender this document to him? May I tender this document? Certified copy in any event.
Exhibit 1.
Exhibit A. Document. এটা কোনটা? এটা আমরা করেছি 2019. You had mentioned that the defendants were disturbing your construction work in the suit premises, in the property. Full stop. Did the plaintiffs take any steps?
आपने कहा है कि डिफेंडेंट
In this regard.
आपने कहा है कि डिफेंडेंट्स आपकी कंस्ट्रक्शन साइट में आके डिस्टरबेंस क्रिएट कर रहे थे. क्या इस मामले में प्लेंटिफ कंपनी ने कोई एक्शन लिया था उनके अगेंस्ट?
हाँ मैंने लोकल थाना में कंप्लेन किए.
We have lodged a complaint in the local police station.
Did you file any civil proceedings in this regard?
क्या आपने कोई सिविल प्रोसीडिंग्स किया था इस सिलसिले में?
मैंने केस फाइल किया विधाननगर कोर्ट में.
We have filed a suit in Vidhannagar court.
I am showing you the original of a document appearing as PD2, page 32 to 36 of the judge's brief of documents. Kindly take a look at the same and tell my lord what is this document all about. That one.
इस डॉक्यूमेंट को देखिए और माय लॉर्ड को बोलिए ये डॉक्यूमेंट किस बारे में है?
क्या है?
ये डॉक्यूमेंट हम जो सूट फाइल किए थे उसका ऑर्डर का सर्टिफाइड कॉपी है.
This is a certified copy of the order. This is a certified copy of the order of the suit which we have filed in Vidhannagar.
Yes.
In Vidhannagar court.
How have you obtained this document?
ये डॉक्यूमेंट आपको कैसे मिला?
I have requested my advocate के मैंने बोला कि ये चाहिए तो उन्होंने मेरे लिए रिक्विजिट फीस जमा करके उन्हें मुझे दिया ये.
I have asked for this document from my advocate and he obtained that.
After
I had
depositing.
requested my learned advocate to obtain the certified copy. My advocate has obtained the same.
My lord, obliged. Are the contents of this document true and correct?
क्या इस डॉक्यूमेंट का जो कंटेंट्स है वो सच और सही है?
हाँ इस डॉक्यूमेंट का कंटेंट सही है. इस डॉक्यूमेंट से हम लोग को ऑर्डर मिला कि वो जो डिफेंड
सच और सही है?
ये बिल्कुल सही.
Yes, the contents of the document.
Order of court may it be marked as an exhibit.
Exhibit B.
B. এটা 14 সূত্র তো in reply in response to your action of filing civil and criminal proceedings against the defendants, did the defendants take any action against the plaintiffs?
आपने ये जो पुलिस कंप्लेन किया और केस फाइल किया, इसके अगेंस्ट डिफेंडेंट्स ने क्या कोई स्टेप लिया?
डिफेंडेंट वो मेरे को डिस्टर्ब करते रहे और वो लोग फिर एक काउंटर सूट भी फाइल किए.
The defendants kept on disturbing the plaintiffs and they also filed a different suit.
डिफरेंट सूट
कहाँ पर?
विधाननगर कोर्ट.
At Bidhannagar court.
बट ये जो जमीन है दैट वाज ओन्ड बाय द कंपनी, बट उस
But the land was owned by the company.
एंड इन दैट सूट वो मेरे को फर्स्ट पार्टी में बना के और इस सूट को कोई मेंशन नहीं किया. जो एग्जिस्टिंग जो सूट चल रहा था उसको मेंशन नहीं किया उन्होंने.
In that proceeding they paid first party and क्या मेंशन नहीं किया?
ऑलरेडी
And had not mentioned about the pendency of the previous suit in which I have obtained order.
I'm showing you the original of a document, copy whereof has been disclosed as PD3, pages 37 to 41 of the judge's brief of documents. Kindly take a look at the same and tell my lord what this document is all about.
डॉक्यूमेंट को देखिए और माय लॉर्ड को बोलिए ये क्या है.
ये डिफेंडेंट ने जो सूट फाइल किया था उसकी ये सर्टिफाइड कॉपी है.
This is a certified copy of the order of the case that was filed by the defendants.
How have you obtained this document?
ये डॉक्यूमेंट आपको कैसे मिला?
ये मैंने मेरे एडवोकेट को रिक्वेस्ट किया और उन्होंने मुझे ये
I
सर्टिफाइड.
requested my advocate for this document and he obtained this document and gave it to me.
Witness shown the last page of this document.
Last page.
No, last but one page of this document. Ordered বলে লেখা আছে দেখুন.
Yes, this one.
Ordered. Last but one page. Can you tell my lord as to what was the interim order that was passed against the plaintiffs?
Plaintiff के against क्या interim order पास हुआ था? आप बता सकते हैं?
Plaintiff number 2.
Against plaintiff number 2 के against क्या interim order पास किया गया था?
इस ऑर्डर में दिया गया कि नेचर एंड कैरेक्टर ऑफ द लैंड को चेंज नहीं करना है.
In this order, it is written that nature and character. It was written that the nature and character of the land cannot or could not be changed
by way of encroaching southwestern bank.
by way of encroaching southwestern bank. Western bank.
Lord, may this be tendered and marked as an exhibit?
Exhibit C.
C.
Certified copy, na?
Yes, yes. But may these publications that have happened, now I'm going to try and prove the publications. But the translations, original translations possibly are with your lordship's plaint. So I'll have to possibly, yes, my lord, possibly, my lord, subject to correction, my lord. Page, my lord, if your lordship sees.
Yes.
Those are the
Xerox copy.
Xerox?
Go through.
Oh, my lord.
See the original print in the original.
Page, my lord.
It's also Xerox 71A.
Original টা কোথায়?
Please go through.
My lord, may I go? 72.
71A.
Original টা কোথায়?
No reason. Signature আছে, black signature comes. 64
না দেখি
नहीं black signature साइन किया
साइन किया है, ये ओरिजिनल है कि नहीं कैसे पता? तो फिर ओरिजिनल कहाँ है? वही तो हम पूछे हैं शांतनु. जज साहब तो ठीक ही पकड़े हैं. দুটো কেন নোটিশ সাথে নোটিশের সাথে লাগিয়েছিল তাহলে একটা অরিজিনাল একটা ইয়ে হবে এটা অরিজিনাল well, I'm the this one which is well, kindly takes page 71A well, is appended to the notice. Well, that may be a Xerox, but the original with the the copy with the actual publication. Well, I really don't know. Well, my instructions are possibly that might have been signed in black, but I really don't know. Well, 64.
Right, but it is the Xerox.
64.
Okay, whatever it may be, you do one thing. You exhibit the original.
Subject to production of the.
You do one thing. Let the original paper.
Yes, my lord.
Be marked.
Yes, yes.
Along with this as
Correct.
identification.
Obliged. Because that is there, and it's your lordship's department that has made that.
That is the original, and this is
the original,
only for
and
the
this is
reference
a
of
translation. Yes, my lord. Now, you have mentioned about a publication in a newspaper by the defendants. In this regard, I am showing you an original document disclosed as PD4, pages 42 and 43 of the judge's brief of documents, along with which in 42 and 43 of the judge's brief of documents. Kindly take a look at the same and tell my lord what are these documents. It judge's brief of document 43 टा ओखाने
अपने डिफेंडेंट के द्वारा एक पेपर पब्लिकेशन के बारे में बताया ये डॉक्यूमेंट देखिए और बोलिए क्या ये वही पेपर पब्लिकेशन है
This and another document page 43 টাও দেখাবে সঙ্গে সঙ্গে 42 টা ওটা আর 43 টা
ना एटे
ये भी देखिए
ये तो है ही सॉरी जी ये वही पेपर है
yes
इसमें
yes this is the same paper this is the paper this is the publication बोलिए
ये वही पेपर है जिसमें जो डिफेंडेंट है उन्होंने पब्लिश कोर्ट के ऑर्डर को दूसरे तरीके से इन्होंने पब्लिश किया है जो कंटेंट सही नहीं है
yes this is the paper publication which the defendant has published fabricating the court order defendants has published
misrepresenting, not fabricating, misrepresenting.
Thank you, sir.
And page 43?
Page 43?
ये पेज 43 उसी ये ऑर्डर का इसका ट्रांसलेटेड है हिंदी इंग्लिश में और ये जो भी मैटर है ये दिस इज ये फैक्ट नहीं है
In page 43 this is the English translation of the same paper publication but this is not fact what has written there is not a fact
How have you obtained the original newspaper copy whereof is appearing at page 42?
आपको ये ओरिजिनल न्यूज़पेपर कैसे मिला
हम वहाँ लोकल मार्केट में ही हम कंस्ट्रक्शन जो कर रहे हैं वो लोकल एरिया में वहीं पे एक ही जगह पे सब बिल्डिंग बना रहे हैं तो मेरे को सब जानते हैं वहाँ पे तो मेरे जो परिचित है फ्रेंड रिलेटिव उन्होंने मुझे फोन किया कि पेपर में ऐसा ऐसा पब्लिकेशन आया है
where we are making our where we are doing our constructions people know us a person of my acquaintance
where my construction was going on at that place all the persons known to me and accordingly the persons has informed me with regard to the such publication thereafter I
purchased
through the said publication
I purchased the same
and I purchased the paper
Are the contents of these documents at page the original of these documents at page 42 and 43 true and correct?
Page 42 और 43 में जो डॉक्यूमेंट अपीयर कर रहा है क्या वो ट्रू एंड करेक्ट है उसका कंटेंट्स सच और सही है
ना उसका कंटेंट तो सच और सही नहीं है ना
contents are not true.
Okay. And may these be tendered and marked as an exhibit.
Which, no, see, which portion he had identifying that you
ওইটা
take
কাটা।
and
May
put the
may I ask a question? Can you identify and encircle the portion in the original publication which according to you contains defamatory materials against the plaintiffs in red ink?
जो पब्लिकेशन है ना, जो डिफेमेटरी पब्लिकेशन है उसको रेडिंग से सर्कल कीजिए।
इसमें जो है सब डिफेमेटरी है।
से सर्कल
There are a lot of other things in the paper also.
कौन वाला पोर्शन आपको जो लगा गलत है आपके अगेंस्ट में है?
ও বুঝতে পারছি না, একটু বুঝিয়ে দাও
पूरे
যে
पब्लिकेशन
অ্যাডটা
से आप
পুরো
सर्कल
অ্যাডটা,
कीजिए।
কারণ অন্যান্য অ্যাডও তো আছে, যে অ্যাডটা বলছে
ओके, आपका ऐड है ये विटनेस encircled
portion of the said paper publication in red ink. My lord, let this marked as exhibit D and D1 respectively.
The red portion mark of the paper publication D1, D and the translated copy D1.
After the publication was made, now after the publication came to the notice of the plaintiffs, did the plaintiffs object to the same? Now, what did the plaintiffs do?
ये पब्लिकेशन प्लेंटिफ देखने के बाद प्लेंटिफ ने क्या किया?
प्लेंटिफ्स
ने क्या किया?
हम हमारे एडवोकेट से कंसल्ट किए।
We consulted our advocate.
उन्होंने गाइड किया कि एक जो उनका जो एडवोकेट जो ये पब्लिश किया द डिफेंडेंट का जो एडवोकेट जो पब्लिश किया उनको एक लेटर दिया जाए टू विड्रॉ दिस नोटिस।
And our advocate guided us to send a letter to the advocate, guided us to send a letter to the advocate of the defendants to withdraw this paper publication.
I am now showing you the original of a document appearing as PD5, page 44 to 50 of the judge's brief of documents. Kindly take a look at the same and tell my lord, what is this document all about?
इस डॉक्यूमेंट को देखिए और बोलिए माय लॉर्ड को कि ये डॉक्यूमेंट किस बारे में है।
ये लेटर हमारे एडवोकेट ने डिफेंडेंट का एडवोकेट को भेजा था।
This is the letter which was sent by our advocate to the advocate of the defendant. Which was sent by our advocate to the advocate of the defendant.
Whose signature appears at the bottom of this document?
This document
At the end of this document?
अंत में किसका सिग्नेचर है?
हमारे एडवोकेट मिस्टर प्रशांतो भौमिक, उन्होंने ये लेटर इशू किया था, उनका सिग्नेचर है।
The letter was issued by our advocate, namely Mr. Prashanto Bhomik. At the end of the document, his signature appears. Mr. Prashanto Bhomik. At the end of the document, his signature appears.
Who instructed Mr. Prashanto Bhomik to issue this letter?
Mr. Prashanto Bhomik को किसने ये लेटर इशू करने के लिए कहा था?
मैंने बोला था कि उन्होंने कि ये इसका क्या किया जाए जो पेपर में पब्लिकेशन आया है, तो उन्होंने कहा कि लेटर इशू।
I instructed Mr. Prashanto Bhomik to issue this letter.
Are the contents of this document true and correct?
क्या इस डॉक्यूमेंट का जो कंटेंट्स है वो सच और सही है?
जी बिल्कुल सही।
Yes, the contents are true and correct.
Did the defendants receive the legal notice?
Defendants
dated 17th August 2021.
डिफेंडेंट ने क्या ये लेटर
डिफेंडेंट्स
ने क्या ये लेटर एक्सेप्ट किया था?
हाँ, उन्होंने ये लेटर एक्सेप्ट किया था। ये ट्रैक कंसाइनमेंट का कॉपी है हमारे पास।
Yes, they have accepted the letter and there is a track consignment report with us to confirm that.
ये लेटर दोनों को दिया गया है, उनका एडवोकेट को भी और उनको पर्सनली भी
This
भेजा।
letter was sent both to their advocate and to them also.
And both were received.
And this was received by both of them. And this letter was received by both of them.
May I tender this to be marked as an exhibit?
E collectively.
E collectively. You had mentioned you have mentioned in course of your earlier deposition that because of this defamatory publication, you had suffered losses. Can you explain in what manner you claim that you have suffered losses?
आपने ये कहा है ये जो पब्लिकेशन है जिसके चलते आप लोगों ने बहुत लॉसेस फेस किए हैं, कैसे और क्या लॉस फेस किए हैं, क्या आप बता सकते हैं?
हम लोग वहाँ एक लोकल मार्केट में एक स्मॉल एरिया में ही सब बिल्डिंग बना रहे हैं, जितने भी कंस्ट्रक्शन कर रहे हैं सिंस 2008.
Since 2008 we are making all the construction works in a small area,
particular locality.
small area on a particular location. बोलिए.
तो इस पब्लिकेशन के कारण हमारी जो बिल्डिंग बन रही थी तो वहाँ पे हमारे जो कुछ फ्लैट्स बुक हुए थे वो बुकिंग नहीं, कुछ एक दो बुकिंग कैंसिल हुई.
Because of this publication, the one or two bookings that flat bookings that were made was cancelled.
हमारे दूसरे प्रोजेक्ट भी वहीं पे ही है.
Our projects are also
Our other
projects are also in the same locality.
उसमें भी हमको बेचने में दिक्कत है. I face difficulties.
We face difficulty to sell those flats also.
बाद में ऐसा हो गया कि मतलब बिल्डिंग कंप्लीट होने के बाद ही बेच पाएंगे हम लोग. बीच में कोई बुकिंग वगैरह अंडर कंस्ट्रक्शन स्टेज में हमारा फ्लैट बिकना बंद हो गया था.
There was a time when there was no booking and
During the construction,
and
there was no flat booking, and the purchaser used to tell us that they will purchase the flat only after completion of the construction work.
हाँ, इससे हमारा काफी लॉस हुआ सर. मतलब जो कंस्ट्रक्शन करने के लिए तो इसकी इंडस्ट्री में कैपिटल इंटेंसिव है, तो जो बुकिंग अमाउंट से तो हम लोग कंस्ट्रक्शन कंप्लीट कर पाते हैं. तो हम एक होल्ड पोजीशन में आ गए सर.
we came to a halt position because with the booking amount we complete the construction works.
No. We have faced several financial difficulties as only after getting the booking amount we used to complete the construction work.
In the, my lord, I will, my lord, seek your lordship's leave to show my witness 3 more documents which have not been disclosed.
What are the documents?
My lord, these are 2 letters, my lord, from, my lord, the intending purchasers, which, my lord, we have traced out, which was not disclosed earlier. He has mentioned it in the plaint, but, my lord, the documents were not disclosed. And this is the annual report, my lord, the balance sheet of the company at that point. This is, my lord, a government document, my lord. It's a statutory document, which will show, my lord, that the turnover was very good. And, my lord, thereafter, my lord, because of this, my lord, if your lordship, I'll make a supplementary judge's brief of documents and file it with your lordship's court.
Application in file.
A non-commercial suit. I'll undertake, my lord, kindly record, my lord, I'll undertake to file a supplementary paper book, my lord, including all this. I am now showing you 2 further original documents dated 29th August 2021 and 10th September 2021. Kindly take a look at these and tell my lord what are these documents all about.
ये 2 डॉक्यूमेंट देखिए और माय लॉर्ड को बोलिए ये किस बारे में है.
ये वो कैंसिलेशन लेटर है जो हम लोग को रिसीव हुआ, पार्टी जो फ्लैट कैंसिल किया.
These are the cancellation letters that were given by the parties who cancelled the bookings.
Do both these letters relate to the same property or different properties that the plaintiffs were promoting?
क्या ये 2 लेटर वो सेम प्रॉपर्टी के लिए है जिसमें बुकिंग कैंसिल या डिफरेंट प्रॉपर्टी के लिए है जिसमें बुकिंग कैंसिल हुआ है?
एक लेटर तो उस प्रॉपर्टी के लिए, सेम प्रॉपर्टी के लिए।
One letter is about the same property.
डेट टेक टू बोलिए ना, नाल शो बोलिए जब।
One letter dated
Dated 29th of August
29th
2021.
August 2021 is about the same property.
जो कैंसिल हुआ था। एंड और एक और लेटर है वो मेरा दूसरा प्रॉपर्टी का है, वो सेम लोकेलिटी ले।
And another letter dated
10th of
10
September
September
21।
2021.
ये दूसरा प्रॉपर्टी का है, दूसरा फ्लैट का है, बिल्डिंग में, वो सेम लोकेलिटी में काम कर रहा
Is about the cancellation of the booking of flat on different property but at the same location.
Same locality, not location, same locality. How has the plaintiffs received these documents?
Plaintiff को ये documents कैसे मिला?
ये तो जो बायर कैंसिल किया वो उनसे में हमको मिला कि वो फाइनली जो बायर, जो प्रोस्पेक्टिव बायर था, उन्होंने जो बुकिंग किया था वो कैंसिल किए, फाइनली ये
The prospective buyers sent this letter to the plaintiff.
Whose signatures appear in these documents?
किसका signature है इन document के अंत पे?
जो प्रोस्पेक्टिव बायर था उनका।
The signatures of the prospective buyers appear on the end of the document.
Please state their names for the record.
क्या नाम है उन लोगों का, बोलिए?
मिस्टर दिलीप मुल्ला।
On the letter dated 29th August 2021, the signature of Mr. Dilip
मुल्ला।
Mulla appears. Dilip Mulla.
MULA
MULA Mulla. MULA appears at the end of the document, and
राजेश कुमार बुतुरिया।
on the document dated 10th September 2021, Rajesh Kumar
Bhuturia.
The signature of Mr. Rajesh Kumar Bhuturia appears at the end of Bhuturia.
BHUTORIA.
Bhuturia appears at the end of the document.
Has the plaintiffs received these letters in the usual course of its business?
क्या आप ये लेटर यूजुअल कोर्स ऑफ बिजनेस में रिसीव किया है?
ना, जनरली हमारा तो कोई बुकिंग कैंसिल होता नहीं है। हमको लग रहा है कि जो मेरा पेपर पब्लिकेशन के कारण जो हुआ है उसके कारण ये बुकिंग कैंसिल हुआ है। इन जनरल हमारा कोई
In general, our bookings are not get cancelled.
Never get cancelled.
Never get cancelled. That is why we feel that this is because of the defamatory publication
made by the defendant.
Made by the defendant.
May these be tendered and marked as an exhibit.
Collectively must perform.
দেখি হবে ছেড়ে দিলে দরকার annual return দরকার না ছেড়ে দিন Lord, that would be all. Oh, plainটা দেখাবো, sorry, I'm so sorry, just I'll show you the plain. Witness shown the plaint and in particular page 19 thereof, 18 and 19 thereof, whose signature appears at page 18 and 19 of this plaint. 18 and 19 of this plaint.
प्लेंट में 18 और 19 पेज में किसका सिग्नेचर है बताइए?
ये मैंने सेंड किया है, संजय कंसल।
This is my signature, Sanjay Kansal.
These are my signatures.
These are my signature. Who has drafted this plaint?
ये प्लेंट किसने ड्राफ्ट किया है?
My advocate has drafted this plaint.
My advocate has drafted this plaint.
Under whose instruction has your advocate drafted this plaint?
किसकी इंस्ट्रक्शन पर आपके एडवोकेट ने ये प्लेंट ड्राफ्ट किया है?
ये मैंने रिक्वेस्ट किया था उनको।
I requested him.
Are the contents of this plaint true and correct?
क्या इस प्लेंट का जो कंटेंट्स है वो सच और सही है?
जी बिल्कुल सही है।
Yes.
Kindly come to kindly come to page 17 of the plaint and tell my lord what the plaintiffs have prayed for.
Not required.
No. Lord, may I file that supplementary judges before documents and kindly fixes the date? I'll come 10 minutes of your lordship's time to argue.
ठीक है, उतर जाइए।
And my lord, if I can find that original, my lord, translation, I will also include that in the supplementary judgment.
So and so appearing for the plaintiff. Plaintiff witness is present. During the examination of the plaintiff witness, how many documents?
My lord.
A to F. And documents were exhibited being exhibit A to exhibit F. Full stop. Evidence of the plaintiff witness is closed. Full stop. Counsel for the plaintiff has adduced two additional document which have been marked exhibit, but the counsel for the plaintiff prays for filing the supplementary judgment document and enclosing the same. Considering the submission made by the counsel for the plaintiff, leave is granted to file supplementary affidavit within a week. Full stop. Counsel for the plaintiff submitted he will not adduce any further evidence. Evidence on the side of the witness is on the side of the plaintiff is closed. Let the matter appear. Any date? Argument. 31st July at 1 p.m. for argument.
Commercial list, item number 11.
Your Lordship,
My lord,
I'm
for
for
the
the
plaintiff. This is my application
Your
before
Lordship, I'm for the defendants. I'm praying for not today. The learned counsel for the appearing in this matter has left the court premises on an urgent basis.
Knowing that the suit case is pending, he has left the court.
It was an urgent
Judgment
matter, my lord.
You are for the plaintiff.
I'm for the defendants.
Have you filed the this is an application for?
It's an application under Order 12, Rule 6, my lord.
So, have you received the copy?
Yes, my lord. It has been served, my lord.
They have filed the affidavit.
Well, I'm praying for not today.
Why? Now, if you file the affidavit, then the direction will be given. If you will not file the affidavit,
They have not filed. They have not.
The first move.
Yes.
Okay, you file the affidavit.
Okay, man.
So and so appearing for the plaintiff, so and so appearing for the defendant. Full stop. Plaintiff has filed an application being GA3 of 2024. Is it commercial or non-commercial?
Commercial.
Why GA3? Not com, it has not been converted. GA-com 3 of 2024. Under Order 12, Rule 6 of the Code of Civil Procedure, praying for judgment upon admission. Full stop. Counsel for the defendant prays for time to file affidavit in opposition. Let affidavit in opposition be filed within 2 weeks.
2 weeks.
2 weeks, comma, reply if any they are to be filed within a week thereafter. Full stop.
Service has been
List
affidavit of service. Affidavit of service.
List the matter on the commercial, na? On 6th of August 2024. Affidavit service filed by the plaintiff be kept with the record. Next.
Number 12.
Obliged. My lord, Mr. Ayan Dattu is appearing. He is coming, my lord.
What is the application? What is the application for?
Application. Application.
Who has filed this application? Defendant. You are appearing for?
I'm for the plaintiff.
Who is for the defendant?
My senior is Jayanto Sengupta.
You are for the defendant.
I'm for the plaintiff, your lord.
The defendant.
Okay,
This is my application for it.
In fact, I'm being led by Mr. Ramalat.
Yes, Mr. Ray.
Well, my applications, if they want to file any affidavit, well and good, or else I can argue.
I'll file an affidavit.
File affidavit.
I thought so, Malat. But he has to, Malat.
After 120 days. Mr. Roy.
Not your lordship.
After
Malat,
120 days.
I have another application, Malat, which is the most interesting application.
Yes.
Malat, I have a better application. I have asked for rejection. Writ of summons extended by the master again here, Malat. I want to argue that point before your lordship, Malat, in full force, Malat.
Census and suffering for the plaintiff, census and suffering for the defendant. defendant had filed an application being GA Com 2 of 2024, praying for extension of time to file return statement. Counsel for the plaintiff.
And my GA3, my lord. I have a GA3 also.
Your lordship is giving direction for affidavits in both the GAs.
Where is
Because
GA3
is there, your lordship.
GA3 is for
Order 7 Rule 11.
For dismissal, my lord.
For dismissal of the plaintiff.
The defendant has also filed an application being GA3 of 2024, praying for rejection of plaint. Full list of counsel for the plaintiff prays for time to file affidavit in opposition in respect of both the applications.
Your lordship, may I file the opposition in the Order 7 Rule 11 first? Because if your lordship decides.
Okay, file both.
Very well. Because if your lordship decides Order 7 Rule 11 in their
I
favor.
will take both. If the order Rule 11 they succeed, the question of does not arise. If they will fail, then they have to satisfy with regard to the extension.
Absolutely, my lord.
And he
But
has
we
given
will-
the
we will also
Mr. Roy
follow-
has given challenge to you.
My lord, at the end of the day, my lord, we always catch hold of the straw even when we are drowning, my lord.
That is the advocacy.
Grateful, my lord.
And now I am under threat.
Press for trying to file affidavit in both the applications. Let affidavit and opposition be filed within 2 weeks or 3 weeks.
Your lordship, 3 weeks.
3 weeks. Reply, if any, there to be filed within 2 weeks.
2 weeks, my lord.
1 week.
1 week, my lord, not a problem, my lord. This is a very small application, my lord.
Within 1 week. List the matter on 20th August 2020.
Very grateful. Very grateful, my lord.
Grateful.
Next.
Number 13.
I'm appearing for the plaintiff.
Yes.
My lord, I'm appearing for the respondents
paying
number
for-
2 and 5.
I'm playing for, my lord, substituted service 2 and 5 has appeared. So, my lord, it's not necessary anymore for me to make a player for substituted service. But if your lordship, my lord, straightway comes to the report, which is
What
there,
you prayed for?
my lord, for substituted service, my lord, because
There is no objection.
my lord, there is, my lord, for 2 and 5 there is no more. Now, my lord, kindly comes to page 82.
82.
Lordship.
Yes.
My lord, that's the report given by, my lord, the sheriff. My lord, your lordship sees 2 has been served and 5 has been served. My lord, I am praying for an order upon the defendant numbers 1, 3, and 4.
1 found no existence of such company.
Yes.
And the person having no such name.
Yes.
Then 3 found no existence. Same.
Same endorsements.
5 also same.
Yes. No. 1, 3, and 4.
1, 3, and 4.
Yes.
Acha, 4 and 5 service.
5 is, yeah.
Yes.
So 1 and 2 and 5 are appearing.
Yes.
Yes.
2 and 5, 1, 3, and 4.
1, 3, and 4.
Yes. Where is the office?
My lord, the
The
office.
address mentioned.
Lordship, the cost title, your lordship, it's at Benting Street.
Benting Street, that is there only.
Within. My lord, 3 is
Mukherjee Road.
also, that is the same. My lord,
Or in Calcutta only.
all are in Calcutta. 1, 3, and 4. Yes, all are in Calcutta, same address.
Same address.
Well, in fact, they had appeared during the ad interim stage. After that, they have not appeared, they have not filed their affidavit, nothing. Even the defendant numbers 2 and 5 has not filed their affidavit in opposition.
Which paper publication?
Yes, my lord.
Have you given the name?
Yes, my lord. If your lordship, my lord, comes to the prayer, my lord, at page
In this daily
13,
newspaper.
my lord, B, my lord, vernacular, 1 vernacular and 1 English, local English, my lord, and local vernacular.
So and so appearing for the plaintiff. So and so appearing for the defendant number 2 and 5.
2 and 5.
2 and 5. Full stop. Plaintiff has filed the present application being GA Com 3 of 2024. Praying for an order of substitute service by way of publication of notice. Full stop. After filing of the suit, the plaintiff has taken appropriate steps for issuance of writ of summons, but the writ of summons could not be served either through the sheriff of this court or through the speed postal services, and there is a report that inverted comma found no existence of such company and persons having no such name at the address. Full stop. The postal services has been written unserved with the endorsement unclaimed. Considering the submission made by the counsel for the plaintiff, peruse the service report. The plaintiff is granted leave to publish the notice of writ of summons for cause service upon the defendant number 1, 3 and 4 by making publication in the English daily newspaper. The statements
and the Bengali part of the state
and in the Bengali newspaper.
Doinik states.
Take the name. Full stop. The full stop. The plaintiff is directed to take appropriate steps within a week from date. GA number disposed of.
Great. My lord, with respect to 2 and 5, we have no objections. Okay. We have no objections. All right. My client is no more using the mark and we have no objections.
File an application to
You
that
do
effect
one
then.
thing. Next date you come with short affidavit.
Yes.
So
All
record and I will dispose of then your name can be deleted.
Can
You
be struck
file an affidavit along with the deletion of the name that can be done.
Can be struck off.
Much obliged.
My lord, may I file the affidavit of service?
Affidavit service is kept.
Grateful.
Next.
My lord, I am appearing in the virtual mode. My
Yes,
lord,
yes,
this
defendant.
matter has come before your lordship at the instance of the office report. The plaint was defective. Now all the defects have been removed, my lord, in
Correct.
terms of the last order. And my lord, summons may be directed to be issued so that I can serve my learned friend.
That lord, he has to take.
You have to file the writ of summons.
My lord, I have already filed.
Have you lodged?
My lord, I have already lost. Department is saying that since it is delayed, so you need to get the order from the court.
The same prayer that I made in the morning for another suit.
So you have to file an application.
My lord,
Thanks.
my lord,
Verbally, with regard to the issuance of writ of summons, it cannot be either. First, you have to file before the master. Master is no authority. Then the master will refer here, or you have to file here.
my lords. My lord, one humble submission. My lord, if the earlier plaint admission order was the plaint is admitted subject to the scrutiny by the department. So
Correct.
if the plaint is deemed to be admitted by today's order, then I will get the 14 days time to serve the summons.
When the plaint was admitted?
My lord, plaint was admitted earlier, but scrutiny has been done by pursuance of your lordship's order.
So when the scrutiny was completed?
My lord, scrutiny was completed 1 week before.
So you file an application before the master.
My lords.
You take a master summon before the master. Master will take pass appropriate order.
My lords, my lords.
And if you are agreed with the master's order, then this court cannot give advice what is to be done.
My lords, my lords.
So and so suffering for the plaintiff. You are for the defendant number.
The defendants.
All
defendants. State.
So and suffering for the defendants. Full stop. Counsel for the plaintiff submits that, and the plaintiff has already cured the defects and will take appropriate step for issuance of writ of summons. In view of the submission made by the counsel for the plaintiff, the case is adjourned.
Grateful.
Great.
Item number 15 is my application. Here, my lord, lordship is pleased to pass an interim order on 29th April 2024 and injuncting the defendant from operating its bank account without leaving apart a sum of 64 lakh. My lord, I have served, my lord. What had
My
happened
lord,
is
I'm
my
appearing on
affidavit-
behalf of the defendant. Mr. Asif Hussain is appearing online, my lord.
Yes, what is that instruction?
My lord, to file WS, my lord.
You will file W.
But I do not know whether the writ of summons has been served, but they can file an opposition to my application. And my lord, may I also point out one thing, my lord, if your lordship sees my affidavit of service, may I hand up? This is this bulky because all
My lord,
the physical delivery.
Yes, Mr. Asif.
yes, my lord, I am appearing for the defendant, my lord. My lord,
All defendants, both defendants.
Only one
Only
defendant.
one
only
defendant.
one defendant, sole defendant. My lord, I want to use an affidavit against the application filed by them because the application is actually in nature of Order 38 Rule 5. And the
Correct.
second thing, my lord, my instructions are there is an arbitration clause. Parties have entered into an agreement, the transactions arising out from a contract where the parties have
Take
agreed to
steps,
resolve
take
their.
steps. The court will decide.
Yes, my lord, my lord. Yes, my
But
lord.
may I only point out one thing, my lord, in my affidavit of service, lordship will notice that, my lord, the time and again it was attempted to be delivered to the respective addresses of the defendant now appearing. May I only, my lord, request my learned senior friend to indicate which address should I serve, because they have been served by way of email. So possibly, my lord, they are appearing on the basis of the email service.
What is the address?
So kindly, my lord, furnish us the address so that, my lord,
My lord, so writ of summons we have been served sometimes in June. So we served entered appearance thereafter. So we will inform. We will.
all refused, all returned.
Okay.
No, no.
They are appearing now, whatever the communication you made with
Very well.
No, writ of summons were served on 14th June.
so and so appearing for the plaintiff, so and so appearing for the defendant. Full stop. The plaintiff has filed the affidavit of service showing that the speed post cover containing the applications and the documents sent to the defendant was written unserved. Full stop. Let the same be kept with the record. Full stop. Mr. Arif Hussain,
Asif.
Asif, advocate appearing for the defendant and submits and prays for time to file affidavit in opposition in connection with GA1, GA 1 of 2024. Let affidavit in opposition be filed within 3 weeks.
Yes, my lord.
3 weeks, reply if any there to be filed within a week thereafter.
Yes.
Within a week thereafter. Full stop. Please the matter. Within a week thereafter. Counsel for the plaintiff submits that the interim order dated 29th April 2024 is going to be expired today. Expired? Already expired?
It had expired,
It's expired
on 19th July.
on 19th July
19th July.
2024 and prays for reimposition of the interim order 19th July 2024.
That's today. Yes,
It's
that's
going to be
today.
expired today and prayed for extension of the interim order. Concerning the submission made by the counsel for the respective parties, interim order dated 29th April 2024 is extended till 23rd August 2024. Release the matter on 23rd August 2024.
But only one thing, but apart from this application GA1, there is another application which is GA2, which I am told is lying in your lordship's records, which is in court, but it is not listed. But that is an application for judgment upon admission. I have served my learned friend as well. But if it's a judgment upon admission application, affidavit has to be.
We have not been served any GA2, any application.
We'll come back then, my lord. We'll come back. I have the service, but we'll come back in due course.
Yes, next.
Great.
My lord, I appear for the petitioner. My lord, in this matter, I am led by Mr. Abrojit Mitro. He has some personal.
Who?
Mr. Abrojit Mitro.
Yes, and morning somebody has mentioned.
My lord, he has some personal difficulty today. My lord, may I humbly pray for an adjournment till Monday?
My lord, I appeal for the defendant number 2. There is an application taken out by the defendant number 2, being IGA number 2, which is in nature of Section 8 under the Arbitration Act, because the disputes are governed. But if on Monday, my lord, both applications could appear.
Monday?
Or whenever your lordship is keeping, my lord, both the applications.
What is the GA1?
GA1 is the interlocutory application of the plaintiff. GA2 is the, my lord, defendant number 2's application for, my lord, referring the disputes to arbitration.
That is served?
Yes.
Lord, sir.
Yes. So whenever your lordship is keeping, my lord, both may happen.
I'm going for defendant number 1.
So appearing for the plaintiff. Mr. Gupta, you are appearing for?
I'm for the defendant number 2.
So appearing for the plaintiff, so appearing for the defendant number 1, and so appearing for the defendant number 2. Full stop. Counsel for the defendant number submit that the defendant number 2 has filed an application being GA2
Yes.
of 2024 under section 8 of the Arbitration and Cancellation Act for referring the matter to the referring the parties to the arbitration. But the said applicant, the J2 is not listed today.
It's not listed.
But the said matter is not listed today. Considering the submission made by the counsel for the respective parties, let the GA1 of 2024 along with GA2 of 2024 be listed before this court on 23rd. 23rd. Next. Fix it.
Lord, I appear on behalf of the respondent.
Yes.
Lord, I mentioned when the matter was mentioned by Mr. Bhattacharya. We are seeking time on the ground of.
Which was the other side?
Mr. Anuj Singh was there in the morning.
He was there.
Lord, I am informed that he's on legs before
Okay, no
4:30.
problem. No problem. It is fixed on the 25th also. It is fixed.
Yes, my lord. It has been already fixed on the 25th.
So appearing for the plaintiff, so appearing for the defendant. Full stop. Due to some personal difficulty of the learned senior advocate, counsel for the plaintiff / respondent, press for time. Accordingly, case adjourned. It is found that matter is already fixed on 25th of July. Let the matter appear on 25th of July at 3 p.m.
Grateful.
Next.
Item number 17 of the commercial list.
But I am appearing for the petitioner in this matter. But I'm appearing for the petitioner in this matter, my lord. This is GA number 1, where I was, my lord, praying for an ad interim order of, my lord, injunction upon the bank account of the respondent, my lord, without, my lord, leaving aside the amount which is admittedly due and payable. Now, what has transpired, my lord, this is a transaction where I had, my lord, given advance to the respondents for supply of goods. Admittedly, they have defaulted in supply of goods, and they have admitted in by way of letters as well as emails, my lord. Now, my lord, in order to demonstrate that I have given the money, my lord, although I have pleaded, my lord, that I'm enclosing the bank statement, but the bank statement has been, my lord, accidentally omitted. My lord, instead, the ledger has gone down in the place of bank statement. So I was humbly praying, my lord, if your lordship permits me to, my lord, put my lord, by a supplementary affidavit, my lord, disclosing the bank statement, and my lord, only the bank statement, so that I can demonstrate that I have given this money to the respondents, my lord.
So appearing for the plaintiff. So counsel for the plaintiff. Press for.
My lord, also, my lord, if I may just be permitted to, my lord, make one more submission. My lord, we have not also given the details of the bank account upon which we'll be seeking the order, my lord. That leave be also given to, my lord, put the particulars.
Disclose the bank statement as well as bank statement of whom? Plaintiff. Bank statement
The defendant.
of the defendant. And details of the bank of the defendant.
Yes,
only.
yes, my lord, with the bank statement where I had the transaction, my lord.
Press for leave to bank statement as well as details of the bank account of the defendant by way of supplementary affidavit. Full stop. Consider the submission made by the counsel for the plaintiff. Leave is granted to file supplementary affidavit by disclosing the bank statement as well as details of the bank account of the defendant within a week from date. Let the matter appear on 26th July 2020.
Grateful, man.
Next.
Item number 18.
Your Lordship, I am appearing for the plaintiff. I am being led by Mr. Banerjee. Your Lordship.
My lord, only one indulgence.
Yes.
I am appearing on behalf of the Priyanti Construction. First time today.
Priyanti Construction.
Yes, my
Defendant,
lord, the sole dependent. Today is the first time I am appearing. I have instructed from the coordinate advocate that in the month of January 2024, the defendant has received the summary of summons. But this one similar application has been going on before the 20th Metropolitan Magistrate under section 131. They thought the summons regarding this suit that is relating to the matter pending before the Bankshal Court under section 138.
So
That is, mistakenly.
So he has not contacted the
Yes, my lord.
advocate along with this writ of summons.
This is the communication, my lord, I have received. My lord, today only I am seeking, my lord, kindly give me an opportunity of 7 days time so that I can try my luck once.
You can try your luck. Why?
Way of an
What is the
application.
necessity of the leave? Luck can be tried anywhere, any time.
I know, my lord, 120 days has already been completed. That is the reason, my lord, I'm only beseeching, kindly give me at least 7 days time so that I can come with an application. my
That's why I'm telling why the court can give
I
time,
know, my
madam. You take your time. You take appropriate steps. Yes. What is your submission, madam?
Your Lordship, this is an undefended suit.
Undefended suit. So what is your?
Your Lordship, I am submitting my
Where
written
is
notes
Mr.
of.
Banerjee?
So, Your Lordship, he is before the division bench and I am submitting my written notes of argument. Your Lordship, I am praying to fix an next date on Monday at 1 p.m. for the argument. He will argue on the point.
So appearing for the plaintiff. Learned counsel for so appearing for the defendant. Counsel for the defendant prays for leave to take appropriate steps. Counsel for the plaintiff has filed a written notes of argument. Let the same be kept in the record. Counsel for the plaintiff submitted. The arguing counsel is arguing the matter in the other court and prays for a week time. In view of the submission made by the counsel for the plaintiff, the case is adjourned. Let the matter appear.
Your Lordship, a similar matter has been fixed for argument on 22nd of July at 1 p.m. Kindly fix this matter.
So both the matter can be completed at 1 p.m. on the same day.
Yes, Lordship.
On 22nd of February and July at 1 p.m.
Much obliged.
It is fixed. And see, 22nd July.
Much obliged.
Take a step. You take a step.
Yes, one.
Yeah, next.
Issues, item number 19. Number 19.
They have given the name. No. None appears on behalf of either the parties. No accommodation is sought for. Let the matter go out of the list.
Item number 20. Item number 20.
Same order. None appears. Go out of the list. Next.
Adjourn motion, item number 21.
Item number 21, I'm appearing, my lord, for the petitioner.
Yes.
Well, this was my application for amendment. On the last occasion, your lordship had directed affidavits to be filed. My lord, the respondent has not yet filed any affidavits. My lord, the amendment may be allowed.
Regarding the amendment, they want to rely on the certain documents which they want to annex with their rectification application. Regarding that, I have no objection. I am praying only they have to serve the complete copy of the rectification application. Accordingly, leave be given to us to file counter statement to that application.
No, if the amendment is what amendment you are sought for, Mr.
Amendment, my lord.
But, my lord, I have asked for 3 additional grounds and some documents to be relied on. My lord, if your lordship sees prayer B, grounds L and N to be added to the original grounds. My lord, this is a trademark rectification application from that, my lord.
Yes.
So 3 grounds to be added and some documents in support which I want to rely on. I will serve the entire copy, my lord, once it is allowed, my lord.
Yes, my lord.
I'll do it immediately as soon as it is allowed.
Regarding the amendment, my lord's consideration, if my lord want to them rely on the document, I have no objection on behalf of our client.
Let them file the document along with the amendment, and after the amendment, they have to give the composite appeal copy. So it will be served to you along with all documents. Then matter can be heard on merit.
Now, in that application, then I am
Absolutely,
planning
my lord.
to file our counter statement.
Whatever it, if you want to file the counter statement, not problem.
Yes.
Let them file first.
Yes, my lord.
So and so appearing for the petitioner. Petitioner so and so appearing for the respondent. Full stop. The petitioner has filed the present application, praying for allowing the petitioner to disclose three certain documents as mentioned in Annexure A to F of the instant application. And the petitioner also prays for leave to add three grounds in the appeal, being grounds number L, M, and N in the original appeal. Full stop. Counsel for the defendant, respondent submit that if this court will allow the application for disclosing the document and addition of the ground, comma, the plaintiff, the petitioner will be directed to serve the copy of the documents and the amended appeal so that the petitioner and the respondent may file their counter affidavit to the appeal.
Counter statement.
Counter statement to the appeal. Full stop. Consider the submission made by the counsel for the respective parties, peruse the document. This court find that the document which the petitioner intend to bring on record is necessary for the purpose of adjudication of the instant appeal, and the grounds is also required to be adjudicated. Accordingly, prayer A and prayer B of the application is allowed. Full stop. The petitioner is directed to file the documents and to amend the appeal by
application, my lord, rectification application.
Ground in application.
Yes, they have filed a rectification application. This is not an appeal, my lord.
Well, the language used comes from the trademark registry. That's
why.
how the language is being used, my lord. That is the problem.
Now here the appeal 19.
Yes, my lord.
Okay, an application of the appeal के लिए ठीक है जी full stop क्या बोला last में and to incorporate the grounds in the application within a period of 1 week from date and to reaffirm and verify the application within a week thereafter. Full stop. After disclosing the document and incorporating the grounds, comma, the full set of the amended application along with the documents be served upon the learned counsel for the plaintiff within a week thereafter. Full stop. In view of the above, GA Com of 3 of 2024 is disclosed.
I extremely oblige, my lord. My lord, apologies for not appearing physically, my lord. I could not run and come on time, my lord.
It's okay. Yes, next.
Yes, my lord.
Ma'am, for the defendant, the application was taken on by the defendant.
Commercial court side.
Commercial.
Deepak Polimar.
Yes,
Yes, my lord, Deepak. My learned friend has concluded his argument. I will not take too long, my lord.
Only two judgments that are cited in reply. Two new judgments not cited in reply. Those are to be distinguished, my lord.
And the facts which you said.
Facts, my lord, we have argued threshold first me, then him, then I again, not in reply to reply facts.
Because he's argued on new facts.
New facts I can't argue. My lord, in a reply, how can I argue new facts in order?
I will not place any new facts, my lord. I'll just correct.
There is no new facts. Facts are there in the plaint.
Mr. Thakkar has raised the total law point.
Yes, my lord. This will kindly far-reaching consequences. Well, I'll first start with the judgments my learned friend has cited. 1983, Bombay, page 12.
Yes.
Well, his contention is that on demise of the original tenants, now they have become joint tenants. And since the other so-called other tenants have not been made parties, his suit is bad, my lord, and for this purpose he has relied on this judgment. Kindly see, my lord, paragraph 1.
Yes.
An extremely interesting and somewhat ticklish question has arisen in this petition, which is filed by the original decree holder, who has obtained a decree against one of his joint tenants by compromise, and the said decree has been set at naught by the court during the execution proceedings on the ground that the decree was inexecutable on account of various reasons. It's not on the proposition that the suit itself is bad. The objection is taken by the other so-called joint tenant, and on against him the decree is not executable, so the premises is not vacated. That is a simple. Now, my lord, this is not a demurrable point. It is not taken in the opposition or in the petition also. This point that the suit is bad because they are joint tenants has not been taken in the petition, and this is not a demurrable point, because whether they are joint or common, a tenancy in common or joint tenancy is a mixed question of fact and law, which cannot be adjudicated at this stage.
Correct.
That is at the time of trial. Then if it is held that yes, this is a joint tenancy, then the consequences will follow, whatever. So, my lord, so this judgment, my lord, I do not need to trouble your lordship with. Next judgment, my lord, which my learned friend has cited is AIR 2015 Calcutta 112 full bench. This is on, my lord, what a coordinate bench is required to do or not required to do when it is confronted with a decision. Kindly see, my lord, this judgment in fact helps me.
Yes.
Kindly have, my lord, page 13. Page 13. The page number is at the top left-hand corner, my lord. I have cited two decisions of the Supreme Court, my lord, on what is the effect of a judgment which is made without considering or dealing with the law. So my submission was the coordinate bench, my lord, has not dealt with the explanation to the commercial debt.
So that is not binding.
That is not binding, my lord, and for that reason. Now, my lord, this judgment says the same thing. Because the law can't change, my lord. Kindly come to since certainty since certainty, your lordship has that paragraph, my lord.
Yes.
Since certainty and consistency are the bedrock of a mature judicial system, a legal pronouncement of a superior forum in the hierarchical judicial structure in this country, when cited before an inferior forum, is binding on the inferior forum, subject to the caveat that the authority of the superior forum is not per incurium. A judgment can be said to have been rendered per incurium or in ignorance of the law, and therefore have no binding value if such judgment is contrary to any statute, or it is contrary to the judgment of a superior forum. My lord, your lordships, that the Deepak polymer is of a coordinate bench, but even a division bench judgment is not binding on the single judge if it is not considered the law. Then, my lord, kindly see, if a judgment of a division bench is placed before a single judge of the same high court, then the law recognized in such judgment is binding for all practical purposes, unless the judgment is patently contrary to the applicable statute, or it is contrary to a Supreme Court judgment. So here, my lord, I've shown your lordship, my lord, that it doesn't consider the explanation. Then kindly, if however the division bench judgment notices a Supreme Court judgment and reads a legal issue discussed in the Supreme Court judgment to imply something that the Supreme Court decision clearly does not say, it is such interpretation which is binding on the single judge of the same high court, and then single judge has no room to interpret the Supreme Court judgment in any natural or ordinary way other than that as read by the division bench. This is not the case before us. If a single bench judgment of a high court on a point of law is cited before a subsequent single bench judgment of the same court, it is binding on the later single bench. The only recourse that the subsequent judge may have, if he does not agree with the previous decision, is to refer the matter to a larger bench. The case is similar if a division bench judgment is cited before a subsequent division bench on the same court, and the subsequent division bench does not agree with the view expressed in the previous case. This, my lord, these statements which are made here perhaps is what my learned friend has relied upon, but this is subject to the caveat given above, that even the division bench judgment is not binding on the single judge if some particular position of law has not been discussed. So therefore, my lord, I say per incurium, and I have relied on two decisions, my lord, on this regard. My lord has 2025 SCC 1 and 1989 1 SCC 101. When a provision of law has not been considered, has not been dealt upon, has not been decided, then, my lord, the coordinate bench can of course consider it, because the first judgment is silent on it, my lord. So this takes care of the two decisions. Then, my lord, he says that a commercial suit does not lie because the premises in question is residential in nature. And he has shown your lordship the lease deed at page, I'll just show your lordship, yes, at page 21. is the lease deed, and he has referred your lordship, my lord, to page 23, clause 6 at page 23, to use the demised premises for the purpose of office, residence, trade, commerce, go down hotel. So he has said, my lord, your lordship has perhaps marked that also. Clause 6 was shown to your lordship that this is a mixed use, not purely commercial. Look, page 23, my lord.
Yes.
So the submission was that it is not purely commercial, there is residential use also, so it cannot be a commercial dispute. Because this lease deed has...
So his submission is that it is not an exclusive.
Yes, yes. I bow down. Your lord, that is perhaps his language, yes. But my lord, that is neither here nor there, because if your lordship sees, this is a deed of...
He has catch hold of the exclusive word.
Yes.
Statute.
Yes. Now, my lord, exclusive or not exclusive will not trouble us, my lord, because this is a deed of 31st January 69, which has already expired by flux of time. And he has admitted this. Kindly see, my lord, why this exclusive or non-exclusive does not arise for consideration. Now, my lord, I'm showing your lordship his affidavit in the before the rent controller. Kindly come to page 146, my lord. He has admitted that this deed has expired and the place is now used for commercial purpose only. This is part of my plaint. I had filed proceedings before the rent controller, my lord. Your lordship sees at page 146. This is the proceeding under 17(6) of the Premises Tenancy Act. Now your lordship will kindly, that was for the fixation of fair rent, which was allowed, and therefore he came out of the Premises Tenancy Act. Kindly see his written objection at 156, please, my lord.
Yes.
Written objection of the opposite party number 8. And that is why I showed your lordship the cause title, my lord. Opposite party number 8 is Swarnalata Chopra at page 148. My petition has the full cause title, my lord. His has the short cause title.
Yes, Premlata Chopra.
Yes, Swarnalata Chopra. And now, my lord, kindly see his written objection on behalf of the opposite party number 8 starts at 156. Then kindly come to paragraph. Give me a minute, my lord. Yes, kindly see paragraph 8, please, my lord.
Paragraph
8 at page 4.
Yes.
The entitlement, last 3 lines, my lord. The entitlement of the applicant to have the rent increased is therefore also guided by the West Bengal Premises Tenancy Act as enacted up to date, and more particularly by the provisions envisaged under section 17(4)(a) thereof, which applies in the case of the opposite party where the tenancy subsists for more than 20 years on or before in respect of the premises constructed in or before the year 84 and used for, your lordship sees, commercial purpose. The section is only for commercial purpose.
Where from your reading?
I'm sorry, my lord, 160. Your lordship kindly turns over to page 160.
Exploiting the aforesaid tenant, gaining profit without paying.
Your lordship sees the first continuing paragraph on top, my lord.
Yes.
Under section 17(4)(a) thereof. Section 17(4)(a) only applies to commercial. I'm sorry, your lordship has 160, my lord.
Acha, 160, yes.
160. Under section 17(4)(a), 17(4)(a) is of the Premises Tenancy Act, which applies only for commercial purposes. And he himself says, which applies in case of the opposite parties where the tenancy subsists for more than 20 years or more in respect of the premises constructed in or before the year 1984 and used for commercial purpose. This document is a part of the plaint. This is his written objection, my lord, before the rent controller. 17(4)(a) applies because and 17(4)(a) only applies to commercial premises. And he says this 17(4)(a) is applicable. This deed which he has shown, your lordship, has expired long ago by flux of time.
Yes.
And my lord, his one more document which is part of the plaint is the rent receipt which he has signed, my lord. Kindly have page 259. (259) is my rent bill, my lord. T. Thompson Plaintiff, bill to Anuradha Devi and others.
That you already pointed out.
I am not sure whether I showed your lordship this. Kindly just see, my lord. Description of tenancy your lordship has, my lord. Office space on the ground floor, office space on the ground floor, office space, mezzanine, car parking space.
Yeah.
Entirely commercial. And my lord, your lordship sees received and accepted Swarnalata Chopra.
Yes.
This is part of the plaint. There are 2 rent. The first is the rent bill. The next is the rent receipt. And all these. So, my lord, that was a tenancy which has expired by flux of time. Now, my lord, yes. Then, my lord, he says, R against para 6 at 23. Now, my lord, he says that I have not conforming with 61A of PND, page para 30 at page 287.
Page?
Yes. Kindly give me a minute, my lord. Kindly have page 287. Once, my lord, he says that I have not said which subclause of the Commercial Disputes Act, Commercial Courts Act is attracted. My lord will kindly say, see paragraph 30 at page 287. Specific.
287?
Yes, 287. Oh,
The
practice.
plaint?
Yes.
The plaint?
Yes, my lord.
Plaint ends. Acha, second.
There is a second volume.
Second one.
Practice directions देख लीजिए. Practice direction. वहाँ है practice direction नहीं? हाँ बुझला. My lord, his grievance, not grievance, his contention is, my lord, that's rule 61A of the practice directions framed by our court, my lord, has not been complied with. 61A reads, my lord, forms of pleadings. It was handed over, I think a copy was given to your lordship, my lord.
287?
287, yes.
See, Manu, 287.
Huh?
276.
Internal page 9. I'm sorry. Your lordship is seeing the. I have a running brief, man. I'm sorry. Page 9. Internal page 9 of the plaint. I'm sorry.
Of the
plaint. It a phone 287. How much it gave you? Oh, GA1. GA1 can know that about. I mean, 711 that.
Internal page.
Internal page 9 of the plaint. Your lordship sees paragraph 30.
Yes, subject matter.
The subject matter of the suit is a commercial dispute within the meaning of the Commercial Courts Act, inasmuch as the agreement, being the last paid rent receipt, relates to an immovable property, and I also use exclusively, used in trade and commerce, and therefore commercial division has. Now, my lord, his contention is that I have not complied with rule 61A of the practice directions.
Correct.
Yes.
Yes.
Transfer Property Act. Well, 61A of the practice directions reads, the pleadings before the commercial courts and the commercial division shall, as far as practicable, be as per order 6 of the code, and shall in all cases in addition thereto state the following: whether the subject matter of the suit or proceeding falls within any one or more of the categories of commercial disputes defined in section 21C of the Act, with a brief statement of the reasons leading to such clarification. I have squarely met with this here, my lord, in paragraph 30.
That is in terms of section 2C.
Yes, 21C, immovable property exclusively used in trade and commerce.
Correct.
So I have stated that. What I have not stated is, my lord, which is the subsection of 21C which is attracted. And this, my lord, 61A has been sufficiently complied with.
Whether the subject matter of the suit proceeding falls within any of the more of category, that's why the rules has not prescribed any specific provision.
Yes.
The court has
yes, the
relied upon the 21C of the commercial court.
So, my lord, all that I'm required to say in what I understand, my lord, my humble submission from 61A is, I have to say how I'm invoking the commercial division jurisdiction. So, I have said that in 30, that it is the immovable property used exclusively used in trade and commerce.
Yes, you pointed.
I've pointed. So, my lord, this, and my lord, a pleading not, even if a pleading is not absolutely perfect, it's not a ground for 711, my lord. It's not a ground for rejection of plaint. It does not disclose, it's not that it doesn't disclose a cause of action.
He's telling that he are not disclosed how the commercial court.
Yes,
as per his
yes. So, my lord, that even then, my lord, it can't fall on within 7.
Cause of action not coming under the purview of the cause of the Commercial Court Act. So
yes,
the suit will dismiss.
Yes.
The rejection of plaint.
Yes. No, no. My lord, he says that my pleading is not accurate.
So that's why he's telling you are relying upon 30.
Yes.
You are telling that you have pleaded in paragraph 30 with regard to the provisions of commercial code.
Yes, ma'am.
He is telling that that is not the sufficient in terms of section
Yes.
Grateful.
Grateful, man. But then he has to tell your lordship which clause of Order 7, Rule 11, which sub rule of Order 7, Rule 11 makes deficient pleading a ground for rejection.
Let me see.
Yes, your lordship will kindly consider that, my lord. Then he says, my lord, no date of cause of action mentioned. When the cause of action has arisen, as we do
Cause of action, it is settled.
Yes, no, my lord. So even then, that cannot be a ground for rejection of plaint under 711, my lord. All that I need to say, it is not barred by limitation, and that is what I've
Cause of
said.
action, limitation, that already also settled.
Yes. No, my lord, he says that as is stated in the Civil Procedure Code, you have to say, like we write in the subordinate judiciary, my lord, that
cause of action
has
also.
arisen on such and such date at such and such place and is continuing. Well, that is not the practice which we follow in this honorable court, at least. And that even then, it cannot be a ground for rejection of plaint under Order 7, Rule 11. Then, my lord, half the suits in this court will be dismissed on this ground. Even my learned friend's senior suit will be dismissed. Then, my lord, he says,
his argument will be accepted and passed, and when he will come, then
then I don't want to face that. My lord, let both of us not suffer because of this, my lord. Then, my lord, he says, he relies on, my lord, the Transfer of Property Act 106, 111. I have already dealt with this, my lord. I don't need to. His argument is that 111H is attracted and not 106.
Yes.
Kindly see, my lord, Transfer of Property Act. I have already dealt with this. His contention is this, my lord, that if lordship sees 106, 106 only, my lord, sets out duration of lease and in what is the duration of lease and how it is to be terminated. And then, my lord, he beseeches your lordship to consider 111H, determination of lease. On the expiration of a notice to determine the lease, I'm sorry, my lord.
Yes, yes.
On the expiration of a notice to determine the lease or to quit or of intention to quit the property leased duly given by one party to the other. So, my lord, this 111 only provides that if 106 notice is given, then the lease shall stand determined. That is all that it does, my lord. But it doesn't advance his case any further on the cause of action argument. That cause of action is a bundle of facts. It is not just the giving of the lease. Because if your lordship sees 106 itself, it says, in the absence of a contract or usage to the contrary. 106 is not a notwithstanding section. It is a section which is attracted only in the absence of a contract or usage to the contrary.
Correct.
So first thing which in any plaint, the first thing which would have to be shown, if there's no contract to the contrary in 106, to first attract 106.
Then only 106.
Then only 106. So all these are facts which need to be considered. It's not that I file a one-page plaint saying this is the 106 notice and now he's out. That cannot be the suit, my lord. No, valuation. And my lord, he said that valuation I cannot claim. 12 months rent. There's no default, no occupation charges. My lord, this I've already dealt with.
That's not a point pleaded.
We're not there.
That's already
Joint. Those are my respectful submissions.
Thank you.
And my lord, one more last submission, my lord, Order 7, Rule 11. If my learned friend's contention is that the suit cannot be maintained in the commercial division, the plaint cannot be rejected. The plaint can only be returned for filing in the original.
7 Rule 10.
In the 7 Rule 10. 7 Rule 10 was earlier not applicable to the original site, but because the Commercial Courts Act now gives overriding effect to the code, notwithstanding anything in the original site.
Correct.
So my suit cannot go. I will not lose my court fees.
That too because of the division. Otherwise it is to be placed before the appropriate forum.
Yes, my lord. But here the plaint will be returned to me for presentation in the original.
Monday, Tuesday, Wednesday, or Thursday.
Yeah. Instead of Monday or Tuesday, Wednesday or Thursday. He will live for 2 more days. That is all.
Now what this court is facing trouble
my lord.
after the, because though act has come 2050.
Yes, my lord.
But we have started 2070.
Yes, my lord.
And 2016 also the original was going on.
Yes.
Subsequently, the court
Then the
has
transfer.
established and started. So many case has been went to
Transfer
the
this.
transfer or directly gone to the commercial division,
Commercial.
and you from the bar also it is going as a commercial.
Yes.
The
Now
court is
decree
also
being
taking.
passed, but
Now the decree is passed. What will be done? How the
many
decree
suits
will
have
be
suffered same
decree will be drawn.
No, drawn up হচ্ছে না।
Drawn up, correct.
There are
Yes.
2-3 suits now.
Stuck like that.
I suffered
Decree
one.
passed, the order passed. You applied for the drawn of the decree.
It is come in original, or it is, yes.
So it is this plaint has not amended.
It has not been numbered as a commercial.
Leave aside the number, but it needs
Yes,
to be
yes.
first title.
First title has to change, commercial.
But when can't draw up those decrees, so all stuck there.
So drop the decree with regard to the cost title. It's not there. Commercial division.
Well, there is a this decision of Bombay, which my learned friend has shown your lordship, my lord, might have the answer. Kindly have this. 1983 Bombay. Here the decree was held to be non-executable. Non-executable. The Bombay court, my lord, provided a solution. Kindly see. My learned friend has answers for everything. Kindly come to my lord.
Not our case.
Yes. The Bombay court suggests a solution that you can go back to the suit because the decree is non-existent. Decree is not executable. You can go back to the suit court and get it corrected. Kindly come to.
That's why now it has, if the suit has come to the now it has come to the court.
It now
So
comes
how
to your
it is
lordship.
to be corrected?
Yes. Now, my lord, kindly see paragraph 16 of this. Kindly see paragraph 16. Even assuming that the executing court was wholly helpless because there was a decree which could not be executed. Similarly, here the decree can't be drawn up in the matter of giving any assistance to the original plaintiff, either on repeal 47 or under 150. It need not be assumed that the original plaintiff had no alternative remedy. Once the executing court, we are at a stage before this, finally pronounced the decree to be a nullity, he could certainly move the original court by an appropriate application, inviting its attention to the fact that since the decree previously passed by itself was found by a court of competent jurisdiction to be a nullity, the original suit has remained undisposed of, requesting the court to start proceeding anew with a view to bring the suit to its fructuation by passing an appropriate executable decree, if necessary by taking evidence, by adding the other parties. So here, Manoj, the decree is not drawn up. He would just have to make an application to the suit court and say that now this decree should be amended to commercial. This is one step further. Decree made, decree held to be inexecutable. The court says you go back to your original court. So they can take a leaf out of this and apply to your lordship again that you change it to.
Should be applied.
Yes.
Either way, suit court has to apply his mind afresh even according to this section, this paragraph. Either way, the suit court has to apply its mind afresh because either it's anew or without.
No, anew because here it is.
No, thereafter. Now the problem is that okay, they can apply for.
Yes, they come back to your lordship.
They come back here.
Yes.
But under the Commercial Court Act, at the time of transfer, there is no order.
There is no order. I think that I don't think any party will take away.
No,
they've taken.
They've taken.
I think you are there.
I suffered once, and I am arguing in this.
No, it is.
Then I will. Then if he briefs me, I'll tell him. Grateful, my lord. Deeply obliged.
Grateful.
In any case, my lord, if your lordship is with Deepak Polymer, then it's a different matter. Otherwise, my lord, even then it cannot be dismissed. 711 cannot
succeed. There cannot be dismissed. There cannot be dismissal.
711, your lordship will kindly consider, my lord, this Deepak Polymer requires some consideration. Grateful, my lord, deeply obliged.
If I
we'll file a short note.
I'll include his points in the.
Yes, no problem.
And I have one application pending, that is J number 4. My application for extension. If I lose here, then that application for extension have time to file written statement.
No, that he cannot, because if it's commercial, maintainable in commercial, he's lost his time.
For the plaintiffs,
I have applied within
for the
time.
defendants.
So the time lost, I not.
Counsel for the respective parties have concluded their submission with respect of GA4, na?
Yes, that is still pending.
GA4.
GA4.
Huh?
This is only GA2 which your lordship has decided.
Yes. GA4 is my application for extension.
That will after GA3, my summary judgment.
GA2
Thereafter
is concluded. Concluded. Full stop. Counsel for the respective parties press for time to file their written notes of argument. Let the written notes of argument filed by 1 week.
1 week.
By week. This is the matter on 30th, 29th July 2024 has to be mentioned under the heading to be mentioned for filing written notes of argument.
Grateful, man. Deeply obliged.
South Point.
South Point.
Howrah South Point.
Howrah South Point. I had concluded my submissions, my lord.
Yes.
The Gupta is to reply. My lord.
This is, my lord, a classic case of possibly a mountain being made out of a molehill. Your lordship will see, and possibly, my lord, if the persons are getting confused that the two schools are identical, then I would be in more trouble. I only survive on foreign donations, and they earn money from the students. There is no iota of any similarity, and I will start my case by showing your lordship the brochure, and then I'll take your lordship to the pleadings. My lord, this your lordship will see, and I shall also show, my lord, the website also, because there is an objection with regard to the website. Kindly sees the nature. Your lordship will see at the first page that at the bottom, Howrah South Point, your lordship will see. Then your lordship will see the logo. And I shall show the two logos side by side. I have annexed in that way that this is completely different. Now your lordship will kindly turn over to the next page. আমি just brochureটা দেখাচ্ছি আমি দিয়ে দিচ্ছি My lord, will kindly come to the fifth page. Page number is at the bottom, my lord.
Yes.
My lord, will see there is a who are we that has been given, that this has been developed by Father Francis Laborde in 1976, and it's a French Roman Catholic priest of Prado. And my lord, he spent 9 years in the slum of Pilkhana, Howrah, West Bengal, which inspired Dominique Lepier for his bestseller City of Joy. This is where the inspiration comes from. And the schools are, kindly see, skip 2 or 3 sentences. Then a small home for handicapped children with a dispensary for the poorest was established in Andul Road, that is in Howrah. It went through a number of developments, from healthcare program founded in 1977, the establishment in Jalpaiguri in 1982, the mobile dispensaries in 1988, up to a national award in 2013. Then what we do is on the right, your lordship will see the headings: rehabilitation homes for the physically, mentally, and socially challenged children, education programs, HSP from schools, non-formal schools, and special schools, health programs, and also empowerment services to pursue studies and training to give awareness on the basic rights. So this is my scope. It's a non-governmental organization. And then if your lordship kindly turns over to the next page, your lordship will see district-wise division, that what all happens. My lord, your lordship will see all are, my lord, homes for, my lord, destitute children. There are, my lord, dispensaries. There are, my lord, your lordship will see everything. My lord, elderly homes and all these things, my lord, are mentioned here. Then my lord will kindly turn over to page number 8.
Yes.
And your lordship will see from the brochure, my lord, it's only, my lord, directed towards, my lord, towards serving the, my lord, underprivileged class of the society, without taking any donation or any fees or tuition fees or anything from them. So, but we need money to sustain all this. That is why, my lord, we have to, my lord, get donations. That is the only source of our earning which we spend. And I am also carrying, I've asked my learned advocate on record to get the balance sheets, and your lordship will see hardly there's any money. ITR returns we are carrying. In 1 year, there is a loss of 3,26,000. In the other year, we are carrying in the last assessment year, it's incurring a loss of 3,26,000.
Yes.
Now, my lord will kindly website to that. Now, may I hand up, my lord, before your lordship, my lord, the website of, my lord, the Howrah South Point. I've opened it for your lordship's kind consideration. Kindly see there's a disclaimer which has been given in pink at the bottom. So once the website is opened, this disclaimer comes.
So this continues
Yes.
in every
Yes.
domain.
No. This is in my website.
This is your website.
Yes. So whenever anybody opens my website, this will be reflected. That we have nothing to do with South Point of Baliganj, nothing of that sort. Because if we are, then people will not give donations.
When you incorporated this?
After the suit was filed, I had indicated, because before the suit was filed, there was a school which we run by the name of Howrah South Point. They objected to it. We said, very well, we shall change it. And we had changed it to some Dulia Ekprantogor Vidyalaya, which is nowhere. They are joining issues now with our name, Howrah South Point, and the website which has howrahsouthpoint.org or
that is the
which we are saying that is our incorporation name. We have the certificate, whatever. We have the certificate under the Societies Registration Act in that name from 1970s.
Since when you are using?
From 1970s. And we have indicated that I shall take your lordship to those documents from my opposition. So, my lord, nobody will get confused by the name of any school. The only issue which they seek to now allege before your lordship is the website and my logo being deceptively similar, that persons would get confused and think that this is South Point. And in fact, I had also heard my learned senior friend making submissions on the last day that the ex-students and the alumni of South Point, thinking this to be a South Point, would give donations. My lord, then their teaching was something which best not spoken. If this is the confusion which can be had with this organization, then least said the better. My lord, page 83 of my affidavit in opposition, this I have given, it's from 1980, 1981. This is 1980.
Page?
Page 83 of my affidavit in opposition. My lord, will kindly see it's Howrah South Point Social Welfare and Community Development Center. It's a Social Welfare and Community Development Center.
85.
Page 83 of the affidavit in opposition. But after 83, A to H, there is 83.
Howrah South Point Social Welfare and
Yes.
Welfare and Community.
Now, since your lordship is on the affidavit in opposition, your lordship will kindly have a look at My lord, page 94. I'm sorry. 94, my lord.
94.
Yes.
Yes.
At the top, my lord will see there is a logo of the plaintiff,
Yes.
and at the bottom is our logo.
Yes.
Kindly see, my lord, there's somebody sitting on wheelchair. He's being assisted by somebody. That's our logo, that's our motto. The color scheme, the font, the letters, nothing resembles. Not a word resembling the logo. Now, my lord will kindly have a look at, my lord, page 92. This is our website. So when we open, we find this, which we have also shown to your lordship, my lord, but this is what we have annexed in the affidavit in opposition. So I'm showing it from that. And kindly compares this with the website of the plaintiff at page 83A. 83 is before 83. I don't know how, but so this is the website saying it's under MP Birla Group and all these things, new campus opening. So this is the website, and 83B is ours. So your lordship will see there's nothing similar. And my lord, a lot of hue and cry were made in the plaint, has been made in the plaint, but with regard to the name South Point, because they say that they have achieved something South Point, so that is why. Kindly comes to 83C. This is a South Point casino in Las Vegas. So that name is being there. Kindly turns over to 83D. Continuation of that. 83D.
Yes.
Then my lord will kindly come to 83E. This is South Point Institute of Technology and Management, Sonipat, which is an educational institute.
Yes.
That is 83E. Then 83F is a South Point Degree College, Sonipat.
Yes.
So all these we have annexed to show that there is no proprietary right in respect of the word South Point. And the fact that they are seeking to make out a case that it's a well-known trademark is also possibly not correct.
Yes.
But there is one other which we have found that we have not annexed in the website, in the affidavit in opposition, is another website, South Point Institute, that is also in Howrah, which has nothing to do with us, but there is one other affiliated to CBSE. So there is one other also. So this South Point is nothing, my lord, it's nothing new or nothing so ingenious that only they have the right. These are two words which are, my lord, common words in, my lord, English, and they do not have any right in respect of these words. There is no trademark, there is no word mark, South Point. And what word marks they have, I shall show from the plaint. Now, my lord, we'll kindly have a look at page 29 of the application, of their application.
Page 9.
Page 29, if your lordship kindly takes. 27, kindly. Your lordship will see that there is a certificate of the trademark, my lord, registry in. So it's this legal use certificate which says that the word mark is South Point within bracket courage to know. So that is the word mark, South Point courage to know. And not only South Point. And this is in class 16, which is formulated books, periodicals, magazines, and so on and so forth, which has been indicated there.
Yes.
Now 29 also is in class 18, and that is school bags, satchels, and camper bags, game bags. This is also, my lord, this is a device mark, but the work mark type is South Point courage to know. I'm sorry, page 31. This is under class 25, which is hosiery goods, school uniforms, and the like, my lord.
Yes.
Then 33 is under class 26. This is of school badges. Now, page 35 is a device mark. And kindly see the pictorial representation. It's towards the right hand side. There is a bird pointing upside, and there's a courage to know written in U format. Thereafter, South Point. So this entire thing is the device mark which is registered. So one thing cannot be segregated from this device mark. So this device mark in the entirety, my lord, has to, your lordship will kindly consider this in its entirety. Same thing goes for, my lord, page 37, which is also a device mark. And this goes on till 45.
Yes.
So, my lord, now your lordship has seen, my lord, the device mark of this bird, pictorial representation of a bird and a courage to know written in U and the South Point at the bottom of that is, my lord, completely different from our logo. So it cannot be that, my lord, my lord, these are deceptively similar.
Yes.
No, my lord, this is not a product which can be bought off the shelf, where persons would go into the shop and say, give a South Point, and somebody gives a South Point. This is not something of that sort. What they are aggrieved by is, my lord, we are getting donations from the world at large, showing or portraying us as an unit of South Point, showing that we are getting donations. That is what they are espousing in the plaint, which we say that if we do that, we will not get any donations, because we only survive on a few donors which we have indicated in the opposition. It's not that anybody one fine morning logs on to the website of South Point and thinks they'll donate. No, we are not that fortunate enough. Now, the donors we have indicated in the affidavit in opposition at page 23. And now, my lord, I'll indicate, I'm sorry, my lord.
Yes, page
23 of my affidavit in opposition. There's a table given by us.
Yes.
And before I take your lordship to this, only one thing. The donations your lordship will see from the website, if your lordship so desires, I can show from that what the intending donors need to do is they are required to sponsor a child for a particular number of days, for a particular program like this, or some sort of a skill program they have to give, or in respect of some healthcare program, some donations are being given. So it's specific to that. The donations are being given. Here, from the website, I can show to your lordship that it is 4,200 INR to provide school supplies like notebooks and pencils for a class of 50 children. That is the donation one can opt for. Then 8,400 is to provide 15 days of meals to 30 children. 3,500 is for one child for 1 year of food and housing. 7,000 is for a handicapped child for 1 year food, housing and care. And 2.6 lakh INR is for to participate to renovate a home for 30 children. So this is, my lord, the nature of donations which are there in the website, that to become a donor, one has to select either of these options. So, my lord, it is inconceivable as to how somebody would log on to their website thinking this to be an unit of South Point Baliganj and donate.
So your website will not open South Point if you go for the website. If we will go to the South Point, all the South Point will come. South Point, Hora South Point, or Baliganj South Point.
When their website is opening, their website is opening. So if your lordship gives the search in Google, my lord, or any other search engine.
So today in the domain.
Yes.
For you are having the Hora South Point.
Yes.
They are having the South Point. Correct. How this, and if we don't know,
yes,
as a layman,
yes,
or we are in search of the South Point school,
right,
or whatever it is. If we go back to the South Point, we go to the website and search the South Point school. If we go to the South Point school,
yes,
in the website, so
South
all
Point has
South
been the plaintiff.
Whatever it may be.
Yes, because I don't have a South Point school now.
Whatever it may be, if you go for the South Point, so the all South Point will come.
Yes.
So it cannot be a confused to the party person concerned with South Point.
Yes, confusion here can be of two natures. One, where to send their wards for education. Two, donation. So here, if somebody sees this website, then there is no similarity between the two where they would choose this over the other to send their wards for education. It's only persons who are deprived in the society that they're fortunate enough that the defendant is there for them. But for the plaintiff, that is not the case. So somebody who is wanting to admit their wards in their school, once open the website, if they open our website, then that is not there.
Okay.
Secondly, from another angle, somebody wanting to donate, thinking, well, South Point is now taking care of all these children, so that is why I would be donating. Websites are different. Once the website is given, then there has to be entire process where to become a donor, a lot of things has to be filled up, and thereafter the donations come. So it is not that somebody just will go and click on a QR code or something and their donations would come and we would get benefited out of filching from their name, as has been portrayed by the plaintiff. It is not that case. So one has to sponsor a child or a class or a program, something of that sort, to get in to give the donations. Now kindly see page 23 of the affidavit in opposition.
Yes.
But these are the major donors which we have, and kindly sees the countries have been given, and it's all abroad. First two are from Germany, then France, then Switzerland. So these are the countries. And now your lordship will see on the right-hand side column, there's a purpose. So purpose, your lordship will find that there's dispensary, then there is a surgery camp, there's a sponsorship program, then one for branch, then one for a particular home, so on and so forth, my lord. So it is not that somebody is giving donations,
Yes.
but thinking it to be, my lord, South Point Baliganj.
Yes.
And these are, kindly see, I'm grateful to my learned junior, my lord. These are organizations who do that. Kindly see on the left hand side, the name of the foreign donors are mostly, my lord, organizations
That's correct.
over the world who support the cause of, my lord, these kind of homes. So it is not somebody like he will not never donate South Point. I don't think they need any donations also. Otherwise.
No, they thought that in the name of the South Point, you are getting the benefit of that.
I think that if that is the case, I would be in more trouble.
That's why.
Yes.
They-
I
this
cannot
is-
get. If people start to compare me with them, then they will not give donations to me.
Okay.
Because I cannot take a rupee from these children or these persons. Not 1 rupee. I only survive and make these schools, these homes, they supply food, cater to their medical needs for a few based on the donations. That's all we do. So even if our schools are being run, even if I take it that I run school in that name, which is no longer the case, before 2-3 years it was, at the request we has changed.
There's no school now.
I'm sorry?
There is no school now.
No, not in the name of Howrah South Point, there is no school. The name has been changed. There are 4 schools in different districts. One is in South Howrah. Why the name Howrah South had come? It's in the southern part of Howrah. That is the whole logic. There is nothing else in that. And that is my registration. That is how I am known to the, my lord, organizations the world over. That, yes, this Howrah South Point caters to this downtrodden or the unfortunate rung of the society. So that is why, my lord, it might occur to your lordship that if you say that this is not a problem for you, then why not change the name? And that might have, my lord, possibly come in your lordship's mind. So to that, my lord, I am, my lord, preempting that, my lord, and trying to, my lord, indicate to your lordship that this is my name, which is known the world over to do these kind of things in India or in this part of India.
Yeah.
So that is why, my lord, it is, so this name of a school, no problem, we have changed. But to change the name of the website and the organization, therein my trouble would be there. Would render my entire cause of getting donations and I have to make myself known to the world that I do these things, which I have been making for last 44 years. So now to change that, I have not in my written statement or written affidavit in opposition tried to indicate that they are not prior users. No. They have been using it previously. I don't join issues with that. But my simple, my lord, defense in this is A, it is, my lord, completely different, my lord, and the question of passing off would not arise in these facts. A, from the logo, B, from the name, C, from the description, and also from the device mark, and most importantly, from the website, which they're portraying as being troubled the most. So the websites, and also, my lord, after this suit, that disclaimer is there.
Yes.
And I filed that separately before your lordship, my lord, a separate sheet of paper where I've taken a color printout of that and given to your lordship, my lord.
Yes.
But one other thing, my lord, possibly of some relevance, your lordship will kindly have a look at the application once. But in my humble understanding, subject to your lordship, you know, testing the same, but they are possibly not only South Point. They are South Point School. Your lordship will kindly have a look at page 46. And why I say so, my lord, I'll try and establish that. Kindly have a look at page 46, my lord. So this is a advertising bill which they have given to show that they have published at various places of the names. Kindly see the address to South Point School. Then the advertisement at page 47 also shows it's South Point School, page 47. But in fact, I'm sorry, my lord, page 46, if your lordship comes back to, but they have also signed as South Point School, or please pay account South Point School. And towards the bottom left, my lord,
Yeah.
there's a stamp. This is what they're known as. My lord, page 48 also, Bill, South Point School again. And 47, I've shown the advertisement, my lord, at 47. Then 50 also, my lord, it starts from, there's a advertisement called Teachers, my lord, on the right hand side, second from last, my lord, right hand side column, Teachers. There's a heading at page 50. My lord, in that, your lordship will find South Point High School invites. Then again, the next paragraph, South Point School invites. So South Point, the whole South Point School is possibly, my lord, in my humble and limited understanding, possibly is not there. And the name is South Point School. This goes on till, my lord, page 50, 59, where in all documents, your lordship will find South Point School.
Yes.
So these are all their documents which they have shown to, my lord, portray a picture that they have spent a lot of money with regard to advertising. But all are in the name of South Point School. And my name is Howrah South Point. Now, my lord, will kindly have a look at my affidavit in opposition, where I have indicated, my lord, how these two are not at all, my lord, or cannot at all be similar, my lord. It kindly comes to page 3, paragraph 4A. And I've indicated in paragraph 4A that I have been registered under the Society Registration Act in 1980. I've shown your lordship the certificate. Then B is very important. Defendant number 1 is registered under the Foreign Contribution Regulation Act, Ministry of Home Affairs, Government of India, for receiving donations from foreign countries in accordance with the provisions of the Foreign Contribution Regulation Act 2010 and Foreign Contribution Regulation Rules 2011. So this is where I have been, because I only sustain on foreign donations. Unfortunately, my lord, I do not get donations from here. I hope my learned senior friend could persuade his client to give some to me, my lord.
He will give month by month.
He can, but I am hoping that his client would give something to me for these children.
Or by yearly, you will contribute something for your charity.
Provided I am not duped, my lord, or being led to believe that this South Point is the South Point which we all know.
Which nobody would. No right-thinking man in the society would.
No, then the Gupta will say that South Point has been transferred only to the South Point, keeping aside the Howrah.
Malad,
that is a possibility.
Malad will kindly come. Malad will kindly come to page 4,
yes.
Paragraph C. But this I have indicated from the brochure, but I have also pleaded that on oath, that in 1976, this was founded by a French Roman Catholic priest. And he spent 10 years, that I have indicated. Then thereafter, program was number of developments and healthcare program, and charitable dispensary for mother and child healthcare program was founded in 1977, and so on and so forth, that I have given. Then the lordship will kindly have a look at D at page 4. The defendant is engaged in looking after the handicapped persons in the society and serve and work for them with competence, love, care, and compassion, so that handicapped and destitute children and all the deprived people may reintegrate into the society.
Yes.
Then I have indicated the 3 main programs which I undertake. A, it's rehabilitation homes for physically, mentally, and socially challenged children. Then B, it's education programs which includes formal school, non-formal schools, and special schools. And C, it's safe motherhood and child surveillance and elderly program for the slums. But these schools do not bear the name Howrah South Point. All the names are different, the names of the schools. I have indicated in paragraph F that there are 3 districts from we operate. Then, Mulad, there are 9 homes, 413 children, 3 creches, and 11 schools with 1544 students. All these I have indicated, and the number of dispensaries which we have made. And we have also given the annual reports. Now, my lord will kindly see paragraph J at page 6, where I've indicated this, my lord, that from the website I was showing from the laptop, my lord, that per year or how much amount is being given, and also that donations are extended under 80G of the Income Tax Act. That I have also mentioned. Then, my lord, in paragraph M and N, I have indicated, my lord, how these are completely different, my lord, in so far as the logo, the color scheme, and the pictorial depiction of the, my lord, the two logos are concerned, my lord. So there cannot be any deceptive similarity. Then most importantly, paragraph my lord, P at page 8.
Yes.
I've indicated that, my lord, this is nothing to do with the plaintiff. The objective is completely different. Then, my lord, Q. The mode of operation of the defendant is completely different, and defendant is solely reliant on donations. The life of the students, their education, health, food depends on donations received by the defendant, not only from the country, but also primarily from abroad, which constitutes more than 95% of the donations. Then I have indicated that the nature of school which I run is different, that in paragraph R, and S, that no right-thinking person in the society would confuse the two.
Yes.
Now, my lord, one thing which I should point out, my lord, your lordship will kindly have a look at, my lord, this certificate. At my lord, page 33 of my affidavit, this is under that Foreign Contribution Regulation Act. And I have been permitted to receive funds only in this account at Delhi.
Where it is?
Well, page 33, your lordship will see there's a registration number given. Nature is economic, educational, social. Then 2, the association shall receive foreign contribution only in its designated exclusive bank account in State Bank of India, the such and such Delhi. So it is not that somebody can easily go into any website and give money to me. Only a particular account has been designated by the Ministry of Home Affairs Foreigners Division. And there is Foreigners Division FCRA wing of the Union of India, which has given me this.
Yes.
My lord, my lord, one other thing, my lord, kindly comes to page 11 of my opposition.
Yes.
But in paragraph X at the bottom of that page, I have indicated that there is no presence of Howrah South Point School of the plaintiff in the district of Howrah. They are only from South Calcutta.
Page?
They are only from
Paragraph?
page 11, paragraph 8. And I have indicated why the name Howrah South Point. Kindly sees the last line. The name Howrah South Point, kindly turns over to page 12, specially denotes the geographical location in the south of Howrah district of West Bengal. That is why.
Yes.
And I have also indicated that from 1980, I have been performing functions under the name of Howrah South Point. So they are coming after 43 years. But other points, my lord, I have indicated, my lord, while arguing, my lord, that these are the logo and the pictorial depiction of my name is completely different. My lord, I have some judgments to show, my lord. Could I come back on some other day and, my lord, just to formally cite 2 or 3, my lord, and conclude my submissions?
Suffering for the plaintiff, suffering for the defendant. Counsel for the defendant has argued at length in connection with GA1 of 2023, but due to paucity of time, hearing could not be completed. Fix matter, let the matter appear on second August. Under the heading
Lordship.
My lord, could it be any day barring second, any other day?
Could it be on 9th, subject to my lords?
Or any other day, my lord, barring second.
Second already.
9th August.
Nine.
Deep
As part heard, huh?
Deep look.
Yes.
My lord, for extension of interim order, my lord.
Which matter?
My lord, if this is, I had given notice, my lord, realizing that it may not be called. My lord, the interim order is expiring, my lord, on 22nd.
Item number?
It's item number 9 and 10 in the regular division. 9 in 9, my lord, GA1 is my interlocutory application where the interim order was passed there. My lord, it was last extended by your lordship by this order. And I'm mentioning upon notice, my lord, to the other side.
Nobody is there, dependent?
No, I have given them notice, my lord, that we are going to mention it.
Till 22nd?
Yes, Monday. And Monday, lordship takes up commercial matters.
So-and-so appearing for the plaintiff. No, the plaintiff has mentioned the matter for extension of the interim order after serving notice to the learned counsel for the defendant, but none appears on behalf of the defendant. Counsel for the plaintiff has mentioned the matter for extension of the interim order as the interim order granted earlier is going to be expired on 22nd July 2024, and on 22nd July 2024 the court will take the non-commercial matters. Consider the submission made by the counsel for the plaintiff, interim order granted earlier, which was extended till today, until 22nd of July 2024, is extended further till 27th of August 2024, or until further order, whichever is
grateful, my lord.
Your lordship, in the morning I was trying to mention this matter. This is item number 11 appearing on your in your lordship's regular list. This is for extension for
Interim order already expired.
expired yesterday, your lordship.
Why you are not mentioned yesterday?
We hadn't served
They
notice
should have-
upon the other
They
other
should
side,
have
your lordship.
mentioned it yesterday at least.
Yes.
They should have mentioned it yesterday at
Down
least.
for vacating this interim. Status quo needs to be maintained.
Extension
This
after
is
expiry. What is being extended?
What is the injunction order?
Status quo on the property.
So what is the affidavits completed?
Yes, your lordship, it's ready for hearing.
GA4, my lord, because
Yes.
they have
No,
just
with regard to the interim order in which GA1?
1, 2, 3 affidavits are complete.
Interim order is regarding to GA1 only.
And what are the GA2 and 3?
2 is my application for passing an
Preliminary decree. 3 is
Their
my application.
asking order upon me to deposit 2 crores and odd, and 4 is their
Okay, I will pass an order to decree, and from the decree you have deposited 2 crore in their account.
It's a partition suit.
It's a partition.
So-and-so appearing for the plaintiff, so-and-so appearing for the defendant. The plaintiff has mentioned the matter for extension of the interim order granted earlier. Counsel for the defendant raised objection and submitted that after obtaining the interim order, time and again the interim order is extended and the application filed by the plaintiff is required to be heard expeditiously. In view of the submission is required to be heard expeditiously. In view of the submission made by the counsel for the respective parties, the interim order granted earlier is extended. Give the date and time.
Lord, may I just raise one small indulgence? Lord, GA4 is their application.
Whatever it is, I am fixing on what you complete all
Yes,
this.
Your Lordship, only one thing I will like to submit. Your Lordship will fix up a date and a time. GA3 is our application. Before taking up the application for passing preliminary decree, Your Lordship, preliminary decree is passed on the admitted stage.
All the applications, pleadings have been completed.
Yes, yes.
Yes.
GA3 is for the purpose that he has misappropriated my grandfather's property. So he has to deposit that
So
money.
I am fixing all the application on that day. Then I will see what is the application. Then
Correct.
serially it will
Yes.
be taken
Yes,
up.
Your Lordship.
Let the matter appear on 19th August at 3 p.m. All the interlocutory application we placed before this court on 19th August 2024. The interim order is extended till 19th August 2024 until further order, whichever is early.
My lord, maybe
Yes.
to mention, my lord, item 20, my lord, like to submit my unconditional apology, my lord.
Item 20.
Yes, my lord, directed this to go out of the list, my lord. I
Nobody's
just
appeared.
entered, my lord. My lord,
Nobody has
did not
appeared.
want to interrupt, my lord. Had called the next matter already, my lord. In that case, my lord.
So what do you want?
My lord, the only issue, my lord, this was kept for framing of issues, my lord. There is a chance of settlement, my lord. The defendants have already submitted a certain number of checks, my lord. They have been dated 30th of July, my lord. If my lord places this after
So
the
that's
30th
why
of
it is
July,
fixed. Let go out of the list. By 30th July, you will receive the amount, you come or you not
if my
receive.
lord fixes it any day after the 30th, my lord, in that case, my lord.
Item number 20. Item number 20. Plaintiff. Let the matter appear on 13th August.
Advocate on record.
13th.
Grateful, my lord.
Yes.
Item number 28.
28. Yes.
This was for basically it's for condonation of delay. One application is there before the appeal. I am not there on Monday. If it can be done on Tuesday.
28. Somebody mentioned, I will take that.
Your Lordship, on the last occasion, Mr. Bhattacharya had taken time on behalf of the department to file the affidavit in opposition. As usual, nothing has been filed.